Please note that this content is for adults only. Viewer discretion advised. If you haven't yet, hit the subscribe, like, and share. Hello everyone and welcome back to another live stream with me, J.O.A. This is Grizzly True Crime and we are here to watch day 6 of the Mario Fernandez Saldana trial. Day 5, I've recapped for you. We've done a YouTube short, we've got pinned comments, you know, with all the timestamps and everything. So I'm looking forward to see what day 6 brings. And actually, I'm most looking forward to when the state is going to bring in sorry, I'm just trying to get the chat going. The checks, because I think the strongest evidence that they have against Mario Fernandez would be the handwritten checks. If they didn't have that, that's difficult. You know, I was just thinking about it, because then you're like, okay, so ironically the truck was close to his house. Ironically and coincidentally, he knew Juan Biggerstaff, who lost a Glock. Okay, and coincidentally, there's a lot of coincidences, they all add up, but I think what ties it all together would be the checks. We need to see the checks. The only people who have shown us the checks so far in this trial is actually the defense. They brought it up in cross-examination, which was quite odd. All right, so please like and share so others know that we are live right now. If you're watching the replay, thank you for watching the replay. That always is a great way to support my work, whether you're watching live, whether you're watching the replay, just watching my videos is awesome. You can like, share, comment, subscribe, all those things, right? Okay, so let me bring up the feed. Did you or did you not? Did you or did you not watch the videos that I posted for you this weekend? One was Henry Tenon's the body cam, the arrest, and what we could hear from the police interview. Then I did a part 1, which was Kim Jensen's first interview with the police, and then a part 2, Kim Jensen's second interview with the police. Why I posted that this weekend is because on Friday they said that Kim Jensen would be proffered. We don't know if she would testify. If you've been sneaking, you know, watch a peek at the feed like me. I did sneak a peek. I admit it. But I don't want to share spoilers. But we just know she's going to be proffered, okay? Okay, I do have one spoiler. I do have one. We're going to see Juan Biggerstaff today. Okay, I was so naughty. Sorry about that. Please, let's not share spoilers. Why? Because we're watching live together on a delay on purpose so we can catch up after lunch, right? We just skip right over that lunch. Anyway, so if you watch them, you know what I mean? I don't know how that comes into Mario's trial, but I think it's going to be very interesting in Shanna's. I think so. Ooh, I can't wait for Shanna Gardner's trial, honestly. Wow, I think that's going to be quite something, and I hope she goes all the way down. You know what I mean? Like, she got to get L-whopped. Mario too, but they got to prove it. They got to prove it, you know? Okay, so let's put the sound on here. Hello, hello. There we go. Here's Mario sitting here. I'll show you now. If I could just see straight. Hello, where's the... There is Mario in his... I think my suit jacket looks too big like his did the other day. My jacket looks too big now, right? That's a good problem to have, right? Stop it, don't laugh at it. I'm looking like he did the other days. Got my big girl suit on. Okay, listen here. I'm ready to slay. How can he have a nicer chair, okay, and a nicer fitting suit than me? Freaking Mario. Okay, so they actually sat here for quite some time. So let's just see, because, you know, they enter the courtroom, wait for the judge, all of that. Let me see who's laughing at me here. Red Viking Princess, you know what I mean? You watched it, right? You know what I mean? That lady said, you know what I mean? So much. Oh, my word. Okay, nobody. There you are. There's Myron. He's laughing at me. How dare you? Okay, but the sound is on. So let's just hear where they actually start talking. My goodness. Are we there yet? Shh.
Where'd you?
Okay.
Morning.
Morning. They sound enthused, don't they? Wait, I want to show exactly when the judge... There you go.
Thank you. Good. Thank you. Good morning.
Morning.
I'm not even kidding. I think I have to put a different jacket on. This is ridiculous, which I'm so proud of myself for losing all that weight. You know what I mean? This is a great problem to have, but seriously, like, this is crazy now. I'm drowning in my own jacket, you guys. This is no court blazer to have on, so give me a moment. I'll play this, and I'm going to put a different one on, okay? Be right back.
Is there anything that we need to take up prior to starting the trial?
No, Your Honor. Correct.
Of Ms. Jensen?
Right, we have her here. She's present. We're ready to go.
Okay, let's bring her in, please.
She's here. Good morning, Your Honor. Ronald Manto on behalf of Kim Jensen.
Right, thank you. Good morning.
Good morning. I just wanted to put on the record.
Do you want to come forward?
Sure.
Okay, Kim Jensen's got an attorney. Disclaimer, I know it's not, no one really cares, right? Is it about what I look like? No. Are we watching a trial? Yes. Do I want to look professional? Absolutely. I want to be ready and dressed for court, you know what I mean? So I'm all sorted now. That other one's going to have to be recycled, and this just is what it is. Okay.
I was trying to pull up my transcript. Give me just a second, okay? I apologize. I didn't know that it was a proffer. I thought she was testifying, so I would have come out earlier.
No problem. And just for the record, Your Honor, my name is Jesse Dreiser. I represent Mr. Fernandez, who's present, Mr. Hill is present, Ms. Day is present, and Ms. Nepstead is present.
All right, Mr. Mizrahi, if you could put the state of Florida's appearances on the record.
Christina Stifler, Alan Mizrahi, and Steve Siegel on behalf of the state.
Okay.
Okay, Judge. Yes, just based on the statement of particulars that were filed by the state on July 24th, I believe that Ms. Nelson would be in a position to invoke, but she's been served to testify, and therefore I believe she's under the protection of Florida Statute 914.
Well, my understanding of the case law is that she cannot just blanket invoke. So it has to be question by question. What is she going to testify to and what she's not? And then the court has to make a finding about whether there is any type of meaningful ability for cross-examination in order to determine if she would testify. That's my understanding of the case law.
Yeah, I think we're in agreement that the state is, based on the subpoena that we've provided the witness, that we are providing her immunity for her testimony and cannot use it against her. And therefore, she's going to be willing to testify. I think Counselor just wanted that on the record, that what she says cannot be used against her. And that's
okay.
Okay, now if you guys were in the chat before the live even started, hours before, then Barbara and I were having a little conversation about Kim Jensen. Okay, so I'm not always there in the chat hours before, but here and there I check in. You see who's there, what's happening. And I was saying to Barbara, I don't think that Kim Jensen would need, I don't think she'd need immunity, because from what? Immunity for what? Oh, but she does have it. They're giving her immunity so that anything she says on the stand cannot be used against her. And actually, when I think about it, those text messages that we'd been over before between Shanna Gardner and Kim Jensen and another friend, that is interesting. I remember saying in the trial prep, like, are they going to arrest him at all or what? Right? So, interesting. Because it is about Shanna needs someone to, make someone disappear. There's statements like that. I think the text messages are quite something, and I cannot wait to see them in Shanna's trial. But she actually is getting immunity if she is going to testify. This is just a proffer, right? The jury's not present yet. You could see the banner up there. Sorry, Barbara, you were right.
For every question, we're in agreement that she's afforded the protections.
All right. So where is Ms. Jensen?
There's Barbara. Barbara Jean, BLC. I thought she did. That's why I asked you, well, Barbara, you had Ann Hunch and you were right. I was like, I don't think she'll need it. She's just the town gossip, you know what I mean? Why would she need immunity? Oh, because she's the town gossip. She's going to need that. Doesn't want to incriminate herself now while spilling all that scalding hot tea, you know what I mean?
She's right here, Your Honor.
Okay. Good morning, Ms. Jensen. Come forward, please. Raise your right hand to be sworn in.
Ma'am, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
All right, Ms. Jensen, before you take the witness stand, I'm going to have you kind of step back so that it doesn't, no. I mean, back outside when you're called as a witness, so it doesn't appear that there is something unusual going on. Most witnesses just come in from the doors. You understand? In just a minute. So I need to have a conversation with you, though. Give her a microphone, please.
Give her a microphone.
And Judge,
time to
maybe a
spill
little
some
bit
tape.
of background as to what we expect is going to happen. Mizrahi is going to enter proffered evidence, and then unless there's a major changing in the court's ruling, I do not believe Ms. Jensen called
Would not.
be.
Spilled all them papers. Spilling the tea. Today they're spilling the papers. You know what I mean? Okay. So I'm not snarking her. We don't snark at witnesses, right? We behave ourselves over here. Okay. You never know who's watching one. We want everybody to feel safe to chat here. All the witnesses, everybody. She's not accused of any crimes or anything like that. The only thing I was gonna say, just an observation, is she looks very innocent. She is innocent. I just mean in the dress she chose today, and her demeanor is like, what? I didn't know that's going to be such a popular public interview. Shame. Can you imagine? I mean, Mario and Shanna, they hadn't been arrested yet when she was interviewed twice. Once was in 2022 and once was in 2023. Holy crap. Imagine all that she told police. Just with all that confidence, everything she was saying so loosely, you know what I mean? Oh my word. So now it just seems like, like someone in tension. She's arrived. Like, hello, am I in trouble? Like, what happened? The whole internet saw that, unfortunately, ma'am. So what's the lesson in that? The police are not your buddies. Don't talk to them like they're your buddies. And don't share the town gossip with the police, because you just don't know how viral that case is going to be, and that all the YouTubers are going to get their hands on it. And all them YouTubers and the whole internet and all the peanut gallery will be watching and being like, you said what? And why? And what's the point of it? They just wanted to know some context, especially of the custody situation between Shanna and Jared Bridegan, right?
Okay. All right. So, Ms. Jensen, first, let me make sure that you understand. Do you understand what your attorney is explaining to the court?
I do.
Okay. Which is what?
That I have
You have a constitutional right.
to invoke.
Right. And so the state is giving you a subpoena. So that means that.
I was forced to come here, not, right? Compelled.
Right, but you're compelled to come here.
Right.
But on top of that, more important than that, is that if they gave you that subpoena, that means that your testimony, since they're compelling you to talk, to testify, then you would have immunity as to the answers.
Yes.
Okay. So that's important to understand, because otherwise, if you did not have that, then they could possibly use this as some sort of information or statements to use against you. You understand that?
I do.
All right. So the second part of this is that this is a proffer, meaning that they're going to call you to the witness stand. There won't be a jury here. So I'm going to determine whether these questions would be asked in front of the jury or not. So what's important is that, I try to explain this to witnesses, because proffer means an offer of proof. So he's going to ask you some questions that he would want to ask in front of the jury. So I like to explain it to witnesses, because you're like, why are they asking me the same thing again? It's because the jury's not here. The jury is the fact finder. Do you understand that?
I do.
And so I'm trying to make a legal ruling, all right?
Okay.
You've already been sworn in, so you can go ahead and take the witness stand. You can take the microphone away from her. There's one on the witness stand.
Thanks, Ron.
Do you want to take this?
Take my phone. It's got incriminating thing. What? What's on there, ma'am?
So there's
What's
a
on your
slight
phone?
incline here, okay?
I think we want her Instagram DMs the way they want Kirsten Bridegan. Do you know what I mean? You know what I mean? Huh? I think we want to see what she's, just out of interest sake, you know? The same way the defense is interested in what Kirsten Bridegan's been sharing, we are interested in what Kim Jensen has been sharing, especially since the arrest. And are there jail calls being made or what? Anyway.
But you wanted her to go out and come back in.
Did you want me to go back out in?
Which, if you guys didn't see my pinned comment or the update on the Kirsten Bridegan situation, there was a motion filed for a 3-day stay, and that was granted, so they bought themselves some time and did not yet have to hand over the phone.
Yes, you just have a seat. Right, Mr. Mizrahi.
Thank you. Please state your name for the record.
Stefan says, I might be a little judgy, and earlier Wogger1 said, I shall snark at this one if I so choose. Well, I was going to say, well, this is my community, and I set the rules over here, you know what I'm saying? So we're not going to snark at her appearance, okay? That gets really ugly and out of hand, and it's just plain bullying. What I want to snark at, though, is how much she victim blames and shames. Like, Jared was murdered, and the amount of shade that she throws at him was just unpleasant to hear. That I will always be upset with, because I'm here to protect victims and their families, you know what I mean? So, yes, I could snark at the strategy, what they say and testify to, things like that, right? But not appearance. I'm not snarking at people's appearance or mannerisms or how, you know, how they speak or whatever it is. But, ma'am, Jared was murdered, okay? Like, has it sunk in yet? It's really not the time to call him all sorts of things, I think, in my opinion, right?
Kim Jensen.
And how do you know Shanna Gardner?
I initially met her probably 11 years ago through church.
And would you consider yourself close friends with Shanna Gardner?
Yes.
Have you had the opportunity to review a series of text messages that have been labeled State's Exhibit 10F for identification?
I did.
And are these some of the text messages that you and Shanna Gardner exchanged and you and Susan Lee exchanged?
They are.
Your Honor, I would enter this as a court exhibit.
All right.
Exhibit 1.
I'm assuming no objection to that for the court exhibit.
As a court exhibit, no objection.
Okay, can I see it? Thank you. You can proceed.
Thank you.
I don't know if they're going to show us these text messages, so I'll quickly show you myself. Hold on. Where is it? Find the page. Find the page. There you go. Kim Jensen said, deep breath. It's going to be okay. I'll talk to you as soon as you get out. Just breathe. You'll work out all of this frustration at the gym later. He hates him. If not, I know Sue's husband knows people. And Shanna said, just when I think doing this whole 1 week off or on thing is a good idea, it gives me such great pleasure imagining slitting his throat. So that's Shanna's text there. I think there's more. Here we go. Kimmy said, Shanna needs a guy. And Susan Lee said, what kind of guy? And Kimmy said, the kind that performs permanent disappearing acts on certain people. Know any magician? And Susan Lee said, magician. No, that I do not. For stupid, because that was how they referred to Jared Bridegan. And Kimmy said, I was thinking Thomas lol. He isn't a magician, but I'll ask if he knows any. I'm sure her ex knows a few. Those are the text messages that they are talking about in this case. Okay.
So, Ms. Jensen, many of those text messages have to do with Shanna Gardner's ex-husband, Jared Bridegan. Is that true?
Correct.
Describe for the record how the divorce went and how the child custody went with regard to Shanna Gardner and Jared Bridegan.
From a legal standpoint, I guess the divorce went quickly, but it was not amicable at all. And the child custody was 50-50. And that was the ruling.
How did Ms. Gardner feel about Jared Bridegan as a father?
He frustrated her as a father.
And did Ms. Gardner share with you that she wanted to have more custody of her children?
Shanna wanted more communication more than anything.
Yeah. Does that include that she wanted more custody?
Prosecutor, no. More custody. That's what I'm asking. Ma'am, Shanna wanted more custody, right? That's why they wanted to get rid of Jared Ryan. No, she just wanted more communication. I don't think so.
No. Yes or no? Or I don't know.
I don't know.
I'm going to object to leading. She's free to answer the question on direct as she wishes.
I think giving 3 potential options of an answer.
I'll overrule it. Go ahead.
You would,
Sorry.
let me ask you this. In those text messages that have been entered as a court exhibit, did Shanna ask about a hitman?
Those were in the text message.
And based on that request, you texted another friend, Susan Lee, about finding somebody for Shanna. Is that fair?
That's not fair.
Okay. Well, what do the words say?
The words say that.
You've testified previously that you were joking about this. Is that fair?
Something that had nothing to do with Shanna, yes.
But you would agree.
Ma'am? Okay, one more time. Just so we're clear on this. You texted Susan Lee, Shanna needs a guy. I think that has something to do with Shanna. What kind of guy? The kind that performs permanent disappearing acts on certain people. Know any magician? Yeah, no. And then, magician, that I do not. For stupid, I was thinking Thomas, lol. He isn't a magician, but I'll ask if he knows any. I'm sure her ex knows a few. You can't say that that's got nothing to do with it, and that's not fair. You said that. You were trying to help. I don't know. Based on these texts, my interpretation of them, okay, is that she was reaching out to another friend to say, do you know someone who could, take care of Shanna's problem and make someone disappear? You were helping her look for a hitman? Okay.
That shortly after Shanna asked you for a hitman, that you then reached out to Susan Lee.
I'm going to object to leading again.
I'll overrule it for the purpose of the proffer, okay? So we can get through it.
Yes, ma'am.
I did reach out to Susan Lee.
And the words are what they are.
They are what they are.
Describe for the record how Shanna married Mario, what you knew about it, and then what your relationship was with Mario Fernandez.
How she married him?
Yeah, what did you know about it? Was it fast? Was it slow?
It was fast. She met him and then married him within just a few months. It was quick.
And what did you think about Mario Fernandez?
I thought she shouldn't marry someone so quickly because I didn't know Mario particularly, and I didn't think that she was ready to move on.
Ma'am, I'm just going to fill in the blanks here from what she said. You guys know what else she said, right, if you watch those interviews. She said that Shanna should have never married him because he's too short as well. She's like, oh, you never do that. You don't marry a man shorter than you. I'm like, ma'am, ma'am. It's a lot more than that, but okay. Say everything you said, ma'am. We heard the interviews. We heard them.
And do you see Mr. Fernandez here in court?
I do.
Can you say where he is so you can identify him for the record?
Right there in the blue suit.
Say that short little man over there. You know you want to. Come on, Kim Jensen, that little guy there.
To reflect the witnesses identified the defendant?
Yes.
So, did you have conversations in the presence of Shanna Gardner about Jared Bridegan with Mario Fernandez?
Maybe. Most of my conversations were strictly with Shanna.
In your meeting with Mario Fernandez, did you think that he was a boastful individual?
I did.
Did you think he would brag about being able to do things that you believed he could not do?
I did.
And was that, just describe that a little bit more for us.
Mario was always a big talker. I always believed that he wanted to be the biggest person in the room. His personality was such that he always had a story about everything. He always had, he always knew somebody. That was his personality. He had a very big personality.
And did that big personality sometimes relate to his Navy career?
I think it was Army, but yes.
You mean dynamite comes in small packages? Oh, I had huge stories for a little man. I'm not snarking at any short people. I'm not the tallest. I'm 5'5", I think. Anyway, I'm more just referring to her interview and the way she actually talked about Mario. Oh my, you gotta listen. So I'm just, I'm just saying what maybe we expected her to say, if she were to maintain the same demeanor and tone, you know.
So he would talk about doing big things in the Army.
Yes.
The did then Shanna Gardner ever share with you statements that Mario made about being able to fix things, take care of things?
And just
Yes.
for the record, I'm objecting as the same objections that I've made in my motion to limine, Your Honor, that you've ruled on.
So just so that I'm clear, this is the objectionable part that you're indicating. There's no objection to the previous testimony? Just so I know that what I'm ruling on.
Yes, well, it's very complicated. There's going to be two separate things that I don't think any of that other stuff get to if this statement doesn't come in and your ruling stands. And I think Mr. Mizrahi agrees to that. Those conversations that Ms. Jensen just testified to, Mr. Mizrahi specifically said that Mario was present for. So obviously there's no marital privilege to that.
Right, so y'all keep doing this. A proffer is get to the objectionable part. So like if there is no, Mr. Mizrahi, if there is no objection to that, I've heard Ms. Jensen testify before. And so if you could get to the part that you believe I need to make a ruling on, that's what I'd like to get to. If there's no objection to this and other stuff, there's no need for me to hear it.
The state of Florida has to lay some background. This is not a situation where the witness is testifying and we've let the jury out. I have to let some background.
I agree.
So I spent 5 minutes laying a background, and now I'm
Longer
getting
than
to the
that.
bushes.
Longer than that. Get to it, Mr. Mizrahi.
I am, Your Honor. I'm getting to the point now where that's why he objected. So,
I'm sorry, but just to be very clear, that court exhibit, Your Honor, would never come in, and we would object to that. But
Okay.
I got it. Move on. Mr. Mizrahi, go ahead.
yeah, just let me do it. So describe the things that Shanna Gardner shared with you about Mario being able to fix things.
That was his catchphrase. He would say that about all things, no matter what it was. If it had something to do with me, if it had something to do with the kids, that was just a common phrase that he would say.
And did Mario Fernandez share with Shanna Gardner that he could take care of, fix the issues Shanna Gardner was having with Jared Bridegan?
In a family law setting, he would say he believed that they could use the family law courts and fix the problems.
And so that's something that Shanna Gardner shared with you, that Mario says he can fix it, he can take care of it. In a family law setting is
Yes.
what your impression was.
Yes, that was my impression.
So did Shanna Gardner also share with you that he could take care of it because there was a motorcycle gang that was living in close proximity to Jared Bridegan?
When Shanna relayed that statement to me, it was I have eyes.
Okay, and that statement, I have eyes, has to do with Jared Bridegan.
I have eyes on the kids at all times, so yes, I guess.
Did Shanna Gardner share with you that Mario Fernandez shared that he was close on multiple occasions to Jared Bridegan?
I don't know that I remember that.
Did Shanna Gardner share with you that Mario Fernandez had eyes everywhere?
Yes.
Did Shanna Gardner say that Mario Fernandez said that there had been missed opportunities?
As
far as taking care of the situation with Jared Bridegan?
I'm not 100% sure if those were the words. Maybe.
Tell me what you remember.
You're asking me to go through years. I just need you to be more specific, please.
Oh, so for years did Shanna say that she wants, because we do think that the state actually thinks that, and therefore we think it, but that it dates all the way back to 2015, because some of those text messages, I think, are from 2015, but then they're also, what they're bringing into these trials is from 2021. Were there dates on those messages? I can't remember. Sorry, one more time. This one is from 2016, okay. And this? 2016, yeah. So they think it goes all the way back when Shanna was talking like this and Kimmy was talking like this. So it's like, but there's years. Yes, ma'am, just answer the question.
Okay. Well, have you previously testified that there were missed opportunities with regard to Jared Bridegan? Have you had the opportunity to review your grand jury testimony?
I did.
Would you refresh your memory to look at it again?
Please.
You have it.
If she has immunity, okay, which she does, that anything she says cannot be used against her, then come on, man. Why do you want to protect Shanna or Mario? Say all the things.
When I say grand jury testimony, I really meant your hearing testimony. So would that help?
If you show me.
Look at page 76 of the hearing testimony. You can go up there.
So what was your question again?
Did Shanna Gardner indicate to you that Mario Fernandez said that there were missed opportunities with regard to Jared Bridegan?
I don't see those words here. Oh, maybe down here, maybe. That was a question.
What was your answer?
I don't see an answer here. I said, my answer is, I heard the whole hearing, so I did hear the statements. I don't see where I answered that question.
Well, if you keep going, you do. 18, 19, page 77, lines 18 through 25.
Depending on the question, I guess it's possible, but I don't think so.
Okay. Now, turning to page 78, lines 5 through 7, do you recall the statement? We'll just do it like that, it's quicker.
Okay.
That there was a delay based on COVID?
This must feel quite
My answer-
intimidating. The two lawyers looming over you. Huh? I already hate it if someone's like just behind me. I don't know. So two of them like this. Ooh. It'd be like, can you stand over there, please? Thank you so much. Oh my goodness. It's making me nervous for her right now. Find it, ma'am. You're under pressure, so much pressure.
I never said anything about a delay in killing Jared because I never had any knowledge of Jared being killed or planned to kill him.
And then lines 13 through 16?
Not long after that, Mario had made a statement that he never goes anywhere. Neither did anyone else in COVID. Like it just didn't seem. You know what I mean?
You know what I mean? Shame she has to read her own words. You know what I mean?
A couple more statements and then we'll be done.
Oh boy. Yeah, Stefan said I would tell both
Do you
to
remember-
back the F off, right? Do you guys also not like that, hey? I'm sure no one likes that. If there's like people standing behind you just like looking at whatever you're looking at. I don't know. I just hate that. That was quite, yeah, and Mr. Defense Attorney, what you defending so hard, huh?
A statement
His client,
that was made
yes, but
shortly
still.
before Jared Bridegan's killing.
Can you be more specific?
Hawaii.
I remember talking to you about Hawaii.
tell, for the record, and tell the court what you remember Shanna Gardner telling you.
Shanna told me that they were getting divorced and how they were going to go about that as far as the kids were concerned. And at some point, Mario asked her if she wanted him to take care of anything, and she said, Jared, and he said, or she said, absolutely not. I don't want anything to happen.
So say that again, since you kind of.
Do you guys believe that? That Shanna was going to Hawaii. I don't know if it's Shanna and the kids or with who exactly. Okay, and then Mario's like, well, while you're gone, you want me to take care of anything for you? And she's like, what do you mean, Jared? Absolutely not. I don't want anything to I don't believe that. Not at all.
Mixed it up.
What did I mix up?
Take care of who?
He asked if there was anything Shanna wanted him to take care of, and she said Jared, and then she said absolutely not.
Okay, so who said Jared?
Shanna.
Okay, so I want to break down. Mario Fernandez says, is there anything you want me to do to take care of?
Correct.
And then she said Jared.
Yes.
And then Mario said, okay.
Mario didn't say anything. She said no.
And then she said no.
And she said absolutely not is what she said.
And this is what Shanna Gardner is relaying to you a week or so before the homicide.
I can't be sure. I told you originally that I wasn't 100% sure which trip that was, because every trip had something to do with divorce in the couple of years prior.
Right.
Okay, tell us everything about all of them then.
You know when the murder was.
I do.
And you were aware of this statement a couple of weeks before the murder.
If it was that trip, but I said I couldn't be sure because there were many trips.
Okay. All right, Your Honor, that's all the questions I have.
Just so that I'm clear, and y'all can ask whatever questions you need to after the fact. So the Hawaii trip, when you said they are getting a divorce, you mean Ms. Gardner and Mr. Fernandez?
Yes.
Okay.
The story makes no sense.
All right, Mr. Dreiser.
Ms. Jensen, good morning.
Good morning.
I only have a few questions for you. To be very clear, this is what Miss Gardner is telling you,
Yes.
a conversation that she had with her husband.
Yes.
You have no doubt in your mind that Mario Fernandez did not know that she was sharing these things with you, correct?
Correct.
And Mr. Fernandez you have never heard any of the words that you testified to regarding this last conversation, and most of your testimony, that Mr. Fernandez wasn't present for that. That's what Ms. Gardner was reporting to you that her husband told her, correct?
Yes.
And even that last statement, you don't know what Hawaii trip it happened on, do you?
I don't.
And there were many Hawaii trips, correct?
There were.
And divorce was something that was talked about from time to time with you and Ms. Gardner, correct?
Yes.
Regardless of how quickly they got married, Mr. Fernandez loved those children, right? That's what you believed?
I believe that.
He was an active and engaged stepfather?
He was.
And Mr. Mizrahi didn't ask you in those statements the questions in between all the different questions, but you would agree you kept telling Mr. Mizrahi that Mr. Fernandez just wanted to keep Ms. Gardner safe. That's what he was referring to in all those questions, right?
Yes.
I don't think I need anything else, Your Honor.
I just want to make sure. So the questions by the defense, those are specifically related to Hawaii? The Hawaii statement?
And all the other statements that Ms. Jensen said that Mr. Fernandez was not present for. That's what was
That's the problem. So I don't know that the defense needs to do it, but that is the purpose of the ruling. It's not necessarily all these statements. It's the circumstances surrounding the statements that.
I totally agree. That's why
I don't know anything about that to make a ruling. It's the circumstances for which the statements occur.
Circumstances under which the statement occurred, there's a state theory, two-pronged way why this comes in.
I understand the state's second theory, that it's about child custody. However, I want to be clear.
Why can't they clear up the mess that it just was about the statements about Hawaii? Because what Kim Jensen said made no sense. That, like, Shanna said, Mario said, do you want me to take care of anything? And Shanna said, Jared. And then she said, absolutely not. No, that doesn't make any sense. It's probably Mario saying, hey, so while you're away, do you want me to take care of anything? Shanna might say, like, what? And he says, Jared. And she says, absolutely not. I don't want anything to happen. I don't agree with that. I think that doesn't sound right. I don't know if Shanna would have said that. She'd probably be like, yeah, do that. But maybe Shanna thought that'll look too weird. If I'm out of town, if I'm in Hawaii having the time of my life, and you're out here taking Jared out, no, that mustn't happen while I'm away. It's got to look totally chilled, which makes me think, yeah, Shanna is the mastermind behind it all, don't you think? Yeah, I think so. She just used, in my opinion, Mario, and Mario used Henry Tenon. And here they all are, but I cannot wait for Shanna Gardner's trial, which starts with opening statements on September 8th, by the way.
I think about 45% of her testimony could be admissible. I find probably 3 statements that she couldn't make. I don't think that this is admissible. There are no circumstances for the court to make a ruling. However, the facts and the circumstances related to the Hawaii trip, I don't know, were they just made via witness to Ms. Gardner or vice versa on a telephone call? Was he sitting on the couch? That's what I mean, the circumstances.
It was a call between Shanna and I. I believe so.
Judge, there's no dispute. Mr. Mizrahi will agree with me. Mr. Fernandez was not present, and he did not know that she was ever going to share those communications. So there's nothing in your ruling that you heard today that's different.
Well, I want to be very clear. I did not say that she couldn't testify. Like I said, I think probably about 45%, but for these private text messages back and forth between, I don't know who some of these numbers are.
They're not.
But anyway.
Joyce Brown said, Miss G, thanks for posting our interviews. Makes such a big difference now watching this. I know, right? We needed that context first. We needed to see her in her natural state. Kim Jensen, before she gets on the stand for this proffer, and before she's probably going to get on the stand in Shanna Gardner's trial. Can't wait.
You're not. Okay, so I'm not making a ruling on that. You just want it admitted for what purpose?
Sir, can you get closer to a microphone? Turn yours on.
So as it relates, hold on, let me pause you. As it relates to the co-conspirator statements that pass prior to her marriage of Mr. Fernandez, I'm not excluding that. Okay, so, but you're not admitting this? Okay.
He has a microphone clipped on right here. Is it not on? Hello? We can't hear you, sir.
Okay. All right. So the state is, all right, so you're putting in a court exhibit that you do not intend to actually introduce as evidence. However, the statements, I only really see 3 potential problems with the admission of some of these statements. The Hawaii statement, a private conversation between this witness and
The Hawaii statement was the main purpose on doing all of this. That is why we on the proper on Friday, that's why we put it on the proper. We believe there's
all right. Thank you, Ms. Jensen. Do you have anything further for Ms. Jensen?
No, can I have 1 minute with counsel?
Okay.
Trying to remember if Kim Jensen talked about her father being a district attorney in part 1 or 2. Do you guys remember? It's like those two are all blended together, the part 1 and 2, the interviews, even though they happened one on May 6th of 2022 and one on February 3rd of 2023. But she did say that her father is a district attorney, and she mentioned this while explaining that she was familiar with how the legal system works and had spent a lot of time in courtrooms growing up. Okay. I'll find it for you now. Hold on.
Remember her, she may have been like.
That was just me opening up that interview. Hold on.
The state and I haven't, I think we understand, it wasn't as clear, but I agree with the court. Anything that she heard Mr. Fernandez say, it would be admissible if the state so chooses to call her. I did not object every single time this morning because I was trying to get through it.
Okay, let's just pause this because it's a whole argument. It was in part 1. It was May 2022's interview, and it's mentioned a timestamp 1 hour, 1 minute, and 54 seconds. That's where it is. So in case you guys want to hear that, although I could play it for you here. Hold on 1 second. I'm not going to put it on the screen. I'm just going to play it for you. Here we go. Wait, let's put it like this.
My dad was a DA. I get it. Yeah. I spent many a time in the courtroom. I know how this works, and you know, you could just see the writing on the wall if you've got any kind of familiarity with, you know, how these kind of cases go. Yeah. You know, I mean, I think she deserves answers.
There you go. That's what she said in part 1 that I uploaded for you, right? Okay.
Most of what she testified to was just what Ms. Gardner told her, and the state agrees with me. They're not calling her to put any of that in. So just so the court's aware, I would have objected to every single question where she was reporting what Ms. Gardner told her Mr. Fernandez said. With that being said, I think the witness can be excused.
All right. Just temporarily so that I can make a ruling. Okay.
Okay.
Thank you.
Okay, now this I'm going to put at 1.1 speed as they make the ruling after arguments back and forth. Just to save you some time. 1.1 speed, okay? Are we there yet? Okay.
So I wrote.
We got the first coffees of the day. Thank you so much, Jacqueline, for spoiling me with 6 Mama Bear coffees. Thank you so much.
In the court's order, the state's secondary theory related to Ms. Jensen. I've rejected that line of thought. I saw no support in the law nor the rule that would allow the state to submit that statement and pierce the marital privilege, I left open the potential that if there were circumstances surrounding the actual statement that would basically, the privacy would fall away, the circumstances for which it was made. But generally speaking, I believe that the exceptions to the marital privilege outside of the privacy area are well defined. It is a crime against either one of their children. AB and LB are Miss Gardner's child. But none of what I saw, and I'll hear you out, changes the court's analysis. So I'll hear you if you want.
Yeah, just very briefly, thank
Okay.
you. The AB and LB are victims of an intentional act that reasonably could lead to their physical or mental injury. Because this is not a murder that is done for a gang reason or for money reasons, and tangentially, those children are injured. The goal and purpose of this homicide was to take away Jared Bridegan's parental rights to eliminate their father intentionally. This was the intentional act done that could lead to their physical or mental injury. LB and AB are children of Shanna Gardner. Therefore, she has the ability, her statement pierces the marital privilege because it's a statement about the homicide involving her two children. That's the theory. The reason why we put on Mr. Ponder yesterday is it was direct evidence from the defendant's mouth to Mr. Ponder's ears that the purpose of this homicide, the purpose he hired someone to do this, was for child custody issues. So this isn't the act itself was an intentional act to inflict physical or mental injury upon these children, in addition to, obviously, Mr. Bridegan. But that was the goal of it. In order to prove a child abuse, the act has to be intentional. So the court's concerned that it was just some random act of violence. That would not be intentionally to the children. The court.
That's not my concern.
Okay.
What criminal case has ever...
Why did you say yesterday? Mr. Ponder was the inmate that we saw doing a proffer on Friday. That was very entertaining if you didn't see that, right? Mr. Ponder, full name is Javel Ponder. The jail inmate was called as a potential witness, day 5 of the Mario Fernandez Saldana trial. He shared a jail, I'm just recapping, right? He shared a jail dorm with Fernandez in 2024, and outside of the presence of the jury in this proffer, he claimed Fernandez made several statements about the case, including that Shanna Gardner had wanted to stage a fake RAPE charge against Jared Bridegan, but then Mario said that wouldn't work because it would only be temporary. That Henry Tenon, he says that Mario said Henry Tenon was too old and wasn't supposed to be the one who carried out the shooting. It was supposed to be Tenon's nephew, but then Henry Tenon effed it all up because he did it himself. And also there were comments made suggesting that Gardner was okay with the risk of being killed herself, but didn't want the kids caught in the crossfire. So most of that was about, okay, if whatever Mario was planning, if there were any kids in the car, as long as it wasn't going to be her kids, she was fine with it, which is really like, oh man, that's what I say. Just, can you imagine the snark we all have for Shanna Gardner? It's not like we don't have it for Mario, but Shanna, she's the worst. You know, it's like, to think of killing your ex-husband, wow. And then to quickly marry this guy, and then after the hit is actually done, immediately you're like packing up and leaving and living in Washington with the kids, ditching Mario just like that suddenly. It's just, wow, okay.
Centered on child abuse, where the children are physically safe in their house, and let's say the other spouse gets beat up, or let's say it's that, beat up by the other spouse, and then somehow that pierces some sort of marital privilege. AB and LB, I believe we all could agree, were safe, at home, dropped off, physically safe. So the mental argument by the state is that, I guess, do you know a case where that's been the child abuse theory?
There are cases where the child abuse theory has been premised on mental injury, 100%. There is not a case that deals with child abuse that mental injury is the reason to pierce marital privilege.
No. Have you seen a child abuse case where one parent is trying to get custody over another parent and therefore the state of Florida intervened with criminal sanctions saying that, no, that's child abuse?
No. There is not a child abuse that I'm aware of, at least an appellate case, an opinion case, where the murdering or injuring of another parent for child custody.
I'm not talking about, let's say not murder. Let's say just a third-degree child abuse where the state of Florida goes and arrests another parent because they want more custody than another parent.
Well, that would never be a child abuse.
Okay, but that would be mental injury on the child potentially, right?
No.
Okay.
Talk about murdering their father.
All right. What about breaking their legs?
Well,
breaking their legs or doing something horrible to the other parent?
That doesn't interfere with their custody. They still have custody of their child if they're beaten up, if their legs are broken, if they go to the courts. That's all legal methods. You're talking about the only true way that they could eliminate custody, the only way they could take this father away from his children was to murder him. There is no other way. That's our theory, is that was done intentionally, and that reasonably could lead to the children's injury. It's a very unique set of circumstances. Certainly we don't have any third-degree child abuses under that premise because it wouldn't exist. We do have third-degree child abuses with an act that could intentionally lead to mental injury to a child. Those exist.
Quote me a case.
I don't have a case right off the top of my head. It's the statute. And there are certainly premises under the statute, under 82703, it says an act that reasonably could lead to the physical or mental injury of the child, and we have to be able to prove those elements. There's not I could probably find one. I don't have it at the top of my mind. You could.
Okay, so I don't know. Can you guys explain to me, anybody, like why did they go from that part I missed of just going from, is Kim Jensen going to testify in front of the jury or not? Are those text messages coming in or not? Now we're going to child abuse. Okay. I'm a little confused myself of like, are we going to see it? All we really want to know is she going to testify or the text messages coming in? I mean, it's also extra confusing that this is the angle they're going with this right now. Why? Because they dropped all the child abuse charges for Mario, Shanna, and Henry when it relates to Bexley, who was in the vehicle and absolutely was in danger and could have been shot. There were shell casings found in the car. You know what I mean? Like, that's child abuse. I'm not saying that the kids of Shanna were not indirectly, of course, abused, psychologically abused by Shanna wanting to kill their father. You know what I mean? Allegedly. And Mario and Henry Tenon. But what? What is happening? You know? Yeah, Diane said, why are they not taking Bexley into consideration? Shame. And she was in the car and remembered a lot about it. You know, she told the police she heard loud booms, that she saw someone dressed like a Halloween outfit, basically, maybe all in black, I don't know. Also, I wonder, somebody was asking up there earlier in this chat, if Mario had said that Henry Tenon was too old and had effed it all up, in what way did he F it all up? Because if Mario was driving the truck, allegedly, we don't have concrete proof of that. It's just what makes sense, especially going close to his house. But okay, if Mario was driving the truck after dropping Henry Tenon off, for example, with the tire, how did he F it all up? Did he not wear gloves? Is that how the DNA got on the tire? What did he F up? Because clearly they knew he's going to be walking back to the truck and being seen on every camera everywhere. Not just the one by the police station, but all the cameras where they saw Henry Tenon on surveillance, walking back towards Pablo Hamlet, right there by Mario's house, right? Yeah, so I'm just seeing what you guys are saying about this now. State, be clear what you want to do, and please be clear as to why Kim Jensen needs to take the stand, because that's what we want to know. Okay, and then put her on the stand.
There's not one, I concur with the court, there's not going to be a case that says that pierces marital privilege. There are, and I submitted in our argument, cases where the reckless driving pierced marital privilege.
Right, but that was one parent that was driving and then injured the child. in my mind, so factually distinct from this scenario.
I don't think the child was injured at all, Your Honor. If you read the case, the child was subject.
I've read a lot of cases very recently, so I apologize for getting it. But I believe that it related to the child. I'll pull it back up.
The child was in the car and the person was driving recklessly, and that could lead, that was considered a child neglect. It wasn't an abuse, it was neglect. For failure to provide the care necessary for the child's well-being by driving recklessly while the child was in the car. I agree that that was, the child was in the car when the recklessness occurred. But it doesn't change the state's argument that the intentional act was to eliminate the parental rights and take away these children's father.
That case also went to the premise of the psychopatient privilege. That's what the court was ruling on, not the marital privilege. They punted, they didn't need to go to the marital privilege because they relied on the psychopatient privilege, which does not have the same elements as the marital privilege.
Loba Volcana, thanks for spoiling the mods with 3 Big Bear coffees today.
I'll just wait.
Defense attorney shaking his head. Whatever. Okay. Mr. Dryce is getting his steps in today, pacing around that courtroom. Mario's probably also thinking, what does this have to do with me? Okay, Mario, but can we see her in Shanna's trial? Thank you so much. Bring in the text. And how about you get on the stand and brag about how you can take care of things? I wish we could see Mr. Ponder again. In front of the jury. They'd be like, what? Okay, let's read what Zenjin answered. Judge saying, doesn't fall under marital privilege, exception of harm to children because they aren't Mario's children. Privilege is to protect marriage. It is indeed complicated privilege at times. Okay. My word, what a long wait.
Southern UFRESNE v. State. It's a Florida Supreme Court case 826 Southern 2nd 272 that goes through. I guess there was a challenge to the phrase mental injury, where there was a constitutional challenge for vagueness, and it goes through the history where it falls. The Florida Supreme Court, it says that we note the definition of mental injury now found in 39, that's when they redid the statute, this is a 2002 case, is a limiting definition as opposed to a broad definition, which benefits the defendant. Thus, mental injury, as defined, will present only in limited circumstances, thereby discouraging arbitrary and discriminatory enforcement. Accordingly, pursuant to this analytical framework, which sets forth in Fuchs, we conclude that the district court properly held that the challenge statute is not unconstitutionally vague. Mental injury is adequately defined, is what it says, and I'll go back up to what they are affirming is not vague, which in 39, I know the state is focusing on the intentional part because your theory is that the murder is the intentional act that would somehow produce this, which is mental injury means an injury to the intellectual or psychological capacity of a child as evidenced by a discernible and substantial impairment in the ability to function within the normal range of performance and behavior. So you're saying that LB and AB, that is the fact. So I would need more facts there.
I understand the court's, I understand that law. I'm very well of the mental injury law and what is required. I would point, Your Honor, to Hill v. State, which I argued at our last hearing at 846 Southern 2nd, 1208 of 2003.
Repeat the last numbers.
I'm sorry. 846.
What is he shaking his head at? You know about that case, Mario? He's like, okay, you say something. You go testify.
Southern 2nd, 1208.
Do you think he'll testify? Do you think he'll take the stand?
And under Head Note 5, 6, and 7. Your Honor, we don't have to prove beyond it to the exclusion of a reasonable doubt that a child abuse occurred. In fact, the court quotes, and I'll read it for Your Honor, although we have found no case in which the defendant has been convicted of this crime of child neglect based on reckless driving of a vehicle, if the defendant's reckless driving is shown to be sufficiently gross, there is no reason why the charge could not be proven. Because of the clear statutory language in both Section 39, which is what we're going on, we agree with the trial court that the psychotherapist-patient privilege does not exist in this case as to any communications relevant to the child neglect felony count. So the law doesn't require you to prove.
I'm not putting that burden on the state.
I'm sorry, what?
I'm not putting that burden on the state. I don't want you to even argue that. I'm not putting that on there. However, I do have to find that would be potentially a child abuse, correct? In some form. I'm not saying that you have to prove beyond a reasonable doubt each and every element, and I don't want you to think that I'm doing that. Okay. And as well as I don't want you to put on an entire proffer of things that I probably about 80% I would allow. I'm not putting the state in a box like that. Instead, I don't know, just like the state is being cautious, saying that we don't want to put in evidence that there was a pre-existing conspiracy for confrontation. That's your choice. That's your strategic choice. However, I need a legal path to admissibility. Admissibility isn't beyond a reasonable doubt. So I want that to be very clear. I'm not putting that burden on the state. Okay. But I do, you would agree, Mr. Mizrahi, that this is unorthodox.
I wouldn't call it unorthodox. I would call it using the law to get in pieces of evidence. That's what I would call it. I wouldn't call it unorthodox.
All right. So Earhart is like my favorite book.
I love it too.
Okay.
I've seen him lecture many times.
Me too. All right.
You have.
Total fan club. However.
Okay, so now we know what their favorite books are. And is Kim going to testify? Too snarky? Sorry. Can we get Kim back on the stand, please? And if it was never going to happen that the state could get Kim on the stand for this trial, then save it for the next one. That's happening just in a few weeks. Can't wait. I think she definitely has to get on the stand for that one, right? Yeah.
However, I don't see that Earhart has anything. He is a guru on evidence that would even suggest a path like this.
My argument to the court's last inquiry about whether or not it is inconceivable that a 9-year-old child whose father has been murdered would not have some discernible psychological issues as a result of the elimination of that parent. This is not unorthodox or way out there. It is incredibly logical that if a child loses a parent, that they will be subject to some type of psychological damage as a result of it. Discernible.
And help us understand what that's got to do with Kim. Us in the peanut gallery, excuse me. How does that relate to Kim's proffer? Or are we on a different topic entirely? At this point, the prosecutor almost sounds like the defense. Are you reaching, sir? Are you the prosecutor or defense? I don't know. He's the prosecutor. As required by Dufresne.
So I think the court's analysis ends there. Is that reasonable? Yes, I think that's reasonable. Therefore, it pierces husband-wife privilege, and it is admissible. That is the state's argument. And if the court, I agree with the court that there is not a case on point, on all fours, that deals with this issue. I agree with that. I agree that with the reckless driving, the child is in the car. This is a mental injury situation as opposed to a reckless driving situation when the child is in the car. Those are two different scenarios.
Well, let me ask you this.
Can I?
I'm still messing. I've got to figure out what Mr. Mizrahi is, what his path to admissibility, and he keeps saying all these much higher hurdles that I'm not putting on the state.
Okay.
And so let me go ahead. What's your objection?
My objection is, and I've been quiet and letting the court and Mr. Mizrahi go, is that you made a ruling and you gave a pathway to the state to see if they could breach the marital privilege. And they put on their proffer. There was no breach of the marital privilege. And now Mr. Mizrahi is getting essentially now what's been 30 minutes of an opportunity to re-argue and start citing case law of cases you've already ruled on, you've already read, that is not what today's hearing was for. Your ruling was very clear. If they can breach the privacy, then you made the ruling. You've read Hill. You've read all these cases. So I'm just sitting here letting him get a second bite at the apple in the middle of the trial, and I think that's unorthodox. I think your ruling,
The audacity.
which was written, well thought, well written, and took time and days before we got a decision, is now just being relitigated on the very premise of not what you said they could do, which is break the marital privilege. And that is frustrating as I sit here and allow this to go on, but it's as you see fit, Your Honor.
Allow this to go on. Oh, sorry. My, have they offended you? I love the tension between these two, between this prosecutor and that defense attorney. Oh my, Mr. Mizrahi and Mr. Dreiser. Love that tension. Because now let's see what the prosecutor says.
So this is where I'm at. In that hearing,
I'm gonna say it.
there was the opportunity to call these witnesses. It didn't happen. The state is able to make a record, which they're allowed to do, which is a proffer. And while I don't necessarily, generally speaking, proffers are the objectionable evidence, and their record needs to be clear, Mr. Dreiser, that generally speaking, the proffer only includes what is being objected to. Like I said, I don't want the appellate court to be under the impression that I ruled all of that inadmissible, which I did not. I don't want the state to make a record saying that I'm saying that it's not admissible because they have to prove something beyond a reasonable doubt. It is not. I know the rules of evidence. So I don't want, that is what I'm doing, okay? So as far as that is concerned, I have heard part of this. I haven't seen it in real life. I did not know what the purpose of Mr. Ponder was or what he was saying, I guess, at the very end. And then I want to make sure that the record, what you're objecting to is the Hawaii statement, and then some other statement that was made on the phone. But there were statements put in that apparently Mr. Fernandez was here for. And so that would not be marital privilege. That is not inadmissible.
I agree.
And so my last question for Mr. Mizrahi is that the statements that you were seeking to admit where you're saying it was related to child custody, you're depending on Mr. Ponder, not from Ms. Jensen, because she said that Mr. Fernandez said he was going to fix things through the family law system.
Well, it's both.
It's both. Okay.
It's both. Ms. Jensen doesn't say that Mr. Fernandez said he was going to kill Jared Bridegan for child custody. That's why we put the Ponder on that.
Okay.
The Ponder statement is the direct evidence that the murder was done with the intent to commit.
Put Mr. Ponder back on the stand.
All right, Mr. Ponder did not need to be proffered. I agree. You weren't making a decision as to whether what he could say comes into evidence. You were very clear about that, and I agree with the court. They just chose not to call Mr. Ponder for strategic reasons. They had no, Mr. Ponder.
They have?
Yes, they have chosen not to call him,
Okay.
and they brought him in to tell you.
Why? We only just found that out now. through the defense. The state has chosen not to call Mr. Ponder. Come on, man. Give him a shot. We saw him on Friday. If you missed it, it's timestamp for you, right? It was interesting. Just to hear what he said. It's up to the jury if they believe him or not. But I do like it if he also was able to testify as to what he heard Mario say, and that he thinks that Henry Tenon effed up, and that if he had known people on the streets who could kill for him, he thinks they would have gotten away with it. So put Mr. Ponder on the stand. Come on, the state's not gonna. Well, that's disappointing. Now it's been an hour 15 since I started live. I'm going to take a quick stretch break before this, before the court actually starts in front of the jury. They've got a few more minutes of these arguments. Okay, be right back.
Evidence that the jury has not heard that could come in. He can say what Mr. Fernandez told him, and then I'll cross-examine him, and the jury will decide what they're going to do with Mr. Ponder. But now they're trying to get in what Mr. Ponder said to influence your ruling. When I don't know why they proffered it, quite frankly, I guess to stack inferences. But Mr. Ponder could have testified in front of the jury. He wasn't saying anything, as you said. You don't make determinations on believability. You make legal decisions. There was no legal objection that I know of that I could prevent Mr. Ponder from testifying. So let's be very clear about that.
Okay, well, I didn't know the state wasn't calling him, so. All right. Mr. Mizrahi, I stopped you because I thought he was going to testify and they'd hear all of that stuff. I needed to make a legal ruling. But if you wanted to put him on again to, I guess, or put his deposition in, I don't know. But I stopped you because I thought he was going to testify.
The state does not need to recall Mr. Ponder for any purpose of the proffer.
All right, so.
We have put on the evidence that we think the court can make this decision, and we understand the court's previous ruling, and I've made my argument, so we're good.
All right, I'll maintain the ruling. Are y'all ready to get started?
Yes, Your Honor.
Ms. Jensen, you don't want her anymore?
Jensen is excused and needs to appear. And needs to be appear for the Gardner case. And she's under subpoena.
Okay, thank you. Nice meeting you. Ready?
We'll see.
Mr. Hathaway, will you get that exhibit? Who's the state calling?
Fred Barton, Your Honor.
Thank you. Waiting for them to be ready.
That Mr. Conversation.
Okay, so we're ready to get started with the jury now. The judge said she'll maintain her ruling, so whatever that means. So I don't think they're going to, Eve behind Zap said, I don't think they're going to use Kim for Mario's trial. That's a bummer. That's such a bummer. I was really hoping they would. Also, somebody said, wait. I can't see it. Wait. Book Mama said they are married only because of these trials. They haven't lived in the same state in forever. What marriage? It's just premeditated. See it, right? And somebody just said about Mr. Pardon that maybe they were talking about they're not going to call him to testify, but he already had his proffer. However that was phrased, he already had his proffer, right? Let me just see if I can find it. Can't find it in this chat now. I just saw a comment fly by there. Anyway, Mr. Ponder has already had his proffer, and now the state has apparently decided, that's what we learned from the defense, he won't be testifying either. So we're not going to see Mr. Ponder again, nor are we going to see Kim again in this trial. we won't see Mr. Ponder again at all, I suppose. But will we see Kim Jensen in Shanna Gardner's trial? I think so. Bring the jury. Private defense attorneys, you know? They're working hard out here. I don't know who is paying. Is it Shanna's parents? I don't know. Here, here. Everybody stand, please. Jury's in the courtroom. Yes, Mario's in jail with no bond. So is Shanna Gardner. And Henry Tenon.
Welcome in, members of the jury. Everyone may be seated. Welcome back, members of the jury. I hope that you all enjoyed your weekend. We are in the 6th day of trial. I want to, before we begin the proceedings today, just confirm that you all followed the communication rule over the weekend's recess. If you could all answer out loud. Yes. Okay, great.
So they didn't watch any of my videos? Okay, good. Will they watch it after will they see Kim Jensen's interviews? Huh? Henry Tenon's? From what we could hear, at least.
Now, to remind you where we are procedurally, the state of Florida is presenting their case. They're going to call their next witness. Ms. Stifler?
Your Honor, the state calls Fred Barton.
Fred Barton, please. Good morning, Mr. Barton. Come all the way forward, please.
Well, hello, sir. Mr. Fred Barton. We'll see how I spell it now, but that's what I guess.
All right, raise your right hand to be sworn in.
Sir, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Okay, sir, go right to your left and then be seated in the chair. Pull yourself all the way up so that you're speaking into the microphone, okay? You may proceed.
Thank you, Your Honor. Good morning, sir.
Good morning.
Can you hear me okay?
Very well.
Thank you. Could you please state your name for the record, introduce yourself to our jurors, please?
My name is Fred Barton.
And Mr. Barton, do you live here in Duval County, Florida?
Yes, ma'am.
How long have you lived here in Jacksonville?
Since I retired from the Navy, 2002.
And what do you do for a living, sir?
I'm a manager for Allied Security Company.
I'm going to keep this brief because I know you got to get back to work. I want to ask you about an incident that occurred several years ago with a man named Juan Biggerstaff. Mm-hmm. Do you know Juan Biggerstaff?
I do.
Can you tell the jury when you met Mr. Biggerstaff originally?
I can't remember exactly, but I met him years ago through his wife, who I met on a dating app.
Okay, and you had some kind of dating relationship with his wife?
Yeah, no, I was going to joke about that. He actually said it. I'm like, ooh, he knows Mr. Biggerstaff, but in what way? In like the swinger kind of way? Or like, oh, just knows him, I don't know, in some professional manner? No. He met Mr. Biggerstaff through his wife, Mrs. Biggerstaff, who he connected with on a dating app. Oh my, everybody buckle up.
That's correct.
She was married to Mr. Biggerstaff at the time.
That's correct.
And did you and Mr. Biggerstaff have any type of interaction yourselves?
No, just when I went around their house, he was there, or he would bring her to my house. She would stay with me on the weekends.
No problems with him. This was a consensual, everyone's copacetic type of relationship.
Okay.
If you can say yes or no, please.
Thank you, sir.
I didn't expect this testimony to go there. Maybe I should have, but okay, wait, what? All right, Mr. Biggerstaff would drop his wife off at this guy's house? Oh my, okay.
At some point, did you become aware that Mr. Biggerstaff was being federally prosecuted?
I did.
And during that time, did you know that he was going back and forth to federal court during his case?
I did.
And I want to ask you about, while he was litigating his case, did he ask you to hold an item for him?
He did.
And did he bring that item to your home?
He did.
Can you tell the jury what that item was?
It was a metal cabinet. He called it a gun cabinet, but I don't call it a gun cabinet, but it was a metal cabinet. And he brought it to my house, asked for me to hold it until his son would pick it up the following week on Friday.
And I know you can't remember the exact year, but in the timeline of his case, when did he bring this gun cabinet to your house?
The last conversation I remember having him with him was based on his attorney advised him that he needed to get rid of those guns or any firearms in which he had possession of, because if he was convicted, he wouldn't be able to touch them, do anything with them, so he was giving them to his son.
Okay, so this was prior to his sentencing, but after he was originally arrested and litigating his case.
That is correct.
When he brought the locker over, where did you store it at your home?
In my closet, in my bedroom.
How did he bring it over?
He came over and I put it on a hand truck, and he brought it to my room. I put it in my room and locked my room, because I locked my room on the outside because my kids used to break in my room. So I locked my bedroom also to keep them from breaking in my bedroom.
Okay, and so he...
Why? What else did you have in the closet? And if you don't call that a gun cabinet, what kind of cabinet do you call it? What kind of things would he normally put in there? Sir, what did you put in there when Mrs. Biggerstaff came over? What you had in there that you didn't want your kids to see, huh?
Brought it on, you said a hand truck. Mm-hmm. What is that? Like a dolly?
Well, it's a hand truck. You just pull it back and you roll it however you got to.
Did you ever look inside the gun cabinet?
Never had access to it. Told him I didn't want access to it. I don't want to have any responsibility if anything's missing, damaged when he picked it up. So I couldn't tell you what was in it.
You couldn't tell what type of firearms were in there?
I wouldn't even know if there's firearms in it because we never opened it prior to him leaving it. We didn't open it when he came to pick it up.
Right. So you never looked inside.
Mm-mm.
You wouldn't know what's inside other than his statements to you that it was
Correct.
a gun cabinet and his lawyer told you to take it with his
That
notes.
is correct.
Who came in?
Why would you do that, sir? And also like, oh, hell no, I was not going to be touching that just in case he's what? Going to accuse you of something being missing, broken, whatever, but you just won't be all up touching his wife. Okay.
Picked it up.
Him and his son.
And what's his son's name?
Juan.
How long after Mr. Biggerstaff dropped off the gun cabinet did they come pick it up?
It's about a week, the following Friday.
Did you keep any firearms or ammunition that Mr. Biggerstaff brought to your home?
No.
Would any of his firearms or ammunition, if they were in that gun cabinet, have been left at your home?
No.
Do you have any of Mr. Biggerstaff's firearms or ammunition to this day?
No.
And you're, obviously, in your job at Allied Security, you're lawfully allowed to possess and own firearms.
Yes, I have a gun from them.
Do you know the defendant in this case, Mario Fernandez?
Never heard of him.
Do you know a woman named Shanna Gardner?
Never heard of him.
Do you know a man named Henry Tenon?
Never heard of him.
Do you know a man named...
You mean Mrs. Biggerstaff didn't tell you that she is also banging Mario Fernandez? You never heard of Mario at all? Even though you were with Mrs. Biggerstaff, Mario was with Mrs. Biggerstaff. Were you on any other videos, sir? You never met him? Oh, okay.
Jared Bridegan.
Never heard of him.
May I have a moment of counsel, Your Honor?
Yes.
No further questions. Thank you, Mr. Barton.
Thank you. Cross?
Yes, Your Honor. Good morning, Mr. Martin.
Good morning.
Nice to meet you. My name's James, so I represent Mario Fernandez.
Mm-hmm.
If I understood correctly from your testimony, sometime in a year that you don't recall, Mr. Biggerstaff brought over this cabinet as you described it.
Mm-hmm.
Is that a yes?
Yes.
Sorry, we just have a court reporter. She needs to hear exactly what your answer is.
I got you.
My understanding is you never opened that cabinet.
That's correct.
No idea what was in it, correct?
That's correct.
And if there were firearms, no idea how many.
That's correct.
Certainly no idea what make and model of those firearms.
Say that one more time.
You wouldn't know what make or model
of firearms in a cabinet you've never opened.
He never opened it. I never opened it. He never opened it. I never wanted it to be open.
Understood. And that was
But you say you don't call that a gun cabinet, so how do you know it's not a gun cabinet if you don't open it? Could you see inside? What did you see inside? What else was hidden in there?
about a week it was in your closet.
That's correct.
After that, you testified that his son, Juan,
And him.
came and retrieved that cabinet.
That's correct.
Where it went after that, you have no idea.
I've never seen or spoke to them ever since that.
And certainly you would not have given firearms to a convicted felon, correct?
I definitely wouldn't have done that.
As to whether or not that cabinet was transported somewhere else and opened, you wouldn't be able to testify to that.
I wouldn't know what they did with it once they left my porch.
And what year do you believe this?
I don't recall what year it was.
And ultimately, you and Mr. Biggerstaff had a falling out later on. Is that correct?
Well, I distanced myself once he got convicted of what he told me he was innocent of.
You and John Biggerstaff no longer had a relationship at that point?
At all. Not at all.
And I know
What about Mrs. Biggerstaff, though?
Ms. Stifler asked you whether or not you knew Mario Fernandez. That name means nothing to you other than maybe at the top of the subpoena that you were served.
That's correct.
And so you have no information as it relates to the homicide of a man named Jared Bridegan.
Except for what I see on the internet.
But you personally have no information as to...
Never seen him before in my life. Never heard of him.
And certainly no information as it relates to Mario Fernandez and the homicide of Jared Bridegan.
That's correct.
I have just a moment, Your Honor.
Yes.
No further questions for Mr. Barton.
All right. Any redirect? Thank you.
Be excused.
All right. Thank you very much, Mr. Barton. You can step down.
Bye,
Call
sir.
your next witness.
State calls John Biggerstaff.
Everybody applaud yourself. Well, let's just give a huge round of applause. Mr. Biggerstaff is going to take the stand. Oh, yes. Is Mrs. Biggerstaff going to take the stand? We better buckle up. What are we going to hear? If you guys don't know, do you know who Mr. Biggerstaff is? I would hope so by now. Mr. Biggerstaff, when it comes to the evidence in the case, is what the state... It's who the state alleges Mario got the gun from, based on Mr. Biggerstaff's Google searches looking for specifically the type of gun that was used in this crime, and then that gun, you know, being stolen. Apparently in Texas, wasn't it? Wasn't Juan, his son, in Texas? And the gun, because Mr. Biggerstaff got convicted of other crimes, which was what again? Trafficking and drug-related offenses. So he wasn't allowed to own firearms, so he had to make like a whole little logbook inventory of the guns he had. But then magically the Glock went missing. It was like, whoops, that's stolen. So it was interesting when Mario was at John Biggerstaff's house, you know, they were like, what were they up to? Well, sometimes it was a big swingers party, okay? Because they've got video recordings of that. So for those who didn't watch any of the other trial days, Mr. Biggerstaff, it's a spicy witness because it's like, did you give the gun to Mario? We don't know that for sure, but it sure seems like it. Number two, Mario, there's video on your phone of Mario banging your wife and you watching? Oh my word. So it's just a little bit entertaining, is what I'm going to say. This is the entertainment of the trial now, as important as it is to allege that he's the one who provided the gun. He wasn't charged with anything to do with that. They don't know where the gun is. They have never found the murder weapon in this case, just the shell casings, right?
John Biggerstaff, please.
Oh, boy. Just called me. Kim says, popcorn, get your popcorn. Did I summarize Mr. Biggerstaff just fine?
He has a
or what?
walker, so he may take it.
Okay.
You got more to add, you guys? Did I miss something?
Okay.
Mr. Swinger dude, who let everybody have his wife, and he liked to watch apparently. Oh my, that's just what the defense brought up for no reason. On that day, we were like, Why is the defense? He was like, let's just get it out there. All right. Mr. Biggerstaff was a swinger. And we're like, what? We were like, why is the defense even saying that? Why did we need to know that? Oh, you're putting John Biggerstaff on the stand. Are they going to ask him questions about that, though? And about the video and audio evidence, you know, that he has of where Mario was on which day. That'll be interesting. The suspense, hey, of Mr. Biggerstaff. Here he comes. He's got his walker.
Good morning, Mr. Biggerstaff. If you could walk all the way forward, please. Good morning. Can you raise your right hand to be sworn in?
Sir, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Sir, if you'll make your way over to your right. Officer, I'm sorry, Mr. Holman, can you help him with his walker as well? Just get yourself situated in the chair, okay?
I need these two things. Purchase the 10mm document. Okay.
Where is that hot mic coming from?
Inventory.
You have to pull yourself up and talk into the microphone.
A little bit. Inventory. Come on. Yeah.
Is that Mr. Mizrahi?
And the purchase of the 10mm.
Okay. I think
Mr.
so.
Mizrahi, when you're ready.
Thank you.
I think that was Mr. Mizrahi with a hot mic. Okay. Hello, Mr. Biggerstaff. Do you see Mario in the courtroom? He's like, I don't recognize him. What? Oh, my word. He's fully dressed. Oh, sorry. Put him in a thong. Do you recognize him now? Oh, dear.
May it please the court. Counsel.
Yes, thank you.
Good morning.
Good morning, sir.
Please state your name for the record.
John Robert Biggerstaff.
And are you a convicted felon?
Yes, I am.
When did you become a convicted felon?
When I pled to felony misprision in 2017.
2017. At the time, before you became a convicted felon, did you have to get rid of your guns?
All of my weapons, yes, sir.
Okay, and that's why we're here. You know, that's why we're here to talk about that.
I understand that, yes, sir.
Did you purchase a 10mm firearm?
Yes, I did.
When did you purchase a 10mm firearm?
I don't know the exact year, but it was prior to 2016.
Why did you purchase a 10mm firearm?
I was a member of a hunting club for a few years up in South Georgia, and where I was making my hunting stand, there were bears. Did some research and talked to a friend of mine who suggested two different kinds of weapons, a Casco 454, I think it was, and a 10mm Glock. Having served with JSO and my military experience, I preferred the Glock weapons over anything else that I was unfamiliar with.
Where's your gun now?
I have no idea, sir.
No idea where your 10mm firearm is?
No, sir.
Do you regularly take gabapentin? I'm not going to get into your medical history, but you mentioned that in deposition.
Yeah, I'm sorry, what did you say?
Gabapentin, do you normally take that?
Yes, sir.
Are you on that right now?
Yes, sir.
Okay. And what is that?
Gabapentin is for nerve pain.
And are you still able to perform your daily functions having taken that prescription drug?
I don't know what you mean by daily functions, no, sir.
What'd you say?
I don't know what you mean by daily functions.
You're able to come here and...
Oh, boy. Okay, he's on medication for nerve pain? Is that what he said? And he's like, I don't know what you mean by daily functions. Oh boy. Are you still active in the swinging community, sir? Oh, is that not the question? Okay.
Testify.
I'm able to come here and testify, correct.
There you go.
What else can you do?
Were you in the Navy?
Yes, I was in the Navy.
Tell the jury about your career.
I was in the Navy on active duty from July 86 until October 1st, 2007. Served on active duty as a cryptologic technician collection specialist.
What does that mean? What you can share with us.
What does that mean? Tell us more. If that's how you laugh about it, tell us everything. Damn.
That's what
Cryptologic technician collection specialist changes with technology and threats as perceived by the U.S. government, National Security Agency. I maintain a top secret sensitive compartment and information facility type of access for my 21 years plus. When I first came in, I was a It's known now as the HF Manual Morse Intercept Operator. Over the years, I learned some different languages and performed different duties.
Well, thank you for your service. Did you also become a police officer?
I did, yes, sir. I became a JSO Reserve Officer.
Tell the jury about that.
I ran into somebody who mentioned to me he was a reserve officer with Jacksonville Sheriff's Office. Thought I'd be a good candidate. Mentioned to me about the academy and so on and so forth. They're in a safety fair, I believe, at Regency Fair, or Regency Mall at the time.
You have to undergo training.
Yes. Following my knee surgery, I had a physical fitness test the following week and started the academy right away. Yeah.
What years were you a member as a reserve officer with the Jacksonville Sheriff's Office?
It was about 3 years long, but I don't remember the exact years. Oh, well, yeah, and it ended in 2016 when I was arrested.
And I guess that was my next question. Obviously, you can't be a police officer if you're a convicted felon. Did you have it down, something happened in your life that you've talked about your Navy service and your police service, and did you have some things in your life that led you down a path that you're not proud of?
Sure, absolutely.
All right, just briefly, we don't have to get all the details, but briefly tell the jury about it.
As a result of severe...
Yes.
Ah, come on. He was about to spill the tea on himself. What? Everybody's all flustered now. That's it. Send the jury out. What are we going to do? A proffer about what he wants to say there? Come on. Apparently, I'm sure he's going to get to it. More about it. Hold on one second. Wait for it. I previously looked at what it led to see. Mr. Biggerstaff was federally convicted for running a sex trafficking operation that involved both adult women and minors. Okay. He operated a national sex trafficking enterprise between 2011 and 2016. Court documents describing as a prolific sex T, who used violence, threats, and coercion. Specific victims included minors. One was 15, another was 17. He had multiple people working for the ring over the years, including people he had previously trafficked. As a result of the felony conviction, he lost his position as a Jacksonville Sheriff's Office Reserve officer and was required to surrender all his firearms, including the 10mm Glock, that of course is relevant in this case. He also had related drug issues. He has acknowledged being a drug addict and later violating conditions involving drugs. The sex T, well, you two have used that word. Okay, conviction is the primary serious felony that made him a prohibited person regarding firearms. So the whole thank you for your service. In this context, based on what he's convicted of, I don't know if that's necessary at this point. What do you guys think? Just let him just answer the questions. Okay, just answer the questions. Look at Mario's face.
You may proceed.
Please, the court. So as opposed to that open-ended question, I'm going to ask you two directed questions. Did you end up with financial problems in your life?
Your Honor, if I may.
Okay.
Needs a break?
Well,
Let me have the jury step in the back, okay?
That was just sidebar. Because they're doing this now. We can't see what the hell's going on. Sidebar happened. The jury's now being sent out, okay? Okay, let's see what's going on here. I don't want to miss anything. Okay.
Are they in there, Mr. Holman? All right. All right. So I'm assuming that the state told him to look at me if he had concerns?
I did not tell him
Did not tell him that.
He's
Okay,
educated
so-
enough to probably know that.
All right, Mr. Biggerstaff, I cannot have any type of private conversation with you, but I can do this. So what are your concerns?
yes, ma'am. My concern is, as a cryptologist, I've been trained to look at everything and listen to everything. So I don't know if I wasn't supposed to hear that conversation over there, but the court reporter has the screen open right in front of me that I can read. I didn't read much, but I just saw that the words going across matched what I could overhear over there, and I just want to let you know in case there's something that comes out of that later.
He's concerned because he is hyper aware based on his training and experience. And he's busy reading what the court reporter is writing, which is a sidebar. I think he's referring to what he saw the court reporter taking note of from the sidebar. Okay.
I'm sure that either needs to be screened, needs to be closed if you have some kind of a side conversation I'm not supposed to hear, or I need to turn away or something.
All right, so your concern was that you overheard part of what the sidebar was about.
Via the screen, yes, ma'am.
Did you hear it or you read it?
I read it.
Okay. Is any of that causing you a concern?
No, ma'am.
Did the objection cause you any concern?
I didn't hear the objection, ma'am.
You didn't?
No.
Did you read it?
No, ma'am.
Okay. So I will tell you, since the state didn't, if you do have some concern about, did you tell him some area that he shouldn't get into or not? I'm not sure. With the other witness, there was that issue. I'm asking.
I don't think that there's an issue with this witness, Your Honor.
Okay, Mr. Dreiser, do you?
Not that I can think of off the top of my head.
All right. So did you have any concern about your background, sharing that with the jury? I just want to make sure that we can, when I bring him back out, we can.
Military background? No, ma'am.
All right.
No.
Okay. I think we're good to go. I don't, unless the lawyers think that there's something wrong, I'm not going to have Ms. Simpkins put her screen down.
So, Your Honor, we're aware of the issue now, and if the lawyers will bring it to your attention if it needs to be put down for the witness.
Okay.
Okay.
Well, I can do this. Ms. Simpkins, can you angle it a little differently? I'll go off. No, right now. Just angle it down a little bit. Is that good?
Yes, ma'am.
Okay.
I didn't intentionally read the whole thing, but.
For the record, the screen is angled down. Let's bring the jury back.
Okay, Mr. Biggerstaff, a favor. Could you attend Shanna Gardner's trial and sit behind Kim Jensen? And then come and report back, okay? Anyway, just say what you read. Say what you read. He's that guy that's going to be sitting behind you in an airplane, on a train, wherever it is, and be like, reading all your messages. Okay. Okay, bring the jury back in. Let's resume that testimony, shall we? My goodness. Direct state ask again. Here we go. Now continue on, sir. Was that a deflection from the question or what? Maybe. Good distraction. Let's make sure they get back on track, right? Ask the question again, prosecutor. Same way you asked it before. Maybe Mr. Biggerstaff was distracting you with all this. Okay, again, I don't want to miss a damn thing, but let's go forward a little bit.
Mr. Biggerstaff, we left.
Hi. Okay, here we go.
All right, welcome back, members of the jury. Everyone may be seated. Members of the jury, pardon the interruption. Mr. Mizrahi?
Please, the court. So, Mr. Biggerstaff, we left off with my question about the change in your life. You were a police officer, you were Navy, and did you end up with financial problems?
I had financial problems long before that, yeah.
Did you also end up with a drug addiction problem?
As a result of PTSD, drug addiction, depression, anxiety, yes.
I'm just trying to explain to the jury the shift in your life. Would you agree there was a shift in your life?
Yes.
Do you know Mario Fernandez?
I do, yes.
And how do you know him?
I've known him for about 18, 19 years. My daughter got a ride home from him one day from school, introduced us, and we became workout buddies for a while.
And do you see him here in court?
Workout buddies, that's what they call it. We became workout buddies for a while. And sir, you would also sometimes film him having sex with your wife. Am I right? Is that correct, sir? Okay, now can you describe that? Okay, no, don't. We don't want to hear that. Do we want to hear that? Or maybe we do want to hear that. Tell us, sir. Tell us everything. What was Mario doing exactly?
Yes, I do.
Did you say where he's seated? Where
He's
he's lying so you can identify him?
seated to my right.
What color suit is he wearing?
I'm colorblind, but it appears navy blue.
Oh, you nailed it. Your Honor, this time the state would ask for the record to reflect the witnesses identified the defendant.
I think they're all in.
Oh, they're smiling at each other now. Tails are wagging, you know. Sir.
Blue.
He said navy blue. Although I think Mr. Dreiser is navy blue.
All right. Yes.
So you explained you.
Oh, my word. Stop smiling. Stop it. Are fond memories coming back? Flashbacks, huh, sir? About your epic workouts? Now, do tell us about that tile work that the defense was making us watch. It wasn't tile work, was it? What were you really doing?
We're workout buddies. Just kind of dive into that a little bit for us, please.
Yes. In the mornings, Mario would come over and type his Pitbull 0 to my truck. And we would work out. I had purchased a home Nautilus gym from Sears many years ago and had it in my garage. It was enclosed. My son was playing football in high school and then on to college. And so we would work out in the mornings. Mario, when he was at home in Jacksonville, would come over and work out some mornings. We'd text each other in the morning, make sure I was up and going to work out. I think I was retired at that time, so I was working for Hewlett Packard, and I was on a 100% travel schedule. So in between my traveling, we'd get together and work out at my house, and then he joined the Army at some point, and I didn't see him for years.
Okay. When he got back from.
But so back to he would text you and ask if you were up so that he could come over and work out? Interesting.
From the Army, did your relationship begin again, so to speak?
Yes.
And did you share experiences in the military with each other?
Yes, occasionally.
Like what?
Back in 2020, let's turn back to 2018. Were you aware of who Shanna Gardner was before you found out that she got married to Mario Fernandez?
No.
Explain to the jury how you found out that they got married.
One day when Mario was at my home, he brought up a picture of him and Shanna, and I believe it was in Hawaii on a honeymoon or something like that, and said he had been married for, I think he said 2 years, I think at that point. It was at least a year. And that kind of surprised us. So.
And why did it surprise you?
Well, I hadn't seen or heard from Mario in a while, and then to find out that he was married, somebody would consider a family friend, it was kind of shocking to find out that he had been married.
Again, with your relationship, was there an occasion on February 15th of 2022 that this defendant, Mario Fernandez, had sex with your wife? I think her name's Maria.
My wife's name is Maria.
Maria and Mario. Okay, and that was the day before Jared Bridegan was murdered, by the way. February 15th of 2022. So when they told us that Mario was at Mr. Biggerstaff's house, and I think they said on that day it was from like 2:30 until 4:30 or something, we were all speculating about what that could be and like, oh, and then they said something about on the audio, did you hear this and this? And I'm like, oh man, they were up to some naughty business that day, and it appears, well, as we just heard, yes, they were. Mario was there to, to be with Mrs. Biggerstaff in front of Mr. Biggerstaff. Okay.
Do you recall that situation?
I don't recall the date. I do recall the situation, yes, sir.
And that was based on your request?
That's correct.
Did you have to convince Mr. Fernandez to do that?
I did.
So he wasn't initially willing until you kind of pestered him for a while? Is that
correct?
Okay. And you would agree that that was recorded?
Either pictures or video, yes, sir.
And so whatever the pictures or video show about the date, you would agree that that's right?
Correct.
Okay, so if it does show February...
Time to show an exhibit. Yeah, no? We got to see it with our own eyes to know if it was the date that they were referring to.
15, 2022, you would agree with it?
Yes, sir.
Did you do work for Mario Fernandez, the defendant?
I did.
What was the most Mario Fernandez ever paid you at a time?
I have no idea, but it was at the most hundreds of dollars to a couple hundred.
Did he ever pay you by check?
No.
What kind of work did you do?
I had a handyman business, and he would, I guess, subcontract me would be the correct word.
Was your handyman business registered with the state of Florida?
It was.
What was the name of it?
904 Handyman LLC.
And so the $200-300 you got was paid to you in cash. I think you said that.
You're correct.
Did you do work on the Potomac address?
I did.
The Henry Tenon, do you know who that person is?
I do, yes, sir.
And how did you meet him?
Henry was a tenant under Mario's rental property there. I had been working for a while to raise the shower head in the shower. Been there for a couple of days back and forth before I met Henry as I was departing the home the first time.
Is the reason you were raising the shower head because Mr. Tenon is...
He's very tall.
6'6", whatever he is?
Very tall, yes, sir.
Okay. And that's why you were doing that?
That's correct.
Did Henry Tenon ever work for you?
No.
Did he ever work with you?
No.
Did he ever work your wife? Come on, ask the question. We need to know. Did you ever film him? Okay, what? But that was important for the jury to hear. See, we're leading up to the checks, okay? But just don't take too long now, State. Show the jury the checks. For the jury, that's going to be like the jaw on the floor, mic drop moment when they see the checks that Mario wrote to Henry Tenon in March and in April of 2022. Because it was $10,000 worth. And just this witness right here did work for Mario, but said Mario never paid him more than, a couple of $100, and he never paid by checks. All right.
I want to talk a little bit about the defendant's issues that he had with Shanna Gardner's ex-husband. Did the defendant share issues with you that he had with Jared Bridegan?
Just two that I remember.
Tell the jury about it.
Mario had mentioned that there was some tension between him and his wife, Shanna, when he would have headaches, and I'd invite him over because we had determined earlier that a cigarette would clear his headaches, and I had cigarettes. I
don't think it was the cigarettes that cleared his headache. But okay, go on.
He'd stop and get a beer for two of us sometimes and bring him over. We'd drink a beer while he'd smoke a cigarette, and just say that her ex had caused a lot of problem or stress between Mario and Shanna because she was in court over the children, and as soon as court would be over, it seemed like she would be called right back into court, if I remember that correctly. And the second was kind of related to that was, I think it was the boy in the family had like issues with elevation, flying to New York to see a specialist that he was required to see. I think that was it. As far as I know, that was the tension between him and Shannon, but those are the only two issues he ever spoke to me about.
Raina Banks said a cigarette has never cleared a headache. Have you guys ever heard of a cigarette clearing a headache? Depends if you call a blunt a cigarette. Is that the kind you mean, Mr. Biggerstaff? Could you clarify what kind of cigarette do you mean? The kind with weed in it? Did you roll it yourself? Maybe that. A cigarette? Nah, I don't think so. Marlboro? I don't think so.
And they were both related to child custody issues.
Correct.
Do you remember on January 25th of 2022 that the defendant came to your house?
No.
Would you have known what the defendant did after he left your house?
I have no idea.
And you have no memory of what y'all would have talked about?
No, none.
Did you become aware of the fact that Jared Bridegan was murdered?
Yes.
Tell the jury about that.
I heard it first on, I think it was Channel 4 News one morning or afternoon, and just in summary, of course, I didn't know his name at the time or anything. And then sometime after that, it was a couple of days or a week, Mario was helping me, I believe, moving things to and from my trailer that I was working on, big, great trailer I had, probably 10 miles from the home. And he had a pickup truck, and he would help me move things back and forth.
Who had a pickup truck?
Mario had a pickup truck. When I got in the truck one time, he had mentioned that Mr. Bridegan had been murdered or shot. And I think the words that he used was, the kid's dad is dead or something to that effect. And I said, oh my God, is that the story that's on the news and everything? And he said, yeah. And that was pretty much, in a nutshell, that was it. That was about the end of the conversation.
So you didn't know anything about the name Jared Bridegan. He just referred to it as Shanna's ex. Is that fair?
Correct.
And so then you were able to put two and two together because you had seen the media stories of the case.
Yes, sir.
When did you become aware of the fact that Jared Bridegan was murdered with a 12-millimeter Glock firearm?
Never.
Even today?
You said 12 millimeter. There's no such thing as far as I know.
I misspoke. See, you're careful. Good. Misspoke. 10 millimeter.
10 millimeter, not until a couple of months ago. It was mentioned by Miss Stifler, I believe. Either her or her investigator Bennett mentioned the 10 millimeter.
But as you indicated that you purchased a Glock 10 millimeter firearm, correct?
Correct. One of many.
I'm showing you what's been entered into evidence as State's Exhibit 191. Mr. Biggerstaff, if you could review those last two pages of State's Exhibit 191 and indicate if that's you purchasing that 10 millimeter Glock firearm.
Without verifying the serial number or the concealed weapon permit, that seems like the purchaser of the dealer information I bought it from.
And it has your name and address.
It does have my old name and address, correct?
So it appears to be your purchase of that 10 millimeter Glock.
Correct.
You would only be able to verify if you had the serial number.
And my weapon, yeah, my concealed weapons number, yeah, serial number. Yeah.
Microphone.
Yes, I'm sorry, the serial number would verify that it would be the correct.
I'm going to leave State's Exhibit 191 up here. I'm going to show you.
Stefan says 12 millimeter would be half an inch, so he was thinking of something else, right? The prosecutor, when he said that, keep going, prosecutor, what else do you want to ask?
What's been entered into evidence is State's Exhibit 190. I understand that it's not the best copy. What is State's 190?
We don't need the sniffles. We can't defluff that now. There was a big sniff into the mic. Sis.
It appears to be the handwritten inventory of 20 weapons that I surrendered in 2016.
So you recognize that?
Roughly, yeah.
And who filled that out?
Myself and my son. It's his handwriting, I believe.
And if you could go to the serial number column 3 of the Glock 10 millimeter, go down to line 7. It's going to be the Glock 40 10 millimeter. Can you read off that serial number?
It would be B as in Bravo, B as in Bravo, G as in Golf, L as in Lima, 770.
And can you read off the serial number of the purchased firearm in State's Exhibit 191, which is up at the top?
It is B as in Bravo, B as in Bravo, G as in Golf, L as in Lima, 770.
So you would agree that this is the firearm that you purchased and the firearm affidavit that you turned over to your federal probation officer?
Correct.
So what you turned over to the federal probation officer was before you were convicted, correct?
That's correct.
So you were hoping that you would get those firearms back at some point.
That's what they told me, yes, sir.
Until you became convicted and you knew that would never happen.
That question, I'm sorry.
That's a question.
Yeah, that's obvious.
Okay. And as you sit here today, you cannot produce that firearm.
That's correct.
Your 10 millimeter Glock 40 firearm was functional?
Was functional?
Was it?
As far as I know, it was.
It was operational?
As far as I know.
You shot it?
I did shoot it after purchasing, yes, sir.
You had ammunition for it?
I, at one time, purchased ammunition for it, yes.
In fact, you had ammunition for all of your firearms, correct?
No.
Is there a purpose?
There's a purpose in this question, yes.
No, I mean, for the leading nature.
No, I can ask it.
All right, I'll sustain it then.
Just speed. Tell the jury what ammunition you possessed.
I have no idea what the hell I possessed back then. None.
Okay. Did you possess ammunition?
I had previously possessed ammunition. I used to have a locker which ATF searched. I used to have ammunition and guns in there, yes, sir.
Is a firearm able to be fired without ammunition?
It can be dry fired without ammunition. You can't injure anybody, as far as I know, without ammunition and no weapon, if that's what you're asking.
What happened to all your ammunition?
Ammunition and all the weapons were stockpiled in 2016, and I have no idea where that crap went. None of it. Excuse my.
No, you don't think these things are crap, do you?
Do I think they're crap?
Yes.
No, I was irritated about the whole situation by having to surrender my weapons, sir.
You would agree that the ammunition is not contained in the inventory?
No.
So you would agree there's no documentation that we have to show that you surrendered your ammunition?
As far as I've been told, there's no documentation to show that I surrendered anything. So that would be yes, correct.
So the crap you referenced was about the charge in your conviction, not the guns or the ammunition.
Word crap came from the charge, yes, sir. It's not.
Because you like guns.
Used to.
And you didn't want to get rid of them. Is that fair?
I did not want to get rid of them under the situation. That's correct.
And there was a point in 2022. I just want to make it clear for the jury. When was that inventory? When did you surrender all your guns?
2016.
And was there a point in January of 2022, specifically January 25th of 2022, that you missed your guns?
No.
Never?
No.
Stifler, can you find that search for me?
Now, how are we supposed to believe anything you say, sir? No, never. Used to like guns, not anymore. Never missed them at all. Who cares about that crap? You know you want them. There's no used to. He just can't have them now because he's a convicted felon. Maybe he has some, we don't know, but like, sure. I'm saying that because you're downplaying so much. No, I didn't miss them at all.
You would agree that guns have value?
Yes.
Specifically, 20 firearms would have approximately how much value?
I have no idea.
Well, I mean, have some general idea.
No, I don't have a general idea. It's not my business.
Is it worth $5?
Sorry?
Would 20 guns be worth $5?
I have no idea.
Would it be worth $100?
I don't know. If you're asking for guns from a
So you had financial problems for a long time, but you have no idea how much guns cost, but you had a whole collection of them. Sure. Again, I don't believe him.
convicted felon, I have no idea what they cost.
No, I'm asking you, based on your knowledge and experience and lifetime of purchasing firearms, how much they cost.
I don't know.
How much did the Glock 10 millimeter cost?
I don't know that either. It should be on the receipt.
Can you give this jury any approximation of how much these things cost?
No.
You would agree that you are not a rich man.
Correct.
Could you have sold these firearms?
At what time are you asking? I'm not sure what time you're
At any time.
I could have sold them up to 2016, yes.
And even, and let me be clear, in other words, before you were convicted of the crime. could you have sold them?
Before I had to surrender them, I could have sold them, yes.
Okay. Even after you surrender them, do you believe you could have sold them?
No.
And why not?
Well, I know better than that. I haven't been in JSO, sir, and worked on some of the things I worked on. I know how some of the systems and checks are done.
You would agree, Mr. Biggerstaff, that your son, Juan, I'll ask another question. Just try to get. Who is Juan Biggerstaff?
It's my son.
And at the time, was he in law enforcement?
Yes.
You would agree that he helped you. I'll ask the question in a different way.
I'm sorry, you said at the time, what time are you referring to?
At the time that you surrendered your firearms.
2016? I don't know that he was. I don't think he was.
Was Juan Biggerstaff a prohibited person? In other words, could he have sold your firearms had you given them to him?
Yes.
And it was Juan Biggerstaff, the person that helped you compile your inventory list.
That's correct. I think he was law enforcement because of a situation where I transferred one to him in that whole stockpile.
You think you transferred him one of the 20 guns?
Yep. Yes.
And which one was that?
It was my backup JSO pistol. It was a Glock 40 millimeter.
Glock 27, 40 millimeter? It was 27 model?
I don't know the model number. I'm sure you do.
Okay. Do you know anyone else that owns a 10 millimeter?
No.
I'm showing you what's been entered into evidence. Stakes Exhibit 197. There's not a lot of room to put it there, so I'm going to have to, I guess, take it out.
Mr. Biggerstaff, don't get too far away from the microphone.
Pardon me.
Have you reviewed that?
Yes.
And we talked about this in your deposition. Do you remember that you did search on January 26th of 2022, 10 millimeter firearms?
No, like I told you then, I searched on all kinds of things all the time. I believe I clicked on bookmarks from the look of this.
Okay. But you would agree with the record speaks for itself?
Yes.
Okay. And then showing you, did you also, I think we talked about this in your deposition, search furniture with hidden compartments?
Yes.
You remember that?
Sure. Yes.
Okay. Now, do you remember making the statement that you missed your guns?
Yes.
Okay. So you do remember making that statement?
Of course.
Okay. And I understand you might have been speculating, but that may have been one of the reasons why you were searching for Glock 10 millimeter back in January. And I was right when I said the 25th. Those were in UTC, so it was the 25th. I'm sorry, let me go back to my question.
Please.
Your missing of the guns may have been the reason why you were searching for them on January 25th of 2022.
No, I think after looking at the furniture thing, I was looking for a way to conceal my substance abuse at home.
Okay. But you would agree that the record speaks for itself about whether you were looking at firearms as well?
Mr. Mizrahi.
I don't think that's a leading question. You agree with that?
I'm sure I clicked on, from the look of it, I'm sure I clicked on bookmarks.
Okay. Going back to your son, do you remember Juan Biggerstaff coming to your house? Strike that. Well, we'll do this now.
Why does the prosecutor not ask a follow-up question about that? I'm sure I clicked on bookmarks. Oh, so you had bookmarked those pages to refer to not just that one day, but many other days. You were looking up Glocks and you were looking up furniture that you could hide things in. Okay, thank you.
Coming to your house on December 21st of 2022.
I don't remember the date, but I remember my son coming to my house, yes.
It was shortly before Christmas and the holidays of 2022. Do you remember that?
I was thinking it was Thanksgiving, but yes, I remember. Okay.
And do you remember talking about the case with him?
Not the case, no.
Do you now know that Juan Biggerstaff came to your house while you were wearing while he was wearing a recording device?
I knew that. Yes, I knew that.
You know that.
Do you know now that your son was there with a recording device? Yeah, I knew that. That was an interesting answer. It was very telling. Not that, yeah, I know that now. Yeah, I knew that. We know you knew that because a lot of the recording was missing. And Juan was probably like, yeah, I knew that. Okay, thank you for that.
Now or you knew that then?
Well, again, based on my prior military experience and JSO experience and not being an idiot, it was pretty obvious.
Ah.
So back in December, I understand you don't know the specific date, but back in December of 2022, you suspected that your son was wearing a recording device? Yes.
Correct. No? Sure. Okay. Yes.
Did he tell you he did?
No, sir.
And although you may have not been talking about the case, you did talk about the investigation where police officers came to your house and were asking questions about the 10 millimeter.
About weapons, and he asked in general weapons. I don't know that he asked about the 10 millimeter. He asked about where my guns were, who had them.
And what did you tell him?
A couple different things. In the beginning, I told him that I had no idea. He knew that I didn't have any idea. He kept pushing for saying they want to know where your guns are. They want to know who has them. So then I told him that somebody would get them to me by the 1st of January. And then I would make a call to ATF and tell them who had, or as soon as I knew who had them or where they were at, I would call ATF, something to that effect.
Okay, you've had the opportunity to listen to that recording.
That's correct.
And do you remember if he talked about starting to prepare for perhaps your arrest and helping his mother deal with that? Do you remember that's how the conversation began?
No.
You also remember that you told him that the only thing they cared about was the 10 millimeter.
I told him that?
Yes.
I don't remember saying that, no, sir.
And do you remember saying that it had been in your possession the entire time?
I don't recall saying that. Actually, I think that was one of the first things I said after I saw that he was pressuring me for more information.
Okay, so now you remember saying that the 10 millimeter has been in your possession the entire time.
I may have said that, yes, sir.
Was that the truth or a lie?
That would have been a lie.
To your law enforcement son?
That's correct.
Do you remember discussing that you felt law enforcement was concerned because of your relationship with Mario Fernandez? Do you remember that discussion?
No.
So the first thing you said is you've had it the whole time, but then do you explain to the jury what you remember about the second conversation where you said it was going to appear at the turn of the year?
I never said that in the beginning. In the beginning, I told him I didn't know where they were.
Okay. And then you said you had it the whole time. And then you said it was...
Somewhere during the conversation, I told him that I'd had them. Then I told him that somebody else had them and that they could produce them by January 1st.
Okay, so those are the three things. First, you said you didn't know. I'm leading just to try to make it quick. Second, you said that you've had it the whole time. And then third, you said it's going to appear on January 1st.
Correct.
Did you tell your son that you were going to call law enforcement when it would reappear?
Yes.
And this conversation would have been before January 25th of 2022.
Before, no, 2022.
This would have been, after 2022. Sorry, I said it wrong.
Holy crap. Yes.
Do Do you remember telling your son that you told law enforcement that Steve from the Georgia Hunting Club had the gun?
I'm sorry, say that again.
Do you remember telling your son that Steve from the hunting club had the gun?
No.
Do you remember apologizing to your son that you had put him in this position?
Yes.
Do you remember telling your son that you wouldn't tell him why he had to wait until January 1st to find out where that gun was?
I remember saying something when he asked me why January 1st or something along those lines. I responded. I don't know how I responded. I don't know the words I used.
Was that a fair?
No, it's not fair. I don't remember.
Would you want to listen to that wire to refresh your memory?
You can try. The wire was pretty crappy. I hope you guys pick out some of the words before, but we can, if you want to.
Okay, well, we may do that at the appropriate time. Okay.
Okay.
We want to hear it.
Were you telling you the truth to your son in this conversation?
Initially, yes.
And then what changed?
I wasn't telling the truth. That's what changed.
Do you remember when Detective Lamont came to your house?
No, Detective Lamont, I don't know. I'm terrible with names.
You remember when Jacksonville Beach scheduled a meeting with you and you said, what?
If you're talking about when I was working at the school, like 4 years ago, yes. Yes, I remember.
You remember scheduling it for the next day?
No, I remember being contacted. I remember they came to the house in the morning as I was leaving to go to work, and they asked me if they could come back in the afternoon, and I said yes. And then I think that afternoon they contacted me, asked me to go down to the station, which I did at nighttime in the evening. I think it was the same day. I don't think it was the next day.
Regardless, in the meantime, you met with Mario Fernandez.
No. That day? No.
In between when you were asked to meet with Jack's Beach and the time you met with him?
No.
Okay. Do you remember deleting things off of your phone in between those two events?
No, sir.
So if the records show that, they would be wrong.
I don't remember them. I delete stuff all the time, sir.
Okay. Did you ever receive a courtesy call from the defendant about Henry Tenon's arrest?
No.
No.
Not that I remember, no, sir.
But didn't he call the same day Henry was arrested? Damn, this guy can really withhold information with a straight face, eh? In my opinion. Obviously, based on all his training and experience that he keeps referencing. But the jury's still hearing, so you made up a lot of stories about the gun. You didn't know where it was. You had it the whole time. It will appear on January 1st. Steve from the hunting club has it. Wouldn't tell him why he had to wait for the gun to reappear. And that he's sorry put his son in that position. That's weird. That's all weird stuff, you know? I just wish they'd ask a more direct question. Maybe they're getting to it about, do you know that we think that you gave Mario the gun? What do you say to that, huh? Did you give Mario the gun? I don't know. That'll be interesting to see. What do you say then, huh? Do you get all flustered at all? No? Did your son? Anybody? Was it hidden somewhere in the furniture?
Do you recall making a statement
Did you ever get any furniture with hidden compartments?
to law enforcement that Mario Fernandez contacted you and gave you a courtesy call to tell him he might get questioned?
Told me he had been questioned, that the new tenant at the home I was working on in Potomac might be questioned, and then I might be questioned as well.
Okay, so you do remember?
I remember, yes, sir.
Who is Fred Barton?
Fred Barton was an acquaintance for at least a couple years, retired sergeant from Jacksonville Beach Police Department.
And your relationship back in 2016, did you have a fine relationship with him?
I don't remember 2016. I don't know how it was. I don't remember.
You remember your gun cabinet going over to Fred Barton's house?
No.
It never did?
I don't recall it going to Fred's house. I can't say it never did, but I don't recall it.
Why would you not recall that? I don't believe this guy at all. Right? Oh, you don't remember. You remember in 2016, I mean, significant time, because it's like, oh crap, you're about to get super arrested and charged with some terrible crimes and have all your guns taken away that you have no idea how much they cost. Sure. And then you're hiding the gun cabinet at Fred Barton's house. Fred, the guy that you're dropping your wife off at for weekends. But you have no idea that you asked Fred to store that gun cabinet for a week. Sure. You should know that guy. You literally dropped your wife off there every weekend, sir. And then your gun cabinet. Oh, my word. Don't even say no, you don't. You can't say that you don't know that.
What happened to your gun cabinet?
I don't know. That's where the ammunition was stored and the weapons. Everything, family heirlooms, compound bow, all that stuff was there.
And that cabinet is on the porch of your house right now.
No, it's down in a landfill somewhere. After ATF inspected it, I chunked it out in trash because it was a piece of junk.
Okay, so ATF did go to your house and see your junky gun cabinet.
That one, as well as another one I told them I had, wasn't a gun cabinet. It was just like a document safe in my closet. I showed them that one as well.
Okay, but what you put into a landfill was the cabinet that stored all your firearms and your ammunition.
Previously, yes.
And you never know where that went? How it got back to your house?
I don't think it ever left the house, sir. It had gardening tools in it.
See, he's not confusing the prosecutor with two of them. Mr. Fred Barton said that the cabinet didn't even look like a gun cabinet. So, okay, then we're talking about the one with a documents cabinet that just so happened to have guns in it. Okay, that Mr. Barton had kept in his closet for about a week. So that's one, and that might be the one he got rid of in the landfill, he says. Okay, but there was another one, an actual gun cabinet. There was all, I don't know what, old rusty whatever, full of garden tools when they went to his house, right? And from Alabama, said, find a quarter from day one. Timestamps are great. Oh, cool. Okay, I'm glad you like the timestamps. That's why I do them for you. Thank you so much for your support.
So the inventory that you gave your probation officer listed 20 firearms. You agree with that?
No, I don't. It's 20 different weapons. They're not all firearms, I don't believe.
Fair enough. What did you do with them?
What did I do with them? I inventoried them. We stockpiled them in the living room. I think I gave them the middle finger because I was so upset about having to surrender my weapons, and I left the room and went to bed.
Okay. Where did they go?
I don't know where they went, sir.
Do you think the probation officer took them?
Probation officer or JSO, whoever picked them up.
So is it your testimony that you think that JSO or the probation officer stole your firearms?
I don't think they stole them. I believe that was part of the process, either that or U.S. Marshals. Since I was on probation and had to interact with U.S. Marshals several times.
And your son Juan was there, was he?
Previously stated, yes, sir. He was there. He helped me with inventory.
Do you think he took them?
Do I think my son took my firearms? No, I don't think he took those. Only the one that I told you about.
Glock.
The Glock 40 millimeter, yes, sir.
So the 19, you don't believe your son took?
If that's the 10 millimeter that you're asking me about?
Asking about all 19 other things documented on that list.
Oh, the other 19 things. No, sir. My son didn't take those. I'm sure of that.
But thanks for thinking that he was asking about that 10 millimeter that allegedly your son did take. Allegedly to Texas, if I remember correctly. And it was stolen or what? Meanwhile, Henry Tenon told the police that the gun, the 10 millimeter, the one that he allegedly used You know, he's going on trial now instead of just pleading guilty like he had in a plea deal. Okay, he told police he confessed everything and was going to testify against Mario and Shanna. He said, Henry Tenon said, he put it in a vehicle that was scrapped. So the gun was scrapped along with the vehicle, and it's irrecoverable. So where is it? All these people are like, I don't know. Henry Tenon gave a clue, but like, I don't know. Does it have to do with this guy or not? Did he provide it to Mario or not? What is the jury supposed to make of it? Besides, this guy is a little bit shady, hey? Little bit.
But you don't know where they are or where they went.
I have no idea where they went. I have no idea where they are, no, sir.
And did you ever go to Fred Barton's house to drop off your gun cabinet and then pick it up a week later?
No, sir.
So are you saying that Fred Barton lied on the stand, or are you lying on the stand? Because you got conflicting stories there, sir.
Are you aware of your son, his law enforcement duties in Texas, had a burglary into his vehicle?
I'm sorry, say that again.
Are you aware that your son, while he was a law enforcement officer, had a burglary into his vehicle?
Into his undercover vehicle, that's correct.
You were aware of that?
I have been made aware of that, yes, sir.
And you're aware that he listed several firearms that were stolen?
No, I'm from Miss Stifler. I believe there was only one that I was told about.
Okay. Are you aware that he took more than one firearm of yours that he says you gave him?
No, I'm not aware of that.
Mr. Biggerstaff, would you get in trouble if you possessed a firearm or ammunition at this point in your life?
Yeah, that's correct. It's against the law.
Your Honor, that's all the questions I have at this particular time.
All right, let me check in with the jurors. Is everyone okay? Okay, you may proceed. Cross.
Good morning, Mr. Biggerstaff.
Good morning, Mr. Reiser.
You doing okay?
I'm hanging in there, sir.
All right. You and Mr. Fernandez have had a relationship since he was in high school, correct?
Correct.
And
Mr. Dreiser, we trust you to ask the right questions about the dirty, dirty tool bench and the activities that were recorded with your client, Mario Fernandez Saldana.
when you were healthy, you worked out together. You said that, right?
That's correct.
And when he would go away on deployment, you weren't sending him care packages or anything like that. You weren't that close, correct?
No, sir.
And then if he came back, you guys would talk, work out, chat from time to time, correct?
Correct.
Okay. During those chats, did Mr. Fernandez ever talk nasty about his wife's ex-husband?
No.
Did he ever tell you he wanted to kill him?
No, sir.
Did he ever tell you he wanted to hurt him?
No, sir.
Did he ever seem really frustrated, like he was going to do something to him, or he was unhinged about his wife's ex-husband?
No.
Never got that impression, right?
No, the only frustration he ever shared was the tension between the two of them and over children and his new fatherhood.
And I want to ask you a question that the government didn't ask you. And if you don't understand my question, you tell me, because I'm going to try to make it.
Let's wait the suspense here for the question. LaSusie said he's a liar that lies with a straight face. Thank you for your sticker and your support. I really appreciate it. Ready? Here we go.
As simple as possible.
Okay.
Did you ever give Mr. Fernandez a 10-millimeter firearm?
No, sir.
Did you ever give Mr. Fernandez any firearms?
Never. No, sir.
Did you participate in the planning of the murder of Jared Bridegan?
No, sir.
Did you help Mr. Fernandez in any way?
No, sir.
Did Mr. Fernandez ever tell you he participated in the murder of Jared Bridegan?
No, sir.
Did Mr. Fernandez ever admit to you that he had anything to do with the death of Jared Bridegan?
No, sir.
You told this jury that You don't remember what happened to your firearms. Is that my understanding?
That's correct.
And you don't remember going to Fred Barton's house. Is that correct?
That's correct.
And you don't remember what firearms Juan took. In fact, what your memory is that he took one firearm.
That's correct. Yes, sir.
Didn't you hear the government ask you a lot about history?
Correct.
You know, I don't recall them asking you about an injury that happened to you in 2022.
Yeah, I'm going to object to the form of the question.
I'll sustain it.
Were you asked any questions on direct about an injury that you sustained in 2022?
No.
Okay, why don't you tell the jury what happened to you in 2022?
I had a slip and fall injury on July 21st, coming out of a Circle K gas station. Sorry. I came out of a gas station with my hands full of products. On my way to my son's, and his wife had, we just came back from Key West for the weekend, celebrating my wife's 50th birthday and my son's proposal to his wife. And they were going to show us both sides of the family, the venue that they were going to do their wedding in and see if it was available. And then we were all going for pizza. I went to a Circle K gas station because I'm a horrible cigarette smoker. I had to have my cigarettes and some caffeine. While I was inside, there was a 4-foot or so laminated poster that came out of the bottom of a frame that they use on the outside of the store to announce the breakfast sandwiches and such. It slid out of the bottom of the frame. I slipped on it. I slammed backwards, injuring my head and my spine.
Did that result in you being diagnosed with a traumatic brain injury?
Yes, sir.
And was that by Dr. Emis, a neurosurgeon here in town?
Correct.
Since the time that you have been diagnosed with a traumatic brain injury, is your memory as good as it used to be?
No, sir.
Would you agree that you don't have as good a memory as to things that happened before that?
Absolutely. I'm on medication for short-term memory loss even.
Okay, but you remember that in between 2 days, you definitely didn't contact Mario. That was clear to you. There were a lot of things that were clear and a lot that's maybe not. Short-term memory. How about that long-term? Okay, he gets very emotional about his ouchie he got, his boo-boo. Okay, I'm not trying to minimize it. It sounds painful and horrible, TBI and all that. But like, whoa, like, oh, there's the emotion. Now there it is. Okay.
Right now?
Correct, yes, sir.
Okay. And could that affect your ability to remember details from 2016 and 2017?
Absolutely, yes, sir.
But you remembered so many things, right? I find it interesting that there were key questions about his Google searches, about the guns, how he felt about them taking the guns. He doesn't know where they went and all that. About the recorded call with Juan. There were so many vivid details he did remember. But anyway, okay. Moving on.
When Mr. Fernandez would pay you for work that you did, you said it was $200 or $300. That's not total, correct?
I don't recall any amounts, to be honest. I was asked to throw a figure out there.
And you would get paid per job, correct?
Correct.
So you don't know. Mr. Fernandez may have paid you thousands of dollars over the years, right?
It could have been. It should have been documented in the invoice program that I used for my company.
And fair enough, you did fall into some substance abuse issues, correct?
Correct.
So you wanted to be paid in cash, right?
Correct.
Because that's how you would buy drugs on the street, right?
That's correct, yes, sir.
Okay. You're clean and sober now?
I am a little over 3 weeks, yes, sir.
Congratulations.
Thank you.
But during the time that Mr. Mizrahi asked you about conversations that you had with Juan Biggerstaff, were you using drugs at that time?
Yes.
Okay. You acknowledge that you bought a 10-millimeter firearm, correct?
Correct.
It was a bear hunting gun, you said.
A bear defense gun, yes, sir.
Did you give that gun to Mr. Fernandez?
No, sir.
Did you give that gun to anybody that you believe the intention was that it end up in Mr. Fernandez's hands?
No.
Did you give that gun to Henry Tenon?
No.
Have you ever seen that gun since law enforcement took it from you back in 2016-17?
No, sir, I have not.
All right. So let's look for evidence that maybe you still deal in firearms. You became a convicted felon in 2017, is that right?
Correct.
And today it's 2026, August. How many times have you been arrested for being in possession of a firearm?
0.
Objection, Your Honor.
Let me see it, sidebar.
Sure. Cue the waterworks when it's the when it's the defense asking the questions. That made a shift, which the state asked about a shift earlier. This was sure a shift in demeanor. Okay. A little bit of sidebar. Why can't we see sidebar anymore? I don't understand. Let us see it. Weird that. Is there an issue with seeing sidebar? Mario, you disappointed your daddy. It's not his actual dad. It's just someone he may have called daddy, in my opinion. Daddy, I'm on the way. I don't know if that's what his text messages said, but I think it could have. You feel bad? Mario looks like he feels bad. He's got pain in his eyes now. Now they're feeling bad for Jared Bridegan, who was killed, but okay. They just feel sorry for themselves. Okay. My word. Okay, wait. What is happening now? Okay. Beehive said, another highly coached witness. By the defense, right? I'm doing okay. I'm hanging in there is already how the cross started. How are you doing? I'm hanging in there. Oh, we've gone into frail little man mode. Slipped on a sign for a sandwich, eh? We're crying for ourselves now? Sir, this is a murder trial, okay? The widow is right there. But all right.
You may proceed.
During the course of this entire criminal investigation, law enforcement has made contact with you on a number of occasions. Is that correct?
That's correct.
They've come into your home?
That's correct.
They've searched your home?
Correct.
Did they ever find a firearm in this case?
No, sir.
Did they ever find a bullet or an ammunition in this case?
No, sir.
Have you ever been arrested as a result of this investigation for being in possession of ammunition?
No.
Have you been arrested as a result of this investigation into you still having a 10 millimeter? Have you been arrested for felon in possession of a firearm?
No, sir.
Okay. At some point in time in August of all of 2022, you were still doing handyman work for Mr. Fernandez? When you could, from time to time?
I believe so, yes, sir.
You were still fairly injured back then, is that?
Very, yes.
Your work was limited to what you could do?
Correct.
Sir, he had the injury, the fall, the slip and fall on the sandwich sign on July 21st of 2022. Jared Bridegan was killed on February 16th of 2022. And Henry Tenon was paid with 3 checks in March and April. And then everything was deleted, factory reset, all the sorts of things were going on. We also, Mario and Juan Biggerstaff were no longer really talking to each other. There was one message they showed us, which was like, hey, we should meet up sometime, huh? Later. But I don't think the injury is the only reason they weren't talking to each other after the murder of Jared Bridegan. Just all communication stopped. You know, between Mario and Henry, between Mario and Juan Biggerstaff. Besides the handyman work, the tile work they made us watch for so long. Do you remember that? But all Mr. Biggerstaff did was he arrived, walked around the property once. Did he even do any work? I don't think we saw him do work. We saw him arrive and leave. Okay,
There was a time in August of 2022 where you did go to Potomac to try to do some tile work. Do you recall that?
I don't recall the time, but I recall trying to do some tile work in Potomac.
That's, that's what we're talking about. Those pole cameras we saw at Potomac. Potomac is the place where Henry Tenon was a tenant, even though Mario enlisted him as an official tenant after the murder of Jared Bridegan. But he's still living there. That's where Juan Biggerstaff went in August of 2022 to do some tile work. But did he even do tile work? Oh yeah, he was using a machine outside. He was. I remember that. Okay.
Yes. And that's when Mr. Ordway was living there?
Yes.
Is that the blonde-haired young man? And
white guy?
I don't know the names.
Is he blonde and sexy, sir? Did you film him too? Was he in your production, Biggerstaff Productions, or no? So you're telling me that this guy will cry on the stand about his slip and fall and buying cigarettes and caffeine and that he got all, I don't know, hurt, injured, whatever, he's got a TBI, but yet in August, 1 month later, July, August, he's doing tile work. Why the hell are you doing tile work in August? That's the next month. To me, that's sus. That's weird. It doesn't prove, I don't know, you can't like lock him up, but he's already been locked up. I don't know how the state, I don't know what the jury's thinking. Does this prove that Mario got the gun from him? Tell me, do you think it proves it? There's a lot of speculation, but anyway.
Yeah, Caucasian male, yeah.
And you would meet Mr. Fernandez there to sort of go what work you should do and how to do it?
No, I think it was all via phone call and text at the time.
You were texting about tile work,
Correct.
Right? And maybe you just don't remember, but if there was video of you and Mr. Fernandez at Potomac, you don't suggest that couldn't be true. You just don't remember.
Correct. Okay. I think that was more about the drywall when he was
other
present.
Renovation projects going
Correct.
on.
Yes, sir. Yeah.
So, Mr. Biggerstaff, also, well, let me back up. There was evidence that Mr. Fernandez, you were a swinger, you and your wife were swingers, correct?
Correct, we were.
And Mr. Fernandez was not the only person that would sleep with your wife that you would videotape, correct?
Unfortunately, that's correct.
Did you give any of those other people a 10 millimeter firearm?
No, sir.
Did you give any of those people?
Why is that unfortunately correct? Sir, you were swingers. Yes, we were. Okay, so you consented to the lifestyle, you liked the lifestyle, it got you going on. Okay, and you recorded Mario having sex with your wife. Yeah, yes. Okay, no, so he wasn't the only one, right? Unfortunately not. What? Why would that be unfortunately? Unfortunately. All right, that makes no sense.
People a gun?
No, sir.
Okay. Did you give Mr. Fernandez a 10 millimeter firearm in exchange for him sleeping with your wife?
No, sir.
Did you have to bribe him or pay him?
No.
Okay. It was just something that you wanted him to do. It was after he told you him and his wife separated, and he did it, correct?
That's correct.
Okay. Any deal that you were making so that you would give him a murder weapon and he would sleep with your wife?
Absolutely not. No, sir.
And this was something that you asked other men to do as part of the lifestyle you were living, correct?
That's correct.
Did he owe you a favor?
No, sir.
Did you owe him a favor?
No, sir.
Is there any other way I can ask you? Did you give Mr. Fernandez a firearm in exchange for the January 25th, February 15th meeting where he came to your house?
No.
On January 25th, there's cell phone data that suggests that Mr. Fernandez came over. Is your testimony is you don't remember why he came there?
That's correct.
Did you give him a 10 millimeter?
No.
Did you give him any firearm?
No, sir.
So he's been to your house dozens and dozens of times, correct?
All three of my residences, yes, sir.
Could have been talking about, or could have been having a cigarette to clear his mind, right?
That's correct.
Could have been having a cigarette to clear your mind, correct?
Correct.
Could have been just chit-chatting like he had done dozens of times, right?
Yeah, he helped me a lot with VA information to get my VA stuff started.
And if a friend came over and stopped at your house sometime 6 years ago, and there was no real purpose for it, any reason for you to remember that?
No.
And going back to the hidden furniture search, is my understanding is you were searching for hidden furniture so you could hide drugs from your wife.
Correct.
That's the only reason, right?
That's correct.
It wasn't to hide weapons from anybody, correct?
No.
And law enforcement has searched your house?
Yes, that's correct.
Has law enforcement threatened you in this case?
Yes.
How have they treated you?
At times, pretty ugly.
Have they cursed at you?
Yes, sir.
People in the state attorney's office, have they cursed at you?
Yes, sir.
Do you think they treated you fairly?
No, definitely not.
They told you that they wanted you to tell the truth and they would give you immunity, correct?
That's correct.
Did you ever accept?
No.
Did you ever bring a criminal defense lawyer with you?
No.
Did you ever plead the fifth and say, I don't want to talk, I'm just not going to answer your questions?
Never.
So you've gone and you've spoken to them when law enforcement came to your house, right?
Correct.
You've gone and spoke to them at their office per their request, right?
That's correct.
You sat down for an entire deposition where I asked you questions for hours, correct?
That's correct.
And you came here today to testify in this trial.
Yes, sir.
Have you ever told anyone that you gave Mr. Fernandez a 10mm firearm?
No, sir, never.
Oh, you guys, law enforcement was horrible to a man convicted of sex trafficking. Oh no, they were a little bit rude to him. Where's the gun, sir? Melissa Loves True Crime. Happy 35-month Grizzly anniversary. Said just wow, yeah, justice for Jared and his family. We are moving right along towards that goal, in my opinion. Thanks for bringing us this case, Grizzly. Thank you for watching with me.
They've told you they consider you a co-conspirator in this case.
That's correct.
But they just never arrested you?
That's true.
You know from being a police officer, it only takes probable cause to arrest you, right?
That's correct.
And nonetheless, with all the allegations and the threats and the cursing, they've never arrested you.
No, all the junk, nothing, no arrests.
Because you've never given Mr. Fernandez a 10mm firearm, right?
That's correct.
There's no surveillance of you giving him a 10mm firearm, correct?
Say again, I'm sorry.
There's no surveillance of that.
No.
When you were giving this conversation with your son, Juan, was this part of what you believed the harassment was, this wire?
Yes, absolutely.
And you suspected you were being recorded?
Yes.
And you told Juan that you didn't have any firearms?
That's correct.
And then he just kept pushing you and pushing you?
That's correct.
And that was at a time when you were still using drugs, correct?
That's correct.
Did you describe your mind as clear at that point in time?
No.
Okay. And your own son, you believe, is probably recording you and pestering you about a firearm that you never gave to Mr. Fernandez, right?
That's correct.
About a firearm that you hadn't seen since 2016, likely.
That's correct.
And you knew your son was law enforcement at that time, correct?
Yes, that's correct.
Did you want him to get in trouble?
Never.
Okay. When you said, I apologize for getting you wrapped up in this, did you mean the fact that he's there asking you questions and likely wearing a wire?
Yes, at the holiday time, absolutely.
Okay, so you certainly weren't apologizing for getting him wrapped up in some criminal activity you were a part of, right?
No.
Do you have anything to do with the murder of Jared Bridegan?
No, sir.
Objection asked to answer you.
Well,
Wait, overruled. Go ahead.
did you have anything to do with the murder of Jared Bridegan?
No, sir.
In any capacity?
No.
So Mr. Mizrahi asked you, did you said something like the weapons will show up in January. Is something to that effect, is that right?
Correct.
Did they show up in January?
No.
Did law enforcement ever come back and say, give us the 10mm?
No.
How and why was it supposed to show up?
Have you been in possession of any firearms since the day that Magistrate Monty Richardson ordered you to surrender your firearms?
If that's the Middle District of Florida, then that's correct. Not one single firearm since then.
Right. And that was unfair to you because I've shown the jury that it was Magistrate Monty Richardson who signed the order making you surrender your firearm. So if I represent that that's in evidence, that's the person or the judge. Have you been in possession of guns since then?
No, sir.
Ammunition?
No.
Weapons?
No, sir.
I'm just looking here on justice.gov because I've never really deep dived what exactly he was. I should have, actually. Just deep dive what he was actually convicted of. And this says October 28th of 2016, Jacksonville, Florida, United States Attorney A. Lee Bentley III announces the unsealing of an indictment charging John R. Biggerstaff of Jacksonville, Florida, with using a facility of interstate commerce to promote, manage, establish, and carry on a prostitution business. If convicted on all counts, he faces a maximum penalty of 5 years in federal prison. According to the indictment, between June 30th of 2016 and July 31st of 2016, Biggerstaff promoted, managed, established, and carried on a business enterprise that involved prostitution in violation of applicable Florida laws. The indictment alleges that Biggerstaff used a facility of interstate commerce, a cell phone, to commit the offenses. Is that why I said unfortunately? I don't know. You mean Mario only started doing that in 2022, sir? Or when? I don't believe that. I feel like Mario was probably there before. An indictment is merely a formal charge that a defendant has violated one or more federal criminal laws, and every defendant is presumed innocent unless and until proven guilty. He was convicted of that and only got 5 years. Damn. Okay. So retro AI English that so he's a pimp. Wow. A little bit. Oh dear. He was doing all sorts of naughty things beyond swinging. Okay.
Mr. Fernandez helped bring tables and chairs to your son's wedding the day after the homicide?
I don't remember if that was him doing that or not. I have a big blank there on who helped me, but I'm assuming since you say that, the answer is yes.
Okay, so you don't dispute that he helped you?
I wouldn't dispute that, yes, sir.
And that was the kind of stuff you did for each other? He would help you do
Correct.
things? You would help him do things, right?
Correct.
And when Mr. Fernandez told you that day that Mr. Bridegan had been murdered, did Mr. Fernandez seem nervous?
I don't know if it was that day, but when he told me, he didn't seem nervous, no.
Did he make any admissions?
No, sir.
Did you think anything of it?
No.
Did you guys talk about what firearm was used?
No, we didn't. I don't think we ever talked about it again after that day.
After the Potomac tile work.
Yeah, was that the time to wipe the phones? Wipe the phones. We didn't talk about it again after that day. Oh, you mean after the courtesy call as well? Mario organized a courtesy call. Well, he made a courtesy call to say, hey, just a heads up that Henry Tenon's been arrested. And you know him, right? Henry Tenon? The guy that you adjusted the shower head for because he's so tall. Yeah, unfortunately, he was seen on surveillance and he messed up. His DNA is on the tire and everything. They've got this guy. And so just a courtesy call that, the police might be onto you. They're on your ass. They're about to interrogate you and be a little rude, okay?
Project that was, I'm going to represent to you somewhere around August of 2022, okay?
Okay.
Did you and Mr. Fernandez have a falling out over that project?
I think we ended on bad terms because of that project, yes.
And it was because Mr. Fernandez wanted you to work on a tighter schedule than your body was allowing you to do?
That's correct.
And you thought you made that clear, like, I'll do the project, but because of my physical condition, I need to do it on my own timeline.
Right.
And Mr. Fernandez got frustrated.
Yeah, and there you were at 1 o'clock in the morning. That's the other thing. This guy went there in August of 2022, just a couple of weeks after his slip and fall and his TBI and all of this. He went there in the middle of the night to do tile work. I don't know about that. Right?
With you that it wasn't going as fast as he wanted it to.
Correct.
And then Mr. Fernandez took over the tile project.
I don't know what happened to it after that. I didn't go back yet.
Because you guys really haven't kept in touch, right?
That's correct.
So certainly you don't owe anything to Mr. Fernandez right now, right?
No, sir.
He doesn't owe anything to you right now, right?
No, sir.
put Henry Tenon on the stand. Oh man, I'm so upset that Henry Tenon, you know, it's made it very difficult for the state, by the way, because Henry Tenon accepted a plea deal and was going to testify against Mario and Shanna. He was going to spill all the tea, everything that he had told police. But earlier this year, he decided to take that agreement back and decided, nah, I'm going to trial, which I think is a really dumb decision. So, because he was going to get 15 to life. Now he's probably going to get LWOPed because, like, Henry, you're on camera. Okay, your DNA is on the tire at the crime scene. So, what made you change your mind? Who paid what? Who convinced you how? What is going on? Because that would have been powerful. Now it's a bit of an uphill battle for the state. Especially, I would say, with Mario, right? That's interesting to prove the case against him. I think with Shanna, it's going to be easier, in my opinion. I don't know what all they have, but I think it's going to be easier somehow because it makes more sense because it's like her ex-husband that she was frustrated with sharing custody of the children, right? And court battles and all of this. So I feel like Shanna, yeah, it's more likely for a jury to convict her based on whatever evidence they have and just knowing, well, that makes logical sense that she would want Jared gone, right?
Your fall at Circle K, did you hire a personal injury lawyer?
After, did you say?
Yeah, after you fell.
Yes, I did, unfortunately, yes.
And was his name Randy Reap?
Correct.
Okay, so if you had searched for Randy Reap, also on the day you were looking at those thumbtack, whatever you described it on Google, that's because that was your lawyer at the time?
That's correct.
Mr. Mizrahi mentioned things like you don't have a lot of money. You would agree you would search for all sorts of things you couldn't afford, correct?
That's true, yes, sir.
Yachts, right?
Yes.
Villas in France.
Yes.
Flour tortillas.
It was in Italy, sir, wasn't it? Didn't they say villas in Italy? I remember us saying that out loud. France? He wanted to go to Italy. He wanted to be in the actual mafia. He was talking big money, joining the yacht club, you know, trying to be a real gangster. Here's a Daily Mail article quickly, which says from March of 2024, police in Jacksonville, Florida, believe a swinger ex-cop may have played a part in the conspiracy to murder Florida Microsoft executive Jared Bridegan. Juan Biggerstaff, 56, and this was in 2024, so he must be 58 now, right? A disgraced former reserve officer with Jacksonville Sheriff's Office is one of two additional suspects in the 2022 murder of the father of four. Bridegan's ex-wife, Shanna Gardner, 36, her husband, Mario, 35, and his former tenant, Henry Tenon, 62, have been charged in what investigators say was a coordinated murder for hire plot. I'm reading it from my other screen, right? It was February 16th of 2022 when Bridegan was driving home after dropping his twins from his first marriage at their mother's home in Jacksonville Beach. This we know, right? Now it says, Biggerstaff, who was convicted and served time for sex trafficking and drug-related offenses. So it started off as prostitution charges, but it did end up him being convicted of sex trafficking and drug-related offenses, right? And described by police as a long-term associate of Fernandez Saldana, has not yet been charged in the murder. Ooh, they really were looking at him, hey? They really were. They've got pictures of him and everything here in Daily Mail. I actually have a picture of the wife. I'm going to show you quickly. Hold on. Don't snark at her, okay? Don't snark at her. Hold on one second. Be nice. She's been through a lot, clearly. Oh, my. All right, let's have a look at this quickly here. Let's do this one. Okay. So here they show Mr. Biggerstaff, right? Because I'm very curious. I'm sure your mind is also like, what is going on with this guy? What exactly was he convicted of? Okay, so we go down here. There he is with, what did they say? Biggerstaff, seen in exclusive Daily Mail photo, served time for sex trafficking and drug-related offenses. The sex trafficking, and if it involved minors, 5 years is absolutely disgraceful. Like, why would he only get 5 years? Okay, now here is Maria, I think. Hold on. Biggerstaff and his wife Maria, pictured, who is not implicated in the crime, are allegedly swingers. Oh, man. Daily Mail's like, we're going to photograph her. We're going to get her. Ma'am, you're on Grizzly True Crime now. Hi, ma'am. Are you going to testify at all? What do you know? Ooh, tell us about Mario. Tammy Kent said, from moderate riches to rags, it's all about the company you keep. Thank you, Tammy Kent, for your $10 sticker. And Kerry, earlier, for your £5 sticker. Okay, what does it say? Queen bee. Born to be in Spain and May. Is that what it says? Or born in Spain and May. Okay. All right. So, mayhem, and then it says here, but recently released court documents and hundreds of pages of police reports reviewed by Daily Mail showed that investigators identified 5 people as having been likely involved in the conspiracy to kill the father of 4, one of them being Biggerstaff. And while prosecutors and police have declined to comment on the status of the investigation, sources close to the case have told Daily Mail that it remains very much active and open. Court documents filed by investigators in January and February of 2023 show that they asked for continued access to wiretaps and to intercept calls made by the 5 alleged co-conspirators. In those documents, Biggerstaff's name is redacted, but a host of biographical details are given. They went sleuthing. It is noted that the suspect, referred to as Target Number 5, has known Fernandez Saldana for many years. That Fernandez Saldana dated his daughter in high school. Dated? I thought he just gave her a ride home from school. That he had a military background and is a former reserve police officer and convicted felon. Police interviewed Biggerstaff in connection with the murders on Monday, August 22nd of 2022. I want to see that. We want to try to get that. Can we get that? Grizzly cat? August 22nd of 2022. Okay. That did not come with a FOIA file. Did it? It didn't come with a FOIA file. Hold on. We're going to look at something. I'll look at that later. There's some recordings here, but I don't think it's a Biggerstaff one. Got the SAO files here. Now I'm so curious. Oh my word, my brain is going it's ADHD central today. Sorry about that. I'm not diagnosed with that. I just think I have it. Okay, sorry about that. I'm just like, whoo, we need to know all these things. No, I don't see any of his interviews. There are some. It says Elizabeth Smith, Henry Tenon, Devin Hightower, Dane Haid, and then track 1 and 2. So we don't have his yet. Let's see. Oh, I thought so. Shame. I thought Grizzly Cat was sending me a message. But it's Mr. Grizzly sending me a picture of Willow. Now let's focus again. Records from that interview show he served with the Navy for 22 years. He told officers that Saldana dated his daughter in high school and that he had the younger man they became workout partners for years before he left for the Army. So, sir, you had Mario date your daughter at some point and then F your wife? That's a lot. That's a lot. These are the days of our lives. You know what I mean? What is happening? Mario? That's a lot of boundary crossing there. Okay, so I wonder how the daughter feels about that. Do you know what I mean? The daughter that Mario once dated. Mario also effed your mom. That's terrible. Records from that interview note that Biggerstaff served with the Navy for 22 years. He told officers that Saldana dated his daughter and that he and the younger man became workout partners for years before Saldana left for the Army. The court records also note that the suspect, identified as Target 5, admitted that he owned a 10mm caliber handgun, but said he did not know where it is. A 10mm handgun was used to murder Bridegan. Records from Biggerstaff's 2022 interview show that he both admitted to owning such a weapon and claimed not to know of its whereabouts. The report also shows that police believed that he lied to them. Biggerstaff told his interviewers that he and Fernandez Saldana had reconnected when the younger man returned to Jacksonville Beach following his brief stint in the Army. At the time, Biggerstaff was running a handyman business and did some work at the rental property at which Tenon was a tenant. He told officers he had not seen Tenon for a year or two and that he did not really know him. Okay, well, here's a whole thing here. Interesting. We've got all that. It's matching what he's saying on the stand right now. This is from 2024, right? Biggerstaff stated he believes the current resident is in trouble, believes he's going to jail soon. Biggerstaff advised if the current tenant moves out, he would move in the first year for $1,000 a month. The rent would go up every year until rent is on par with the houses in the area. All right. There's a whole lot of documents here. Damn, okay. There's Shanna. There's Mario and Henry Tenon. Biggerstaff's was one of several cell phones subpoenaed by investigators, and court documents reflect the investigators' assertion that cell phone records connect the conspirators. When police downloaded the contents of the phone, which Biggerstaff surrendered to them, they found that all text messages between him and Fernandez Saldana had been erased up until May of 2022. But according to court documents, toll records show a significant increase in contact between suspects immediately before and after the murder compared to the otherwise sporadic contact between them in the 6 weeks before the murder. Do you remember that chart that they showed us? That was helpful. I'm reading this to you now, by the way, in the middle of this cross because it will give us some context as to what he's answering. So it said, they note that the suspect had frequent and in-person contact with Fernandez Saldana on the day before, the day of, and the day after the homicide. When interviewed by police officers, Biggerstaff was specifically asked about his communications with Fernandez Saldana on the days before, the day of, and after. When asked what he and Fernandez Saldana spoke about on the night of the murder, Biggerstaff made a shock claim. According to the report, Biggerstaff stated the conversation was of a personal nature. Biggerstaff advised that he and his wife are swingers. His claims appear to be backed up by the fact that intimate images of Fernandez with Mr. Biggerstaff's wife, Maria, who is not implicated in the murder, 53 at the time, were recovered from Biggerstaff's home computer. Biggerstaff told police that Fernandez Saldana was a swinger, but that Gardner was not. I don't want to show the children's faces here. Sorry. I tried to blur out the kids' faces, and right now they're showing there. So it says Bridegan was embroiled in a bitter and protracted legal battle with Gardner over custody of their now 13-year-old twins when he was murdered. So this article is from 2024, right? Shame, they'd be like 15 now already. According to the agreement, at the time of his death, the children stayed with their mother and father in alternating weeks. Okay, the rest here we know. The rest we know, it said Biggerstaff did not respond to Daily Mail's approaches for comment. Police records show that he continued to advise he has no knowledge of the murder. All right, so now we go back to the cross-examination. Let's quickly see Monica B. Thank you so much for your £10 sticker. And Kerry said Biggerstaff's TBI after JB's murder convenient. I mean, it may have happened, right? Thanks for your £2 sticker. I'm sure it would have happened. But nonetheless, it is convenient timing, and it's also, maybe I shouldn't be so sure, because there he was doing tile work at 1 o'clock in the morning in August, just a few weeks later. That's so weird. Okay, sir, keep telling us lies. Or who's it now? The defense. Okay, keep telling the defense what you got.
Tortilla recipes.
Correct.
How to make the best chocolate chip cookies.
Correct. Correct.
Lawyer at the time.
That's
there
correct.
You
Mr. Mizrahi mentioned things like you don't have a lot of money. You would agree you would search for all sorts of things you couldn't afford, correct?
That's true. Yes, sir.
Yachts, right?
Yes.
Villas in France.
Yes.
Flour tortilla recipes.
Correct.
How to make the best chocolate chip cookies.
Correct.
Military bases in Charleston.
Yes.
You also looked at a 9mm firearm at one point, right?
Correct.
Would it be fair to say you probably have looked at thousands of things on the internet?
Yes.
Because when you were injured, you weren't very mobile, were you?
I haven't been very mobile for 6 years. That's correct.
And a lot of what you do is on your phone.
That's true.
Any rhyme or reason as to sometimes what you're looking at or why you're looking at it?
No. What I'm watching on TV usually generates my searches.
And if you had looked for a 10mm.
Or if you're smoking them cigarettes, maybe you get the munchies, and then you're looking at, homemade chocolate chip cookies and homemade flour tortillas and yachts. Villas in France or Italy. Okay.
Millimeter at one point in time. Would you agree you wouldn't have had to do that if you still owned one?
That's a true statement. Yeah.
You could have gone to wherever it was and looked at it if you still owned one, right?
Right.
But you didn't do that because you didn't own one, right?
Correct.
And in those particular searches, you would acknowledge that that you never searched anything to do with firearms that had anything to do with Mr. Fernandez, correct?
That's correct.
May I have one moment, Your Honor?
Yes.
We have no further questions. Thank you.
You're right.
Sure.
Mr. Biggerstaff, you mentioned that the state of Florida offered you immunity. Remember that line of questioning?
Yeah, yes, sir.
And who was that, me?
You, correct. You and Mr. Stifler, yeah.
We're both assistant state attorneys, right?
That's as far as I know, yes, sir.
Well, your conviction, was that in state court or was that in federal court?
Federal court.
Did you, in the course of this investigation, ever sit down with a federal prosecutor?
Are you asking? Okay.
You want to approach or what? What's the problem now? Oh, my word. Mario, what did you do on February 15th of 2022? We know that you banging Mrs. Biggerstaff because it was actually captured on video and audio. Oh no, but what else? Did you take a gun home after that or what? Like the night before the murder? And then was the story going to be, well, we're just going to say it was from swinging. I was just there to do this one naughty thing. Didn't take anything with me when I left. Sure about that? Did Shanna know about that? I do wonder, did Shanna Gardner know about that? About his lifestyle? Or just the exotic massages that he got at the house? Allegedly, rumored so.
You may proceed.
So did you ever meet with the federal prosecutor with regard to this case at all?
I don't know. There was at least one probable federal somebody in my home that didn't provide credentials. So I don't know who it was.
That was an ATF agent, perhaps?
I don't know.
Was it Jim McIntyre? Because he also doesn't provide credentials. You know, it just appears out of nowhere in the Nicholas Casota's trial. You know, so what was it, Jim McIntyre, an agent, a secret agent man who appeared and just started asking questions, and you just answered all of them? Oh.
They were with an ATF agent, yes.
When the talk of immunity came up, it was just me and Ms. Stifler.
No.
Who else was there?
Jack's Beach homicide, police detectives, an agent from ATF, and some female, I don't know who she was.
It's your testimony that an agent from ATF was present when we discussed immunity with you?
Correct.
Okay. That's all the questions I have here.
Anything further? No. May the witness be excused. All right, Mr. Biggerstaff, you're excused.
Thank you, ma'am.
Thank you.
Thank you.
Take your time.
Okay. Did that prove anything? Did we get anywhere? What do you think the jury's thinking? How will the jury LWOP this man? Find him guilty, I mean.
The next witness.
How will they do that? Unless the checks and all those other coincidences circumstantially come together. Without Henry Tenon testifying, I think it's a difficult case. By the way, I told you that Mr. Grizzly had sent me a picture of Willow, and I'm going to show it to you now. Look at this, look at this, look at her. It's way too much. She's too cute. I always tell her, Willow, it's too much. Okay? You need to tone this down. It's way too cute. All right? That's her on the couch. Cute. Right now. So there, you see the cats. At least one of them. Okay. If you want to see more pictures of the cats, behind the scenes, live streams from my living room, behind the scenes stories, what I got up to this weekend, all that kind of stuff, you can either become a member on YouTube or you can join Patreon. Those are the places for the behind the scenes stuff. Okay. Are we ready to, I think they're going to, I just saw this recess thing. I think I want to take a break now, and then we'll see who's next.
I'd like to take a break, or is the next witness short?
Okay.
Members of the jury, we're going to take 15 minutes, okay? And then we'll come back for the next witness.
15 Minuten.
Can I see the lawyers at sidebar for scheduling?
Scheduling. When are you resting, State? What you got? My goodness, stop that, stop that. Okay, we go forward. There's something happening here. What? Here. Mario, what are they saying?
Media outlets.
Okay. Dear Mrs. Biggerstaff. It's me again, Mario. Remember me, Maria? Dear Maria, it's me, Mario. Today at the trial, they brought up our
deadline that if you all want
February 15th of 2022 interaction.
Want to object to that procedure, okay? Because I don't want that situation that happened before I thought there were no objections filed and then somebody came in there objecting. So I'm going to set aside the deadline so that you all can object if you need to. But based on her case, I don't know how many media outlets would be interested, and it's limited space back there. So I'm also amending the order to say that I need you all to let me know that you want to participate in the individual voir dire, because I don't have enough room back there, and if I don't have enough room, then I need to find another place to do it.
But we want to participate.
So I'm just giving you all a heads up. So if you want to, when the order gets filed today, it's going to be filed today. If you want to transfer it to your counsel, you can, so that they know that there is a deadline for them to object. There's a notice requirement that y'all want to participate or not, okay? So I can make arrangements to have, the only thing that I'm excluding are the videotapes, the videoing of the jurors. So it would be the same procedure, just no cameras back there. So because they're disclosing sensitive information related to their finances and family and medical situations. Okay. You're welcome.
Okay, so we're still on the break here. And we teleport through it. Come back for a moment here. Let's see.
Thank you. All right, both sides ready?
State's ready.
Okay, Mr. Holman.
Bring the jury.
All right, welcome back, members of the jury. Everyone may be seated. The state calls its next witness.
State calls Juan Biggerstaff.
Juan Biggerstaff, please.
Oh my word. Now we're going to see Biggerstaff Jr., Juan Biggerstaff, who was a law enforcement officer in Texas. And then at some point, how did they phrase it? It was phrased so politely from that one guy that looked like James Bond, that witness. Remember him? What happened to Juan? Let me just quickly see. He was described as a police officer, mentioned as working in narcotics in Arlington, Texas, and previously a SWAT sniper. He cooperated with the Jacksonville investigators by agreeing to wear a wire while speaking with his father about the missing 10mm gun. And I don't know, at some point he got, I don't know how it was phrased, like disconnected from service, like he was let go, is what it sounded like. What did he do? What was he investigated for? Why did he lose his job? Is that what happened? Okay. I got to go do my 20
Good
squats.
morning, Mr. Biggerstaff. Walk all the way forward, please. Please raise your right hand to be sworn in.
Sir, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
All right, sir. Head to your right. Watch your step. You may proceed.
May it please the court. Please state your name for the record.
Juan Biggerstaff.
What do you do for a living, sir?
I'm an independent contractor selling roofs.
How long have you been so employed?
2 months.
And what did you do? Yeah, we do some of these questions to make sure that you project your voice and things. Previous to being a contractor with roofs, what else did you do?
I was in law enforcement.
How long were you in law enforcement?
About 8.5 years.
When did you resign your law enforcement position?
March of this year.
March of 2026.
Yes.
Were you under investigation at the time you resigned?
Yes.
I want to turn your attention to February of 2022. Were you employed in law enforcement in February of 2022?
Yes.
And were you living in Texas?
Yes.
Is that a suburb outside of Dallas?
No, it was in Dallas.
You were in Dallas?
Yes.
What police department did you work for?
Irving.
Which is a suburb of Dallas?
Yes.
Okay. So you're living in Dallas but working in Irving?
Correct.
Is that where the stadium used to be, the Dallas Cowboy Stadium?
That's correct.
So do you know a person named Mario Fernandez?
Yes.
How do you know him?
He was a family friend of ours.
Do you see him here in court?
Yes.
Could you say where he's seated and what he's wearing?
He's seated to my right. He's wearing a blue suit.
Is he the person closest to the jury or furthest from the jury?
Furthest.
May the record reflect the witnesses identified the defendant.
Yes.
Who is John Biggerstaff?
It's my father.
I want to turn your attention to when your father got in trouble with the federal government. Do you remember that?
Yes.
Were you working in law enforcement when that happened?
No.
Well, how short after when he got in trouble did you become employed with law enforcement?
I became employed with them September of 2017, so about a year.
Okay. And do you know where that was in relation to his conviction as opposed to when he was indicted?
No.
Around the same time, maybe shortly thereafter?
Yes.
Okay. At that time, obviously, you were not a prohibited person?
Correct.
And did you help your father in the preparing of the federal affidavit relinquishing his firearms?
Yes.
Tell the jury how you went about doing that.
We collected the firearms that were in the house at the time. Just went by serial number and make and model of all the firearms, and then I transported them from the house day of or day after to my sister's apartment.
The jury has already seen this, but just for consistency in the evidence, showing you what's been entered into evidence of State's Exhibit 190. Is this handwritten affidavit that you and your father filled out?
Yes.
Whose handwriting is that?
Mine.
And that's lists 20 firearms or items that he was surrendering?
Correct.
Describe for the jury how those firearms were transported.
I took them in my vehicle, which was a Ford Focus at the time, and they were in various bags and gun cases.
And what did you do with them?
I dropped them off at my sister's house or apartment.
What is your sister's name?
Stephanie Atkinson.
And that was her name at the time? 2016?
Ooh. Yes, I believe she was married in 2016.
And how long did the firearms remain at your sister's house?
Several months. They purchased a house, and at that time is when I went and picked them back up.
Bless you.
So this is, and just for the jury's orientation, this is in 2016?
2016, early 2017.
Before your father was convicted of the crime.
I don't recall the actual conviction date, but I think so, yes.
If you don't know, that's fine, but if you remember, it was while he was on pretrial release that he had to collect his gun.
Correct, yes, that's right.
And then he was convicted later in 2017.
Right.
Okay. So after the guns were in your sister's, what happened?
So when she purchased the house, she no longer wanted the firearms in their house. I went and picked them up, and I kept them with me, separated several for myself, kept the rest in my vehicle until I left for Texas later that year.
Which guns did you keep for yourself?
There was a Smith & Wesson 9mm, a Glock 27, it's a 40 caliber, a 243 bolt action rifle, and a Benelli shotgun.
Was one of the guns that you did not keep a Glock 40 10mm firearm?
Yes.
What happened to that firearm?
That was left at Fred Barton's residence.
Explain to the jury how that occurred.
Fred Barton was a friend of my parents, and they had kind of like a gentleman's agreement to leave the guns at Fred's house when I was leaving for Texas.
I believe that. I believe Fred Barton over these two. How about you guys? Beehive85, thanks for the 10-pound sticker. I don't believe him. Oh, that gun? Yeah, it was at Fred's house. Mm-hmm.
When would that have been in 2017?
Yes.
Describe for the jury who went and how the guns were transported to Mr. Barton.
So myself and my wife were in one vehicle. My parents were in my dad's truck at the time. I transported the guns in the same cases and bags that they were in, walked them inside of Fred Barton's house, and I want to say I left them in one of his closets, and then we continued west.
Are you familiar with a gun cabinet that your father owned?
Yes.
Kind of a cheap one?
I don't remember, yeah.
Do you remember if it later on kept gardening tools?
I do not know that.
Did you transport these guns in a gun cabinet?
No.
So they were in just bags?
Yes.
And you put them, you believe, inside of a closet?
Yes.
Did Mr. Barton inventory them in any way? Did he look at them?
Not that I recall, no.
And your father was with you when this happened?
Yes.
What happened after you dropped the firearms off at Fred Barton's house?
I drove to Texas.
When you dropped off the firearms at Fred Barton's house, did you inventory that there were 16 firearms that were dropped off?
No.
Do you know if that 10mm was dropped off?
Yes.
So you do know that for sure?
Yes.
And you kept the 4 that you've already indicated?
Correct.
I want to fast forward now to December of 2022. Was there an occasion where you became in your law enforcement duties, wore a recording device to go speak to your father?
Yes.
And was that done pursuant to law enforcement's request?
Yes.
Did that make you feel uncomfortable?
Yes.
Why did you do it?
That's a good question. I had a order from my department that I had to follow just standard operating procedures to be cooperative in criminal investigations.
So pursuant to your law enforcement career, they're like, if they ask you to do this, you should do it.
Yeah.
In talking to your dad, I'm going to go through some of the things that y'all talked about. But before that, did he know that you were being recorded?
I did not tell him no.
That would have been a violation of wearing the recording device.
Right.
It was supposed to be surreptitious or undercover.
Right.
And you did you work as an undercover police officer back in Texas?
Yes.
So you were familiar with that policy?
Yes.
Can't tell people that you're recording them.
Right.
So did you begin the conversation with telling your dad or asking your father the question that should you be preparing your mother for something that's going to happen with regard to this 10 million?
Yes.
And what did your father say?
I believe he responded no.
Did your father indicate anything about the 10 millimeter?
In regards to 10 millimeter, no. Just that the guns would show up January 1st.
Did you remember if your father told you that the authorities only care if the 10 millimeter matches the 10 millimeter involved in the murder that they were investigating?
Yes.
Do you remember your father telling you that he had the 10 millimeter the entire time?
Sorry, I do not recall.
Yeah, you had an opportunity to listen to The Wire before. Would you like to listen to that again?
No, it's fine. If that's what is transcribed, then yes, that's what would happen.
But we want to hear it.
Do you
He's
remember
looking
your
for a
father
tissue,
saying
guys.
They knocked the 10 millimeter?
Ma'am, guys, anybody in the court? He's looking for tissues. He's busy rubbing his nostrils on his sleeve.
Was here.
Yes.
Do you remember your father telling you that it was here and it will appear later?
No,
Yes.
I'm going
Not
to
yet.
object.
Grounds.
Hearsay. He can't testify to what his father is telling him. He can testify to what he
Wait.
tells his father.
What's your response?
It's impeachment.
I'll overrule the objection.
You remember your father telling you that the 10 millimeter firearm was here, meaning with him, and would appear but just cannot yet.
Yes.
Do you remember your father telling you that he did not know where it was at the current time?
Yes.
Do you remember your father telling you that it would appear after January 1st?
Yes.
You remember your father telling you that he did not know who had the gun, but they would appear after January 1st?
Yes.
You remember your father telling you that he told ATF that Steve from the Georgia Hunting Club had the gun?
Yes.
Do you remember telling your father telling you that he felt bad to drag you into this?
Yes.
Do you remember your father promising that when that 10 millimeter reappeared that he would turn it in?
Yes.
Mr. Juan Biggerstaff, I'm just going to say your first name just to clarify from your father. You kept 4 of the firearms. How come you didn't sell the other 16?
Never crossed my mind.
Could you have?
Yes.
Were those 16 other firearms, were they valuable?
Yeah.
What about the ammunition?
As far as being valuable?
Well, no. Just what happened to it?
I don't know.
As you sit here today, do you know what happened to that 10 millimeter Glock?
No.
Did you ever go back to Fred Barton's home and take the guns out of his closet?
No.
Do you have any idea if your father did?
No.
I'm going to fast forward to June of 2023. Were you the victim of an auto theft / burglary?
Yes.
Tell the jury about it.
I had a early 2000s GMC Yukon that was a pool car, meaning it was one of the worst cars to have in the department. I had it parked outside of my residence, and I had just gotten out of training for the day. I left my belongings in the car, getting ready to go on vacation with my wife. Came back from like a 3 or 4 day vacation, saw the car was gone, immediately contacted Dallas Police Department. And while I was on the phone with Dallas Police, I noticed that my car was stopped at the end of the street, abandoned, and several of my bags were stolen out of the car.
So the car was taken from your home, and how far away was the end of the street?
Maybe a quarter mile.
And you were able to see that, I guess, while you were on the phone?
Yes.
And what was...
That sounds convenient. What were you being investigated for before you resigned, sir? And you want to make like Fred Barton, who we saw testify first this morning, by the way, when the jury was present. He seemed way more trustworthy than these two. You want to say that Fred Barton had it, and you have no idea what happened after that? Between Juan Biggerstaff and his dad, they sure are trying to build, like, they're trying to get a lot of distance, you know, obviously between them and the gun, but just like, okay, we'll just say we dropped it off at Fred Barton's house. We'll just leave it at that. I don't know about that. Doesn't come across as credible at all.
My department issued Glock 31, which is a 357 SIG, and my Glock 27, which is a 40 caliber, and ammo and other police paraphernalia.
When you provided the serial numbers for those firearms, did you make an error?
Yes.
Tell the jury.
So when I was waiting for Dallas Police, I referred back to that inventory and just unintentionally copied down the incorrect serial number, which happened to be for the Glock 10 millimeter, not the Glock 27.
And I understand those are on lines 7 and 8?
I believe so, yes.
I'll approach just to make sure. States Exhibit 190.
Cuff
That's
him.
correct. It's the Glock 27 is line 6,
And his
then
dad.
the Glock 40 10 millimeter is line 7.
Yeah, correct, yes.
Now, you would agree that this States 190 is lined,
Yes,
and you filled it out.
yes.
When you reported the 2 firearms that were stolen, you were aware, or were you aware, I guess is the better question, that the 10 millimeter firearm was important to police?
Yes,
Because you had actually worn an undercover recording device to talk to your father about that 10 millimeter.
right,
And you were, based on your training experience, are stolen guns and reporting them accurately important.
yes, very.
You would agree that you did not report it accurately.
Correct.
And the serial number that you put down was to a firearm that you knew police were very interested in locating.
Yes,
So you don't know where that gun is. Magically, your car got burgled. You saw it go, whatever, a quarter of a mile down the road. Okay. Cool. You're saying everything was left at Fred Barton's house. You had some of the guns. And then when you actually documented the weapons, you just, with all this training and experience, just wrote down the wrong serial number for the very gun that the police were looking for in the murder of Jared Bridegan. Whoops, out of all those that I wrote down, just that one had the wrong serial number. Like, okay. Sir, we're looking at you with a big side eye, right? Right.
You know why your father would lie to you in that recorded?
Objection, Your Honor, second.
I agree. It's.
Rephrase that, please.
Do you know of any reason why he would lie?
No.
In that recorded conversation with your father, did he also tell you things about immunity?
Yes.
What did he say?
That he didn't believe in the immunity that was offered, and he thought it was BS.
That's all the questions I have.
Cross.
Good afternoon, sir.
Hello.
Good to see you again. Congratulations.
Thank you.
Try to get you out of here pretty quickly.
Appreciate it.
Now, Mr. Biggerstaff, I'm going to state asked you.
Hello. Okay, did you hear that? Hello. Mr. Biggerstaff, hello. Okay, so we gather the Biggerstaffs are friends with the defense. Cool. Good to know.
Most of the questions that I'm going to cross-examine you on, so I'm going to just try to be brief with you. In 2016, when you wrote that inventory, that was all the firearms and any other weapons you understood your father to have. Is that correct?
Yes.
So 2016.
Yeah.
And you actually took possession of all those firearms in like a duffel bag and in gun cases.
Right.
Was not in a cabinet of any time when you delivered it.
No.
Now, I know the state asked you, just trying to get you to project your voice, asking you questions about how long you've been in Jacksonville since you left Texas, and I understood that was since March.
Correct. No, I've been back since April of this year.
You resigned your position with the law enforcement office out in Texas.
Yes.
You were not fired.
Correct.
And to be a law enforcement officer, you took an oath?
Yes.
To uphold the laws and the Constitution?
Yes.
Okay. And I believe Mr. Mizrahi asked you, I'm fast forwarding a little bit to when you wore a wire, the reason you cooperated was because that was policy of your own department.
Correct.
So it would be in violation of that policy to lie to other law enforcement.
Correct.
I also don't know. I thought, did I miss something? Or why did he congratulate him? Hello. Hello, Juan Biggerstaff, and congratulations on what? His business, it's not roofing. Was it roofing or roots? I can't even remember now. For being an independent contractor. Is that it? Congratulations for what? Coming back to Florida? I don't know. Congratulations, yeah, maybe he's a new daddy. Oh dear. Congratulations for what exactly? If we're confused, the jury's confused, the jury will also be like, oh, the defense, they buddy with the Biggerstaffs. I don't know if that helps. Okay.
No dispute that at some point your dad owned a Glock 40 Gen 4 10 millimeter.
Right.
I think a lot of people call it like a bear defense gun.
Sure.
But you're familiar with it. You've seen it before.
Yes.
And in 2016, that was one of the firearms that you put on that inventory list.
Yes.
I believe it was number 7 on that list that Mr. Mizrahi just showed you.
Yes.
Okay. To your knowledge, is that the last time your father saw that firearm is when you sat and completed that inventory?
To my knowledge, yes.
Have you ever seen him in possession of it again?
No.
One of the firearms you kept was the Glock 27 that was stolen out of your vehicle?
Correct.
And that was item number 6 on that list, correct?
Yes.
Okay. And the jury's seen that list and they're going to take it back in evidence, but that was just handwritten right above the Glock 10.
Yes.
Was he hoping that they'd be like confused, the two Glocks would be confused and be like, oh no, one got stolen. Maybe the other one did too. I don't know. All of this is quite shady though.
And the state asked you about when you retrieved those firearms from your sister and then took them to Fred Barton's house, your father was with you. Or excuse me, you retrieved them from your sister, put them in your car, correct?
Yes.
Kept them in your car for a number of months?
Yes.
Okay. Any idea whether or not your father had any access to that car?
He did not.
Okay. And then on your way out of town, who helped you move to Texas?
My now wife and my parents.
Okay. Like driving a U-Haul truck and
We drove my vehicle, Ford Focus, and my dad's pickup truck.
Okay. And if I understood your testimony, literally on the way out of town is when you dropped those remaining firearms off at Fred Barton's house.
Correct.
You walked them inside and put them in a closet.
Yes.
Okay. Did your father go with you?
Inside the house?
Yeah, did he go in the closet with you?
If I remember correctly, he was inside of the house already. But
Did you see him have access to those firearms?
no.
Okay. Certainly it'd be a violation of his pretrial release or his supervised release if he had been convicted at that point.
Correct.
You then drive to Texas. You become a law enforcement officer out there. I believe it was in 2018 is when you actually got into patrol. Is that accurate?
Correct.
Okay. And at that point, you're just a police officer in Texas. You would come back and forth from time to time to visit family?
Yes.
Okay. Any time coming back and forth that you ever saw those firearms?
No.
Okay. Ever see your father with a firearm?
No.
You guys ever go shooting or anything during that time period?
No.
That would also be a violation of, at that point, his supervised release.
Correct.
And you, as a law enforcement officer, during this time period, would somewhat be required to report him if you saw him in possession of a firearm. If you saw him breaking the law while you're a police officer, you'd be required to report him under those policies that you mentioned earlier.
Yes.
Safe to assume you never reported him because you never saw him in possession of a firearm.
Correct.
In February of 2016, did you come back to Jacksonville?
Yes.
Why?
I was getting married.
Okay. Do you recall when you actually got back in town?
It was the morning or afternoon of the 16th.
Okay. Did you come to learn that that was the same date as the homicide of Mr. Bridegan?
Yes.
When you came back in town on February 16th, did anybody give you a 10 millimeter?
No.
Did you see your father on February 16th?
Yes.
Did you see him approximately around 8 or 9 o'clock that evening?
Correct.
With your mother?
Yes.
And your mother doesn't drive at night, does she?
No.
Okay, so your father had to drive your mother to your sister's house that evening.
Correct.
And you saw him that evening?
Yes.
Didn't appear nervous or anything out of the ordinary?
No.
No indication anything was wrong with him?
No.
Did you see Mr. Fernandez in the days after February 16th?
Yes.
Okay. Tell the jury about how you saw him.
Mario had offered to help, or my dad asked him to help pick up some chairs and tables to set up for a rehearsal dinner that we had.
And do you recall what date that was?
That was the 17th, I believe.
Day after you got back in town?
Yes.
Okay. Did he appear nervous or looking over his shoulder?
No, I only saw him for maybe 5-10 minutes, but no, he did not.
Otherwise, he just helped set up like you understood he had agreed to do?
Right.
How long did you stay in town?
Full week, I believe.
Did your father or anyone else give you a 10 millimeter to take back to Texas with?
No.
Okay. And then at the end of the week, you just went back to Texas?
Correct.
Continued being a law enforcement officer?
Correct.
Yes, Colleen Singer said that's another convenience. And another coincidence. A lot of coincidences with these people. Shady, shady. Enough to prove that Mario is guilty? I don't know. We'll have to see what the jury decides. But I do think the checks are the worst, most incriminating, most damning evidence. Those freaking handwritten checks. Who does that? Especially if Shanna Gardner and her family are the ones with the money. See, they were smart to be like, let him write the checks. Let him pay Henry Tenon. Because why would he do that? Why would he write 3 checks to Henry Tenon?
Later that year, did you come back to Jacksonville?
Yes.
In 2022?
Yes.
And at that point, had you been interviewed by the ATF?
Yes.
They interviewed you in Texas?
Yes.
Were you truthful with them?
Yes.
Did they ask you about the 10 millimeter?
Yes.
Did you tell them the same thing you've told the jury this afternoon, that you did not see the 10 millimeter?
Correct.
And did you also get interviewed by the ATF here in Jacksonville?
Yes.
Was your story the same? You
Yes.
had not seen it?
Yep.
And again, that's part of the policies in which you have to follow as a law enforcement officer, is your truthfulness with other law enforcement agencies.
Correct.
And as Mr. Mizrahi mentioned, in December of 2022, you agreed to wear actually 2 recording devices.
Yes.
One in your pocket and then one that was like a cell phone.
Right.
Okay. And these were things you were familiar with from your own law enforcement experience.
Yes.
Okay. My understanding is they maintained observation of you to make sure that you couldn't call your father to say you were on the way over there in order to tip him off that you were wearing a wire.
I don't know that to be true.
Okay. Did you tip off your father you were wearing a wire?
No.
Okay. Didn't write any notes or anything to say, hey, Dad, I'm wearing a wire, don't say anything?
No.
Okay. Did he mention Mario Fernandez?
Did he have a code word? Did you do eyes of like, could have?
Fernandez at all during your discussion with him?
Not that I recall, no.
Your dad told you a whole bunch of different things during that conversation.
Yes.
Okay. Some inconsistencies as far as so-and-so has the firearm, or I don't know where it is, or it's going to show back up.
Right.
Okay. In essence, 3 different stories about this firearm.
Yes.
Now, your father had, my understanding, a traumatic brain injury in 2020, somewhere around that time period?
Yes, yeah.
Okay. Did you notice that he had some difficulties after that accident?
Yes.
Did you come to understand your father also had some substance abuse issues?
Yes.
Okay. That combined with the brain issues, you noticed a big difference in your father?
Yeah.
Kind of his cognitive abilities?
Yes.
And his physical abilities?
Yes.
Thank you to Renee and Barb for spoiling me with Mama Bear coffees.
After you finished, we'll just call it that recording session in December, did you turn over that recording to law enforcement?
Yes.
Did you get an opportunity to listen to it before you gave it to them?
No.
Did you get an opportunity to listen to it when you were with them?
No.
You just went back to Texas and continue on your law enforcement?
Yeah.
State asked you in June when you were back in Texas, your vehicle got stolen. This was your undercover vehicle?
Correct.
And the Glock 27 that was stolen, was that the one that was given to you by your father?
Yes.
With the serial number that was listed on number 6 on that handwritten inventory?
Yes.
And as you told Mr. Mizrahi, you just simply put the wrong serial number, correct?
Correct.
Did you refer to the inventory for that number?
Yes.
Okay. And you did not put it was a Glock 10 millimeter that was stolen. You would agree with that?
Correct.
And at the time, you were living in Dallas.
Yes.
So you reported your stolen vehicle to the appropriate agency because you were in Dallas.
Yes.
But you also notified your agency that your vehicle was stolen.
Yes.
At some point, you came back to Jacksonville and you were interviewed or met with the state attorney's office again. Is that correct?
Yes.
And during that subsequent meeting, it had become clear to you that law enforcement did not believe your position on the 10 millimeter, correct?
Correct.
Someone had actually filed some sort of a complaint with your agency that they didn't believe you were being truthful.
Correct.
Ultimately, they put you on administrative duties as a result.
Yes.
No one actually found that you were being untruthful, but because of that complaint, they placed you on administrative duties.
Yes.
You understood that the people sitting at this table, Ms. Stifler and Mr. Mizrahi, didn't believe you.
Correct.
They said as much.
Yes.
And during one of those meetings, they actually offered you immunity in the event you wanted to tell a different story.
Yes.
Did you accept that immunity?
No.
And you know what immunity is from your law enforcement experience, correct?
Yes.
And whether or not that included federal authorities sitting in the room or otherwise, you were interviewed by ATF multiple times.
Yes.
And by state law enforcement.
Yes.
Do you stand by every statement you've given to them?
Yes, I do.
You told the truth every time?
Yes.
Certainly don't want to have a negative impact on your new family by being untruthful with them.
Correct.
Mr. Biggerstaff, did you have any involvement in the homicide of Jared Bridegan?
No.
Do you have any reason, do you have any evidence that Mr. Fernandez had any involvement in that homicide?
No, I do not.
Do you have any involvement with disposing of a firearm?
No.
You consulted with an attorney out in Texas during your administrative duty time period?
Yes, employee attorney. Yeah.
It was an employment lawyer, correct?
Yeah.
Do you have any other information that would actually implicate Mario Fernandez in this homicide?
No.
Have just a moment, Your Honor.
Yes.
I said congratulations at the beginning of your testimony. It's because you had a baby last week.
Yes, sir.
I noticed you had the armband on.
Yeah.
Thanks for clarifying, defense, of how much you were buttering up your favorite witness today. Okay.
Your Honor, I don't have any further questions.
Okay. Thank you. Redirect.
Yes.
But this is a good question. Why would Daddy's guns be on the same list as his own? Why? It's weird. There's so much weird here. Is weird enough to convict Mario or have these two arrested? No. But it's weird. Something was going on. They just haven't been able to prove it.
Mr. Juan Biggerstaff, do you love your father, John Biggerstaff?
Yes.
Do you love your mother?
Yes.
That's all the questions I have, Your Honor.
May the witness be excused.
You may.
Yes, Your Honor.
Thank you. All right, members of the jury, I appreciate your...
I know why that was the redirect, but that was lame. That was a terrible redirect. It could have gone so many other ways. Do you love your parents? Yes. Okay. What? That's it? That's all they got to ask? Ask that question. Why would Daddy's guns be on the same list as his own? Why would someone steal your undercover vehicle and only the gun inside and nothing else? Okay.
Patience in pushing into the lunch hour. He will be the last witness before the lunch break. Please leave your notepads on your chair. Follow the communication over the lunch recess, and I'll see you we'll call it 1:30. We'll come back, okay?
Thank you, Obby's House, for supporting the mods with a Big Bear coffee. There was a Big Bear coffee. Mine are Mama Bear coffees. Okay, so ready to close your lunch boxes, huh? Teleport over the lunch break. You ready? You good? Okay, here we go. And we're off. Damn. And we're coming back. Excuse me, what? Ma'am. Okay, here we go. Some high fives with the defense attorney. Yeah. Just that one 10mm they were so interested in. That's what I will remember. Oh, you wrote that serial number down all wrong. No matter what, John Biggerstaff and his son, in my opinion, are lying about their knowledge of that 10mm. There's so many stories. I mean, John Biggerstaff himself is like, I don't know where it is. Actually, it's going to reappear on January 1st. Actually, how many reasons? He came up with so many. And then his son is also like, it was probably at Fred Barton's house. Like, between the two of them, they came up with a lot of stories about that specific gun. Why is that gun important? Because it was the murder weapon that the police have not been able to find. Did Juan take it back with him to Texas? Did it then get stolen? Did someone lose it? I don't know. Henry Tenon said it got scrapped along with the scrap vehicle. So there's a lot of stories around that gun. It's not a case of, oh, we don't know where that murder weapon is. It's just everyone in this case that's been looked into has a different story about it. So, yeah, that's very weird. Who we got? Okay. So, are we to think? Did they prove it? Nothing concrete, okay? But based on everything that we saw, my opinion is, yes, that Mario got the gun from Mr. John Biggerstaff. And yes, that his son got rid of it. That is my opinion. The jury will have to make up their mind. It's just those two are just saying all sorts of stories that don't add up. And both of them with law enforcement careers that no longer exist. They were being looked into. Well, the one, John Biggerstaff was convicted of sex trafficking and drug-related charges. So, okay, as high up as he may have been in his Navy career and all that. Yeah, that fell apart. And then guess what his sons did too? They were looking into his son, and then it's like, whoa, I'll resign. Administrative leave. Now I'm going to resign instead. Now I'm going to start an independent contracting business and move out of state from Texas. Sure, go to Florida where your daddy is. Weird stuff, man. I think if they could have proven anything, they would have arrested both of them, right? In this case, as maybe co-conspirators, if they had any proof. They don't have it. Because a lot of things were factory reset, deleted, communication stopped, all that kind of stuff, right? But yeah, there's nothing concrete there. These are just opinions based on what they showed us. What's next, Dave? What you got? Because this is not a slam dunk case by any means.
Swear or affirm the testimony.
How was lunch today? Okay, good. All right. So we are ready to continue with the evidence. State of Florida, call your next witness.
Chris Johns.
Chris Johns. Good afternoon, Detective.
I was going to say, wait, we've seen him before. Okay.
Will you please raise your right hand
Chris
and be sworn in?
Johns.
Detective, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
Tell us about the checks. So if you're only starting to watch this trial with us today, yeah, this detective has been on the stand before. He's recalled now for, hopefully, the checks. Tell us about the checks. Sir, what else did you find?
Proceed.
Thank you, Your Honor. So, jury knows you. We don't have to go through any introductions. You've been brought back primarily to discuss the financial records that you obtained during the course of your investigation. But there was one thing we forgot to ask you, and that's State's Exhibit 199. Detective, have you had the occasion to go to the Potomac address, Mario Fernandez's former rental house, to see how it looks today?
Yes, I have.
And I'm showing you it's been entered into evidence of State's Exhibit 199. Is that a fair and accurate depiction of how it looks today?
Yes, it is.
And I think in the top left-hand corner of the picture, it says the Google Earth image is approximately March of 2025.
That's correct.
So State's Exhibit 199 would have been after Mr. Fernandez sold the home.
Yes.
So now we can go to some of the financial records you obtained. How do you, as an investigator, go about obtaining financial records?
Through a subpoena issued by the State Attorney's Office.
And when you receive those records, do you also receive an affidavit saying that these records are made in the normal course of business?
Yes.
Okay, so what we're going to do is, first of all, State's Exhibit 171. We give the jury an idea of how these records are contained. I've opened up State's Exhibit 171, and it should be on everyone's screen now. When the jury looks at the tenant financial records, we see two different folders come up. Can you explain that to the jury what those are?
One of them is a Credit One bank credit card, and it's just the credit card statements, and I think the application information. The other folder is his PNC Bank subpoena return, which is his bank account.
Okay, if we open up the Credit One.
Finally. I wonder if the state will rest after this, hey? They might. Kelly Smith said, do you think the convicting evidence is the checks? I do think so. It's like Donna Adelson. She got so screwed with those checks. It was like all the, like there's emails and there's all sorts of circumstantial evidence and, emotional emails, we'll say, when the way she was talking about the victim. But then when they showed the checks, Donna's handwritten checks as well, right? Yeah, I know. She was screwed. So I think in this case, I don't know how Mario's defense will actually argue away the checks. They will try. They'll say, so what? It was for roofing. It says it's a Kickstarter. It's for roofing. It's for his business. But he had said on those wiretapped calls with a friend that he got a quote for tree felling, and they said like it was $3,000, and he was never going to pay that. So then he got Henry Tenon to do the work for him, which would have then been for what, a couple of $100, you know what I'm saying? So then to pay him $10,000 in March and April, it's 3 checks, $3,000, $2,000, $5,000. That's weird. That's so strange. How are you going to explain that away? Mario, that is what I think is the smoking gun in this case. Without that, and without Henry Tenon testifying, they got nothing. I don't know how they would convict him, but those checks are crazy.
Is this what you refer to as his credit card history?
Yes, sir.
I think it's all pretty self-explanatory, so we don't need to go through that. But let's look at the PNC bank records. We see 2 different folders when we click on those. Is there overlap contained in those records?
Yes, there is.
Why do we have overlap?
It was just the time period that was requested on the subpoena, and so it was the return of it.
So is there any reason for the jury to spend their time on the June 1st, 2022 to December 31st, 2022 files?
No, the first folder basically covers the time period that we reviewed and then up until the time that he was arrested.
So that would be the 1/1/2022 to August 18th, 2022.
That's correct.
Okay. First thing we're going to look at is that certification. Is that what you refer to as you received from the records custodian?
Yes, sir.
Okay. The jury can see that published. So we will now go to 1/1/2022 to 8/18/2022. Do we see some redactions in these?
Yes, sir.
Is that like for things like social security numbers?
That's correct.
Okay.
Thank F. Because if they're going to show social security numbers here on YouTube, on the streets here, YouTube will take the video down. Obviously, but they're very sensitive with that. If there's like a date of birth, maybe a phone number, that's one thing. Social security number? YouTube is like, that's it. Cancel the stream. So thank you for redacting that state. Now show us the evidence. What he got? He cashed those checks, didn't he? He had the little stubbies in his vehicle, huh?
There it is.
In the Ford F-150.
Adobe looks completely different from mine Adobe. There we go. So
it's just how Adobe rolls.
Looking at page 22 of States 171, what is the jury looking at here?
This is a statement for his checking account at PNC Bank.
If we scroll down on page 22, can you, for the record and for the jury, indicate what the beginning balance and ending balance was of Henry Tenon on his bank statement for the dates of 1/7/2022 to 2/4/2022?
I believe
I guess let me show that for the jury. Is that 1/7/2022 to 2/4/2022 the period of the bank statement?
Yes, sir.
All right, and then scrolling down to the balance summary.
The beginning balance is 52 cents, and the ending balance is negative $2.38.
And how many deposits and other additions were there in the bank account?
There was a total of $250 in deposits, and there were deductions in the amount of $252.90.
And we see an average monthly balance. Could you read that for the record?
The average monthly balance on the statement is negative $66.17.
And were there
a financially vulnerable person that Mario just happened to know and then gave $10,000 to right after the murder of Jared Bridegan?
Additional charges and fees, like overdraft fees, that were included?
$36 for the statement.
Do these statements also contain banking and debit card withdrawals and purchases?
Yes. Let's
go now to the period 2/5 to 3/4 And do we see that at the top of the statement on page 24?
Yes.
And then going to the balance summaries, can you again show the jury the ending balance, the deposits, and the ending balance?
The beginning balance was negative $2.38. There were $703.50 in deposits, $643.80 in deductions, giving an ending balance of $57.30.
Okay, and we also see significant overdraft fees.
There were a total of $144 in overdraft fees.
And again, we see the debit card withdrawals and purchases.
Yes, sir.
Okay. So now going to 3/5 to 4/6 of 2022, beginning on page 26, what is the balance summaries?
The beginning balance was $57.30. The deposits were $11,518.95. Deductions were $4,601.79. You have an ending balance of $6,974.46. Bring his average monthly balance to $941.36. And there were $180 in overdraft fees.
So going to the deposits and other additions on page 27, do we see 3 significant check deposits?
Yes.
And can you put the dates and the amounts?
On 3/28, he deposited a check for $2,000. On 3/29, he deposited an additional $3,000 check. And then on April 6th, he deposited a $5,000 check.
And do these checks end up matching the business check stubs that were found in Henry Tenon's truck?
Yes.
The truck that he had in. This is it. This is now the this is it. Strongest evidence the state has. 3 handwritten checks from Mario. 3 deposits. Henry deposited the money. And the little stubs were found in the Ford F-150 that he had hidden at a friend's house. He had it towed there and was hidden there, even though he had the keys in his pocket. Okay, this is the gotcha.
Do we also see cash deposits?
Yes, sir.
Okay, we'll get to those in a little bit. And again, we see banking card withdrawals and purchases.
That's correct.
Do we see work that corresponds to Henry Tenon's truck on 4/4 of 2022?
Yes, sir, we do.
Discount tire, as well as advanced auto parts on 4/4. Do we see those?
Correct, yes.
So we're going to fast forward to page 39. That's not page 39. This is. Okay, we're looking at page, 38 going into page 39. Do we have the pay period several months later?
Yes, July 8th through August 4th.
And what's it
What are
looking
the
like?
balances?
The beginning balance is $204.63. There were $829.84 in deposits. There were $1,336.39 in deductions, with an ending balance of negative $301.92.
And this would have been the balance shortly before Mr. Tenon's arrest.
That's correct.
So now if we would go ahead and fast forward.
Yes,
Do
please.
these records contain the check deposits and or the deposit slips of cash that Mr. Tenon did?
Yes.
So turning first to page 44, what are we looking at here?
That is a check, like an electronic check for a credit card payment.
Let's see here, make it look a little bit bigger.
I'm sorry, that's an Advance America payment.
I need to make it bigger. So this was paid to Advance America as from Henry Tenon. In other words, he owed them money for advances.
That's correct.
And that was the amount of $100 done on July 29th of 2022.
Correct.
And then we're going to go to page 50. It's smaller. What is the jury looking at on page 50?
This is a paycheck for Mr. Tenon from Monis & Pallets.
Can you state what the amount is?
$364.37.
In reviewing Mr. Tenon's bank records, were his payments from Monis and Pallets typically in this amount range?
Fairly consistent amount.
And did they also always include cents? In other words, they weren't flat numbers, like 100 or 200?
That's correct.
And will we see some of these deposits in his bank records?
Yes.
Did you give the date of January 28th of 2022?
No, it's dated January 28th, 2022.
Oh, that's okay. The jury can read that. And does it say in the memo what the pay period was?
Yes, the pay period is January 16th, 2022 to January 22nd, 2022.
So about $364.37 for a week's worth of work.
Yes, sir.
And do we see that corresponding deposit?
Yes, sir.
Okay, looking now at page 250, in reviewing these records, did you also notice that Mr. Tenon was making cash deposits?
Yes, sir.
Do you have any idea where that cash came from?
No, sir, I did not.
So looking at page 52, do you see a cash deposit February 11th of 2022 for $250?
Yes, sir, that's correct.
And remind us about when the homicide was?
It was the 16th of February.
Do we see the corresponding deposit check?
Yes, sir.
On 2/18 of 2022, do we also see a cash deposit?
Yes, sir, we do for $340.
And do we see that corresponding deposit check?
Yes, sir.
Or slip? Looking now at page 56, what is the date and deposit here?
It is March 14th, 2022.
And for how much?
$520.
Okay. User error. All right, if we can go to page 56, what are we looking at here?
It's a deposit ticket for $520.
And then page 58.
It's another deposit ticket for $150 on March 18th.
Then on March 28th of 2022, is this the deposit slip for the $2,000 check?
Yes, sir, it is.
And on page 60, what is that?
That is a check written to Mr. Tenon for $2,000 from First Choice Home Rentals, LLC, on March 28th, 2022.
And for how much?
$2,000.
And for what?
According to the memo line, it's for landscaping and clearing.
The person that writes the check puts that information on.
Yes, sir.
In reviewing the records of this case, did you find any invoices from Henry Tenon charging for $2,000 worth of landscaping and clearing?
No, sir, I did not.
And who signed the check?
Mario Fernandez.
There it is.
And then, on the same day, there's another check on page 62. Please read it for the record.
Also from First Choice Home Rentals, LLC, to Mr. Tenon for $3,000. It says keeping up with the roof, also signed by Mario Fernandez.
Again, did you see any invoices corresponding to that?
No, sir.
And is that the deposit slip for the $3,000 on page 63?
Yes, sir, that's correct.
Then the next check is 4/4 of 2022 on page 64. What are we looking at here?
Also, the third check written by First Choice Home Rentals, LLC, dated 4/4/2022, made out to Henry Tenon for $5,000. The memo line says Kickstarter, good luck, and it's signed by Mario Fernandez.
So for the period of time that you looked at Henry Tenon's bank records, were these payments different from the payments he received for his normal job at the pallet company?
Yes, sir.
Were they significantly more money?
Very much so.
And do we see the deposit on page 65?
Yes, sir.
And just to show the jury some of the deposits for his work at his pallet company, we're looking at page 66 is the deposit slip for 2 different checks.
Yes, sir, that's correct.
And do we have pictures of those checks on page 67 and then 68?
Yes, sir.
First 67, again, this is from Monis Pallets, and we talked about that non-round figure of $367.
88 cents, yes.
88 cents. And again, do we have a pay period listed there?
April 10th, 2022 to April 16th, 2022.
Macy said, why did Mario decide to write checks this one time if he had given him cash for his other handiwork? I was like asking Donna Adelson the same, right? Why? If Katie McBanawa had previously gotten cash, even stapled stacks of cash, why did Donna Adelson decide to write, wasn't it like 44 checks that she hand wrote? She hand wrote a whole bunch of checks from the dental practice, which is also a murder for hire case, right? We watched her trial together. Why? I don't know. What is it supposed to be like, make it look more legit? Like it was for work. It was for work. No, everyone will believe us. I don't know about that.
And then again on page 68, please put the amount, the date, and then the paper.
The check's dated 4/15/2022. It's for $483.79. And the pay period is April 3rd, 2022 to April 9th, 2022.
And then we also see some cash deposits.
Yes, sir. A cash deposit for $700 on May 11th.
Again, you don't know where that cash came from.
No, sir.
More cash deposits. Let's go ahead and go to 75.
And while we don't know where the cash came from, I mean, maybe Mario was like, I'll do some in cash and some in checks and some like this and some like that. For all we know, you can have rent for free or whatever, right?
So we see, we don't have to go through each cash deposit. The jury can find that there are several cash deposits.
Yes, sir.
And then go to some more of the checks. On page 77. For the record, just put those items of information on the record.
It's a paycheck from June 10th, 2022 for $365.19. The pay period is May 29th, 2022 through June 4th, 2022.
And then page 80.
This paycheck is dated July 8th, 2022. It is for $324.93. And the pay period covered is June 26th, 2022 to July 2nd, 2022.
Now, Detective, could some of the cash deposits be situations where the legitimate work that Mr. Tenon did was deposited, then taken out, and then redeposited?
Yes, sir.
We just don't know where the cash came from.
That's correct.
Okay. We are now going to look at Mr. Fernandez and Ms. Gardner's financials. So when we open up their financials, do we look at 3 different folders?
Yes, sir, that's correct.
Explain to the jury what the 3 folders are.
The Navy Federal return, which is, I would say, their primary banking institution. And then Mr. Fernandez had some accounts at USAA. And then there was also an account at Vistar, which I believe he might have been associated with, but I don't believe that to be his money. I believe it was his mother's.
And these 3 are going to be in States Exhibit 170. So let's look at the Navy Federal, since that's the primary one that we're going to be looking at. Do we see that certification in the first Adobe file?
Yes, sir.
And I'll start with, what is Navy Federal Beached Bake 904?
That is a small cookie business that they owned.
And then do we have a Fernandez?
Have you seen the interview, that Shanna Gardner does about the cookie business? Let me look. Hold on one second. Wait. Where is it? That's not it. This one. Let me show you. You ready? Is it playing twice? Can you hear it?
I'm Jean Pickett, and we are around town today with Shanna Gardner.
Just tell me if you can hear that. You can hear it, and I don't want it to play twice, double, because of my sound settings here.
Gardner Fernandez from Beach Baked 904. Hey, Shanna.
Hey, Jean.
How are you doing this morning?
I'm here, wide awake.
Awesome. Well, I know you are a busy baker. You stay up to the wee hours of the morning just baking. Tell us about Beach Baked 904, because you are a brand new bakery at the beach, and I've tried your cookies and they are to die for. So tell us about what's going on.
Thank you. I am a home-based bakery. I work under cottage law, and it initially started off as a hobby and something that I hoped would pay for itself, and it turned into a business, and I couldn't be happier about it. This has been my passion since I was a child, and it's allowed me to be flexible with my hours so I could be with my kids more. And that was really the goal. I am a custom bakery, so I do anything and everything that people ask me to or can come up with that's within my skill set or wheelhouse.
Okay, so I just quickly went to look. What date was this posted? It's from YouTube. May 6th of 2020, so 2 years before Jared Bridegan was killed on February 16th of 2022, right? I'm showing it to you because they're showing us records there for a Navy Federal Gardner Fernandez account, and one of them is it says Navy Federal Beach Baked 904. Okay, so now we can see what the hell was that. It was their cookie business, okay? And you know who else looked up cookies? Juan Biggerstaff. He was looking up home-baked, homemade chocolate chocolate chip cookies. Okay.
Well, what I really love, though, about your bakery is it's really founded in the basis of what your grandmother's recipe, her trainings. It's really a heritage that's been just born and raised with you.
Yes. In fact, my logo, I just got it updated, and the font for the words, the typography is modeled after my grandmother's handwriting. My brother-in-law, who's an amazing graphic designer, was able to sketch out and hand draw and create her handwriting, because when it came down to it, this came about, and this is possible through what started with cooking with my grandma in the kitchen, and then it turned into a labor of love and a way to show people that we care about them and to kind of share happiness, make people happy. Everyone's happy when they get little treats, when they get food.
Well,
I'm allowed to roll my eyes at her because she is now accused of murder. Okay, everybody's happy. I'm just so full of love. I just love people. I want to make them happy. Sure you do. Alleged killer. Okay, yeah. Oh my, couple is to die for. Okay, now who else? This is Beach Baked. Okay, wait. 904. And that just rang a bell. Did Juan Biggerstaff not say that his handyman company was 904 Biggerstaff LLC? Did he not say 904? Because I think he did. There's more connections between Juan Biggerstaff. We got cookies and 904. What else were they involved in? Oh my word, this woman I can't. She just annoys me so much. Shanna Gardner. Whew, the snark is going to be off the charts for her trial.
Let me tell you, the samples that we had and tried around the office made everybody happy. And my favorite cookie that you brought by was the strawberry lemonade. That, for a cookie, it was refreshing. It was surprising.
I like to work with natural, whole flavors. I'm not a huge fan of extracts and artificial flavors. I want my brand to really be known to be homogenous and very real.
Right. And you could definitely taste that even in the cupcake, the strawberry cupcake, because it had that little bit of crunch from the seeds. It was real strawberry that was in it. It wasn't just all flavoring.
Mhm.
Yeah. So talk to me about like the type of products that you do. You have the little cupcake.
Side note, there's only 3 minutes left of this interview, okay? So it's not like we're taking a huge side tangent, okay? I just really needed to show you this, and this was the moment. It was cue in the 904. It was like, oh, Mario, Navy Federal Beach Bake 904. And there was a cookie business. That's it. It's time to watch this interview. 904 is the main area code for Jacksonville, Florida, and the surrounding First Coast region, including Duval County, Jacksonville Beach, St. Johns County, Nassau County, and most of Clay County. So that's why. One could just say it's just area codes, but it's kind of weird that John Biggerstaff and Mario and Shanna are like 904, Beach Bake 904. 904 Handyman LLC. Okay.
And the cupcake was absolutely beautiful. It was a strawberry cupcake with a strawberry chocolate dipped strawberry on top. But you do more than that. And you were talking about how you like to sample or try new things and new flavors, and how you're putting that out, these just things that you're inventing, these flavors.
Yes. I actually dream of new flavors and recipes, and I'll wake up and think, I just thought of a new idea. I thought of a new recipe, and I'll go into the kitchen when I have the time, or I'll write it down, and whenever I have that free time, I'm able to throw it together. So I've always loved experimenting and playing in the kitchen. So this has been a great avenue to channel all of that creativity. I do mainly cakes, custom cakes for parties, and then designer cookies. They're royal iced cookies, but I also do a variety of drop cookies, buttercream, frosted cookies, cupcakes, all sorts of things, breads.
Stop it. Sorry, I gotta hold back my snark slightly. Oh my word. What other businesses were entangled in these? Handyman and cooking making and tile working, landscaping, gun hiding businesses.
Muffins, anything that can be baked. In most cases, I'm down to do it.
That's great. Now,
like a gun and a cake?
Your new things that you're trying. I mean, who do you get to sample your newest flavors?
I actually was able to link up with a couple local people, food reviewers. Nate Does Food on Instagram. I was able to meet up with him this weekend and give him a little mini cake, and that was awesome to meet him and kind of tap into that group. And it got me thinking, I've always wanted to gear towards doing a mystery flavor cake, mini cakes on the weekend, and it can be anything and everything that I want to create under my own creative freedom, and offer it as a flash sale. And then with everything going on with such uncertain times, I was talking to a friend, and we came up with the idea of, what if we make this something where it can help the economy, it can help our community, and turn it into a charitable event. So now I'm leaning towards, I'm working up, trying to get the logistics of finding a charity to identify each month and have some of these flash sale cakes have all of the proceeds. I'll donate everything on my end, and whatever anybody will pay, whoever buys them, the proceeds will go completely to that charity at the end of the month. And we can.
You're so loving, like so loving and thoughtful.
That is fabulous, because not only, does it taste good, but you're helping people as well. So Shanna, if somebody wanted to order from you or see your designs, your flavors, your cakes, where would they go? How could they get in touch with you?
Yes. So social media is my number one outlet for communication. Instagram and Facebook are the top. It's Beach Baked 904. But I also have a website and an email. It's beachbaked904.com or beachbaked904@gmail.com. And it's all one word, beach baked, BAKED 904.com.
Awesome. Thank you so much. And I am so looking forward to trying your flash sales. I love new things and new flavors. So thank you so much for joining us today.
Thank you, Jean, for having me.
Just really reminds me of Corey Richards, doesn't it? That was annoying to watch, okay? She's like so loving and kind, you guys. She's just like thinking of the community and like flash sales and charity while plotting murder of her ex-husband. Already since around 2015, when they got divorced. Tried to alienate her children. Parental alienation, huh? Yeah, until she's allegedly involved in the murder of Jared Bridegan. Anyway, she's just a loving woman who loves making cookies. We'll enjoy that. In jail. She's been in jail ever since she was arrested in August of 2023. Held on no bond. Anyway, so does she also still dream of flavors? Oh, okay. Navy Federal Beach Baked 904. That's where we were. Okay.
There's checking and savings account in the third Adobe.
Yes, sir.
We also have a first choice home rental in the fourth.
Yes, sir.
Do we have a Shanna Gardner checking and savings in the fifth?
That's correct.
And then the Shanna Gardner irrevocable trust in the sixth.
Yes, sir.
So we'll begin first by going through the first choice home rental, because we have first choice home rental checks that were deposited in Henry Tenon's account that we just saw.
That's correct.
So page 2, what are we looking at here?
This is the membership application for Navy Federal Credit Union for the first choice banking relationship, and it lists the two owners of this LLC.
And who are the two owners?
Mario Fernandez and Shanna Gardner.
Is there a percentage of ownership listed?
According to this application, it shows that Mario Fernandez is 60% and Shanna Gardner is 40%.
So we are going to go, and certainly all of these are in the record, so I'm only skipping things for time's sake. Page 46, this is going to be for the time period of February 1st, 2022 to February 28th, 2022.
Yes, sir.
Explain to the jury what they're looking at in the business checking and the business savings account of this LLC.
This is a statement for the period that you stated, 2/1/2022 through 2/28/2022. Unlike a lot of banks, credit unions you have a main account number, and then you would have what they refer to as shares, which are just like sub-accounts of your main account. In this case, you're looking at one, which is the business checking account, and then the other, which is just the business savings account.
And the previous balances, and then show what's deposited.
The total previous balance was $4,206 for both accounts. The total deposits were $56,201.67. Withdrawals were $601.33, and then the ending total balance for both of those sub-accounts is $59,806.61.
And then we'll see on page 47, obviously there was a lot of money deposited. Does it say on 222 and 228 where those $5,000 and $50,000 deposits came from?
I know at least the $50,000 one came from Mr. Fernandez's account.
So from his account into the LLC.
That's correct.
So we see here a transfer from checking for Courtney Thomas. What is this?
That would be a rent payment, I believe.
And do we see that reoccurring on a monthly basis?
Yes.
And is that for the Sandalwood property as opposed to the Potomac property?
That's correct.
Do we have evidence in the Potomac property that rent was approximately $700?
I think it was 800, but I'm not sure.
780,
Yeah.
somewhere in that range. Okay. Do we see on page 50 that there were some legitimate payments made for the care of the Potomac home?
Yes, sir, that's correct.
And please show that to the jury.
You need my, sure.
Should I stop? No, I was just wondering what was going on.
What is going on? We didn't see rent on Henry Tenon's bank records, did we? We didn't see him paying rent. Oh, sorry. I've still got a... Detective Johns is back.
Okay.
What is happening?
Mr. Mizrahi.
Do they need
We're
a...
looking at-
We're good?
We're looking at page 50. If you could show the jury show the payment to Bueller.
Yes, sir. Right there on March 3rd, there's a $14,000 payment.
Bueller.
Right there.
You saw that?
And that was for Bueller air conditioning.
And do we also see payments for items from the Home Depot?
Yes, sir, that's correct.
Do we also see that $2,000 and $3,000 checks that correspond to the checks written to Henry Tenon?
Yes, sir.
And your review of these records was the balance of over $55,000 unusual for this LLC?
Yes, sir.
And although unusual, there was a large expenditure to Bueller Air.
Yes, sir, that's correct.
Was the amount that was deposited well in excess of the $14,000 to Bueller Air?
Yes, it was.
So we're fast forwarding to, well, too fast. Going back to page 53, which is on a separate statement, do we see that $5,000 check on 4/7 made to Henry Tenon?
Yes, sir.
Am I underlining?
Bueller was that air conditioning company that arrived. We were like, oh, there they are on the poll camera, right? Okay, so we know that that happened. Well, what about all these other, what is going on here with all these checks, huh, to Henry Tenon?
On check 29?
Yes, sir, that's correct.
We also see a check 30, it was $240.
Yes, sir.
Did Mr. Tenon also deposit cash amounts in $240 increments sometimes?
Yes.
And that $5,000 that we see on 4/7, what was the memo line of that $5,000?
I believe it said Kickstarter, good luck.
Okay, going now to page 59. So we see transfers that reduce the balance in this account directly to Mario Fernandez.
Yes, sir.
And just, I guess, point the dates out and circle them for the jury.
Looks like June 16th, June 23rd for 5,000, and then an additional for 5,000. And then there's another one for 500 on the 24th.
I think the $500 was a reoccurring one as payment for like his doing this work.
Yes, sir.
And then going to page 72. What are we looking at on page 72, specifically the October 14th?
There was a cash withdrawal for $10,000.
And below that, do we see a transfer to from checking back into the account?
Yes, sir.
In reviewing all of these records, do there appear to be a lot of money moving around?
There was, yes, sir.
In your training experience, could you figure out really a reason why all this money was moving around?
No, there was no what seemed legitimate reason for it.
Grounds.
So he may have clearly paid Henry Tenon more than what we know about the checks, the handwritten checks, the $10,000, right? It seems so. Because they offered, according to court documents, about $150,000. That's actually what Henry Tenon told police that he was offered. How much of that he actually got? Interesting.
Lack of foundation and speculation.
I'll sustain as a foundation.
Well, let me just ask the question because you kind of add it on sometimes. Did you see any reason why any of this should be happening?
I'm going to check if his opinion is the reason.
Let me see it at sidebar.
Stefan says money laundering. Something fishy going on there with this LLC, which is so dumb still. Like Mario wants to say allegedly to that inmate that we saw with the proffer on Friday, Mr. Ponder, that Henry Tenon was not the guy that he originally intended to, kill Jared Bridegan. He was hoping Henry Tenon's nephew would do it, but then he wasn't available. So he said allegedly again to that jail snitch that Henry was too old and then he effed things up. Mario, I think you effed it up all by yourself with these handwritten checks. Like, what on earth are you... doing that for? You thought that would never be questioned? Especially if it was just for like construction, aircon, whatever, but like to Henry Tenon? That amount? And then unlisting him as a tenant, but he's still staying there. That's so, all of that is just strange.
So,
You may proceed.
thank you, Aaron. So we left off on page 72. Do we see a cash withdrawal for $10,000 and then a transfer of $5,000?
Yes, sir.
We're going to now, do these records also contain the checks?
Yes, sir, they do.
And we're going to start those on page 117. So explain to the jury what they're looking at on 117.
This is a check written to Tri-H Construction for $2,000.
And is there in the memo line or 4-line information?
Yes, it lists the White Horse property address, and I can't read the rest of the memo line there.
It may say
Agreement draw, I think.
I'm not really sure.
Agreement drawn or agreement draw, something like that.
And the White Horse is the Sandalwood address?
Yes, sir, that's correct.
And then on page 118, what are we looking at here?
Also a check to Tri-H Construction for $16,300. And it says siding repairs, and it also gives the White Horse Road address.
And both of these checks are back in well, one of them doesn't have a date on it. Maybe on the other part of the check it does. Yeah, they're both in 2021. Is that fair?
Yes, sir.
And then on page 119?
Another check to Tri-H Construction for $2,573.99. And it says for siding and electrical.
Page 120?
This check is dated October 14th, 21 to Current Electrical Contractors Incorporated. It's for $317 and is also for the White Horse property. It has an invoice number there.
It does have it has an invoice number. Okay, and then on page 121.
This is the $2,000 check that we saw with Mr. Tenon's records. It says for landscaping and clearing.
Page 122.
Another check written to Mr. Tenon for $3,000, and it says keeping up with the roof.
And 123.
A check dated 4/4/2022 for $5,000, and it says written to Mr. Tenon, and it says Kickstarter, good luck.
And do we see a check on page 124?
Yes, sir. This one was written April 5th, 2022 to J.B. Cornwell, I believe. $240. Dirt AS, I'm not sure.
And then on page 125.
Check written on 4/22/2022 for $7,494, written to Current Electrical Contractors Incorporated, and it lists the Potomac address.
I don't know. I feel like this is not helping because the state was sort of implying, even with the wiretap calls, I was under the impression that, Mario didn't make such big payments at all, but here there's many of them, right? So in 2021 and 2022, yes, it's weird that he made it to Henry, but he did say on the phone, on that wiretap call with his friend, that he asked Henry to come and do the work. If he had paid other contract workers so much, I don't know. Doesn't it weaken the evidence against Mario? Doesn't it look like a pattern of him paying lots of money to have work done at the properties? It's just on the phone call that was wiretapped. He said, well, he got a quote or an estimate for tree felling. It was $3,000 and that was too much, so he asked Henry to do it. But the thing is, maybe he asked Henry to do lots of work. I think, the Kickstarter, good luck. I think the notes are a bit odd. But what do you think about what they're showing here now?
Page 126.
check written on June 30th of 2022 to J.B. Corwell for $425. I believe it's at store 57.
I think, Detective, if you look at for deposit only, it may be J.B. Coxwell.
Oh, sorry. Yes, J.B. Coxwell.
They're a contractor with an operating account.
Yes.
Page 127.
June 30th, also to J.B. Coxwell for $200. It says for fill dirt for the White Horse Road address.
128.
Current Electrical Contractors Incorporated for $158. And it says invoice 2864-A.
So let's look at the third one, which is Mario Enrique Fernandez's accounts. And do we see his information as well as a family member, which is his brother?
Yes, sir.
I'm fast forwarding now.
Right? I just feel like that weakened the evidence a little bit. But Mamushka says he lists the addresses on the checks for work he's paying for, but not on those three. I mean, there's a lot of circumstantial evidence to weigh up here. It's just, I thought this was a lot stronger. Still pretty good, but I wonder what the jury's thinking at this point.
To page 59. What are we looking at for the statement period 4/8 of 22 to 5/27 of 22?
Yes, sir.
Is there an interesting deposit?
There is a transfer of $45,000.
So what was the beginning balance and what was the ending balance?
The previous balance, or the starting balance, had been $49,804.69. And the ending balance was $2,000.1543.
We're into page 151. Yeah. 4/28/22 to 5/27/22.
Maybe it's also the way it's being questioned, presented is very, getting the vibe of complacency, you know what I mean? Don't be complacent, Mr. Prosecutor. Make it extra clear for the jury. Put some passion in those questions. As you show these financial records, it's not that obvious. You got to make it like, and here, what are we looking at? Hopefully they're tied all together then in closing arguments. Right?
If we fast forward in those accounts, on page 151, turning your attention to 813, what do we see in 813?
There was a cash withdrawal of $2,250.
Turning now to the next page. This is going to be page 152. And again, we're looking at a statement period now because we're jumping between different checking accounts in July of 2021. What is this?
It's a bank wire that was received for $382,894.34.
And did your investigation lead to where that came from?
That was the sale of the house that Ms. Gardner owned prior to marrying Mr. Fernandez.
And we can see that that money remained in the account for some period of time?
Yes, sir.
And then turning to the next statement period, going from August to September of 21, we still have a large portion of that money remaining in that account.
Yes, sir.
Do we have large withdrawals?
Yes, sir.
And showing you page 156, do we see one of those large withdrawals on 9/13?
Yes, sir, for $150,000.
Now, during the course of your investigation, were you able to determine what Mr. Fernandez's employment was during the period of time that was relevant to your investigation?
I believe during the time that we were looking at these bank statements, he received money from the VA.
In addition to any monies he was receiving from the VA, did he have some rental properties?
Yes, sir, he did.
Which I think you said totaled about less than $2,000?
I believe during the period we looked at, there was a total of $31,500 in rental payments.
Did your investigation lead to where this money is all coming from?
Most of the money that was transferred into this account would have derived from the trust.
And whose trust is that?
Ms. Gardner's.
In your investigation, I think the jury's already heard that her parents were very wealthy.
Yes, sir.
Just look at a couple more of these. 176. Do we see a large withdrawal during the period of time of 1/28/22 to 2/27/22?
Yes, sir. There was a large withdrawal of $36,500.
And then page 180, which is the same period of time, 2/28/22 to 3/27/22. Do we have a large transfer to checking?
Yes, the $50,000 transfer.
Fast forwarding to page 265, I know the jury has already seen the fact that these accounts contain checks. What are we looking at on page 265?
That is a check that was written to Mr. Fernandez from Mercedes-Benz of Jacksonville for $35,000.
And did your investigation lead to what that was for?
I believe it's for the sale of the Tesla.
And finally, on page 277, what are we looking at there?
That is a check to Mario Fernandez from Shelley and Sterling Gardner for $75,000.
Shanna Gardner's parents.
What was the date of that?
I believe it was 12/21.
I'll go back to it. Just for the record.
Yeah, December 21st, 2021.
And is there anything on the memo line?
No, sir.
So I want to spend just a minute on the Beach Baked. Is Mr. Fernandez also listed as the named person on that account?
Yes, sir, he is.
And does it list the 1511 Marsh Inlet Court address?
Yes, sir.
And does it also list Ms. Gardner as well?
Yes, it does.
So just to show the jury, are there any large amounts that are either deposited or written checks on this account?
No, they're usually fairly small amounts, less than $1,000.
Is that consistent with what you learned about the home baked goods account business that Ms. Gardner ran?
Yes, sir.
So just for example, on page 8, we're talking about balances that range between $500 and $1,700?
Yes, sir.
And then on page 10, $500 to $1,100?
That's correct.
All right. Now, we're going to look at the irrevocable trust.
Okay.
Before we go into what's contained in the bank records, did you also review the trust documents in this case?
Yes, sir, we did.
And what do the trust documents say about Jared Bridegan?
That Miss Gardner could resume being in charge of her trust once she had no further legal entanglements with Mr. Bridegan.
We'll look at that in a minute. It's definitely here. I just read through the page now. All right. Let's look at who was the trustee of the irrevocable, Shanna Gardner Irrevocable Trust.
Mr. Fernandez.
And do we see that here contained on page 1?
Yes.
Skip to page 25. Can you explain to the jury the statement period 7/18/21 to 8/27/21 what they're looking at?
Yes, it looks like there was one sub checking account and then 3 sub savings accounts. And the total balance, or the beginning balance for the statement period, would have been $181,195.93. Ending balance for the entire of the sub accounts was $179,713.46.
And the identical balances in the 2 savings accounts, would that correspond to the accounts that were designated for AB and LB?
Yes.
Guess we need to go to the beginning of the trust. Do we have an ending balance of 12/28/20 to 1/27 of 21?
The ending balance was $218,655.88.
Looked at page 52. What are we looking at here? First of all, let me put the dates. 4/8/28 of 2022 to 5/27 of 2022.
Yes, sir.
What are we looking at here?
The beginning balance was $251,026.15. And then the ending balance was $12,202.61.
And what happened from the 2021, early 2022 statements until April and May of 22? What had changed?
Ms. Gardner had opened up another account, and I believe they were separating, so they were transferring out all the remaining assets.
Was there a need for an irrevocable trust anymore?
No.
And we see on that 5/2 transfer of $120,000?
Yes, sir.
Page 68, which is going to be September of 2022, what are we looking at?
This is the Shanna Gardner Irrevocable Trust statement, and it is $0.
I'm showing you what has been entered into evidence as defense exhibit number 3, subsection C, page 25. Can you read that into the record?
Furthermore, and notwithstanding the foregoing, when our daughter Shanna shall have no further legal entanglements with her ex-husband, Jared G. Bridegan, she may elect to serve as the trustee by delivering a signed and notarized document to the trustee then in office.
To have that clause, I don't know if I'm just not understanding it right, but to have that would obviously motivate Shanna to do something about Jared so that she could have the trust. I don't know. It's just like how else, I don't know. The critical clause in the trust agreement was that Shanna could only become the trustee and gain control of the money when she had no further legal entanglement with her ex-husband, Jared Bridegan. like, if the parents made that clause, that's so weird. And then transferring $75,000 to Mario? Yeah, right before Christmas of 21. It's just, there's a couple of things that I'm sure we all have a lot of questions for, right? K.D. Gonzalez. Thank you, Stu Bear. Thank you so much for, thank you so, did I say it right? K.D. Gonzalez? Gonzalez Tube? Is that better? Thank you so much for your $50 sticker. Damn, thank you for supporting my work. I really appreciate it. What are you guys thinking about this? Because I'm like, we're going to see more people arrested or no? It's just like, well, Shanna, you can only have this trust and all this money that we're going to, okay, if you have no further entanglement, legal entanglement with Jared. Eh? That would motivate their daughter to do bad things. How else was she going to not be entangled with the father of her children? Beach Mom says, follow the money, always. Right?
So we look at...
Yeah, that's what I'm saying. Sarah says, ooh, the trust situation is interesting. The contingency about the legal entanglement is interesting. And why make him the trustee? So suspicious. Is this another Donna Sue? That's what I'm thinking. I'm like, hey, Shanna's mother, what exactly was going on here? Because why do you trust Mario so much, but not Jared Bridegan? What is happening there? Why Mario? Why is he fine, even though the marriage didn't last long and Shanna got married so quickly? I don't get it.
Page 72, do we also see a corresponding check to Shanna Gardner in the amount of $75,000 that corresponds to the date and time that Mario Fernandez received that $75,000 check?
Yes, sir.
So now I want to look at Ms. Gardner's checking and savings account.
Okay. Any objection from the defense?
We're going to go first, page 38.
All right. We'll see this
again in her trial. You just explain to the jury what they're looking at for the statement period 12/2021 to 1/19 of 2022.
She has two sub-accounts, a checking and a savings, with a total previous balance of $1,245 and an ending balance of $1,120.63.
And do we see those every day?
Hold on. That is true. HB Labs and Rod said, don't forget Mario telling his gal pal from the military that his marriage to Shanna was, and he said a contract with her parents. That their marriage was a contract, and he talked about his special skills. Yeah. That was also from day 5, right? When we saw that. What did, Shanna's parents, I'm just asking a question, okay? I'm not blaming them. I'm just saying, I have questions. Did Shanna's parents think Mario was the right guy to help them all get rid of Jared? Because it sort of looks like that, right?
Checking things that she's paying for and things like that?
Yes, sir.
And then from 1/20/22 to 2/19 of 2022, similar type balances?
Yes, sir.
And then 2/20 to 3/19, do we have similar type balances?
Yes, sir.
I mean, Charlie Edelson found Catherine McBunower, who knew people. Donna Sue was involved there. Can't believe Wendy hasn't been arrested yet, but okay. In this case, so Shanna found herself Mario, like the Katie McBunower of the case, and Mario knew people. How about Sherry Gardner? What are you, ma'am? These transactions look interesting.
And then 3/20 to 4/19, similar balances?
Yes, sir.
Then 4/20 to 5/19 of 2022. What's changed?
There was a significant increase in the balances.
Can you show the deposits for the jury and say what they are?
So the previous starting balance was $3,246. And then there was a total deposit in the amount of $233,419.09. And then withdrawals of $15,511.80, giving her an ending balance of $221,147.01.
And did we see those 50, 45, and 120,000 figures in different parts of the other accounts?
Yes, sir.
Are you familiar with the $10,000 threshold?
Yes, I am.
Explain that to the jury.
If you take a cash withdrawal or do a wire in the amount of in $10,000 or more, they're required to do a currency transaction report, which basically reports to FinCEN or the Treasury Department any large movement of money.
That's all the questions.
Thank you. Cross-examination?
Yes, ma'am.
Oh, boy.
You need a moment, Mr.
We've got to buckle up here. Yes, ma'am. How long is this going to take? We're going to be here for the rest of the day, probably.
Ms. Rai.
Other than dropping my pen, no. Don't.
You take a few trips.
It's evidence. You need this?
Yeah, no.
This is your notebook.
Yeah, I don't need it at the moment. Thank you, though. Okay. Put that one over there. Let's see. All right. Good afternoon.
Good afternoon, sir.
Good to see you again. Let's talk about a few things first, globally. Shanna Gardner's family is extremely wealthy, correct?
Yes, sir.
Hundreds of millions of dollars in yearly revenue, correct?
That's what's been reported.
You have no reason to believe that's not true, right?
No, sir.
And Shanna Gardner's parents gave Miss Gardner and Mr. Fernandez money, correct?
Yes, sir.
And through your investigation, you were able to learn that it wasn't just those two $75,000 checks. They got regular and reoccurring money from the Gardner family, correct?
Yes, sir.
Yeah. So although you just talked about two checks, since the moment Mr. Fernandez married into that family, he started getting money, correct?
I can only go and report what is the time period that was reviewed, which those are the only checks that were received, but I have no reason to believe that they did not receive other funds.
They got money wired to them, correct?
Well, the wire that I saw was from the sale of the house.
No, but there was other, in all of the records you reviewed, they got money wired from the Gardners to themselves, not just checks, correct?
I actually don't recall seeing a wire from them.
You're not suggesting to this jury that they got two checks for $75,000.
No, their lifestyle was funded by the Gardners.
And let's back up a little bit. Let's back up. Jared Bridegan was married to Shanna Gardner, correct?
Yes, sir.
And he didn't work when he was married to Shanna Gardner, did he?
As it was reported, that's correct.
He lived off of the Shanna Gardner trust money, correct?
Yes.
Because you know through your investigation that the Shanna Gardner family paid their children for all sorts of reasons, educational reasons, and as part of their trust fund money, right?
Yes, sir.
Okay. And you pointed out a big transfer from the sale of the home of $382,000. Do you recall when I asked you on direct examination how much Mr. Bridegan got when Miss Gardner sold the home?
I don't recall the figure, but there was an amount he received.
About $390,000 that Mr. Jared Bridegan received, correct?
Yes.
Okay. So no different that Mr. Bridegan received hundreds of thousands of dollars via the Gardner family, right?
Correct.
Okay. So in this trust, you were able to learn that not only did Shanna Gardner get money, the Gardners also gave their other children money, correct?
Yes.
Okay, so there's no disagreement that the extremely wealthy Gardner family gave their children money, right?
No.
And did you make sure that it was clear, and I will if you didn't, the $75,000 checks dated 12/21, Shanna Gardner got $75,000, right?
$75,000 went into the trust, and $75,000 went into Mr. Fernandez's account.
Right, from the Gardner money.
Yes.
And the purpose of the trust was so that her money was protected, right?
Yes.
And you said that you were a financial planner here in town. You have your own business, right?
Yes.
So you certainly are aware that wealthy people give their children money, right?
Yes.
For tax reasons, right?
Various reasons.
To lower their inheritance tax, right?
There's several reasons, yes.
Dozens of reasons why really wealthy people start trusts for their children, right?
Yes.
So let's just globally talk about a few more things. That trust document that says that Shanna Gardner can be the trustee of her own trust if she so elects, if she doesn't have any entanglements with Jared Bridegan, does it say anything about Mario Fernandez?
No, it does not.
So in fact, if she has no entanglements with Jared Bridegan, she gets to control the trust, right?
That's correct.
Mr. Fernandez is already in control of the trust, right?
Yes.
He is the trustee, okay? Right?
Yes.
Okay. So let's now talk about what Mr. Fernandez had prior to the homicide. I'll stand here. Can you publish this? Can you zoom out? Can you see this, Detective?
Yes, sir.
This would be from the same records that you were talking about from States 170, right?
Yes, sir.
Okay. This is a Navy federal account, right?
That's correct.
This is Mr. Fernandez's personal checking accounts, right?
I can't see the titling, but at the top.
Okay, sorry. There we go.
Yes, sir.
Ms. Gardner's not on this account, correct?
That's correct.
This is just his money. He can do whatever he wants with it, right?
Yes, sir.
And this is the month.
I believe it's on December 28th at the top.
Yeah, December 28th to January 27th. This is before the homicide, right?
Yes, sir.
Mr. Fernandez had access to $212,000, correct?
Yes, sir.
If he wanted to do anything he wanted with that money, there's no trust that dictates what he could do. That is his money, right?
I mean, I don't know what a divorce attorney would say about that, but otherwise, yes.
They weren't getting divorced, right? So you're married, happily married people. You can just go and take whatever money you want out of your account, right?
Yes, sir.
You don't have to call a divorce attorney to do that. That's your right to do whatever you so choose with the money in your account, right?
That's correct.
You may come home and your partner may be a little upset with you, but certainly there's no law that he couldn't have done whatever he wanted with that money, right?
Correct.
Okay. Okay, let's go to the next month. This is Mr. Fernandez's checking account, correct?
Yes, sir.
Same statement I showed you before, except for this is the next month, 128 to 227, correct?
That's correct.
Still has $158,000 available to him, correct?
Yes, sir.
Okay. This is the following month, right? Same account?
That's correct.
This is after the homicide, 228 to 327, and he had 158,000. The ending balance was 96,000, correct?
Yes, sir.
All right, and that was his own personal checking account.
That's correct.
Now, you suggested to the jury that he transferred $50,000. You recall that?
Yes, sir.
He transferred it to himself, correct?
He transferred it to the LLC.
First Choice Home Rentals.
Yes.
So it didn't come from the Gardner Trust, right? So if it was ever suggested to this jury that Mr. Fernandez transferred $50,000 a week after the homicide from the Gardner Trust to himself, that would not be true, would it?
I think it's a mischaracterization in the way you're stating it.
No, I want to make sure it's crystal clear. If it was ever represented to this jury that Mr. Fernandez transferred $50,000 from the Shanna Gardner Irrevocable Trust 1 week after the homicide to himself, that would not be true, would it?
At least part of those assets would have come from the trust, yes.
What assets came from the trust, detective? I just showed you that Mr. Fernandez had $212,000. Then the next month he had $196,000. He had plenty of money in his own personal checking account, right?
Yes, that would have come from the trust.
Also, Mario getting money like he did and Jared getting the $390,000, very different situations. Jared Bridegan got that as a divorce settlement. And the Gardner family were not happy about it. And it was an agreement reached and Shanna got the house. They got 50-50 custody. Shanna got the house. And he got $390,000.
We just talked about that. On 12/28, he deposited $75,000 from the Gardners, right?
Yes.
It didn't come from the trust, did it?
Overall, I'm saying the amount of money that he was only making $37,000 a year.
We have to be really careful with our words.
I agree.
Money goes from the trust account to, and I'm going to walk you through it. We're not going to guess, trust me. We're going to go through every single trust account record to see where that money went. But I'm asking you a very basic financial question. You can transfer money from the Shanna Gardner Trust to Mr. Fernandez. He could do that if he wanted to, correct?
Yes, he was the trustee.
That did not happen. That $50,000 did not come from the trust account, did it?
No, that specific transaction came from his account.
Right. And let's say
I'm putting it at 1.1 speed because otherwise we're going to be we'll probably be here all day anyway. Like, shame, the hope that just drained from his face when the defense attorney Dreiser said, we're going to go through every single record. No, every single one. Oh my word, the defense attorney working hard out here.
December 28th, Mr. Fernandez got $75,000. That could have come from the irrevocable trust, hypothetically, right?
Yes.
But it didn't. And this is why I want to make sure that words matter. Shanna Gardner's parents, Shelley and Sterling Gardner, wrote him a check for $75,000 at the end of the year.
Why?
Right?
Yes.
That's where that money came from.
Why'd they do that?
The assets are commingled.
They're not.
They wrote him a $75,000 check, and he did transfer $50,000 from his account.
Okay. We're really going to figure this out together. The Gardners live in Utah, right?
Yes.
And they're private wealth clients of Chase Bank, correct?
Yes.
Because you know that because it says it right on the check. $75,000. This is an example of the two checks that the Gardners gave them, right?
Yes, sir.
But why? And why was Shanna then working 3 jobs at one time? It was something about her parents saying if she's not married, they're cutting her off, but it also would make her rush into a marriage. So I don't know. I'm starting to think a lot of things. My speculation is going off the charts of like, was her parents saying, look, man, we're cutting you off until you find someone who can solve this problem for us. That's what it sounded like to me. Kelly Gonzalez, thank you for the 5 Big Bear coffees for the mods.
You're saying it was commingled, it all came from the same place. This came from a checkbook as a Chase private client from Shelley and Sterling Gardner, right?
Yes, sir.
From their bank account, right?
Yes, sir.
That did not come from the irrevocable trust, correct?
No, that check was, the check that you just showed me was deposited into the trust.
Right. And in the identical check, with the exception of it saying Shanna Gardner, it said Mario Fernandez, right?
Yes.
And that came from the Chase private wealth management banking account of Sterling and Shelley Gardner, right?
Yes, sir.
So that didn't come from the irrevocable trust, right?
That specific $75,000 no, it did not.
Okay. And in addition to all the other money that Mr. Fernandez had, you're saying, well, it's all commingled. It came from the irrevocable trust. Isn't that what you're trying to say?
Yes.
Well, $35,000 of it came from Mercedes-Benz of Jacksonville when he sold his Tesla, right?
Yes.
That didn't come from the Shanna Gardner irrevocable trust, did it?
I mean, you'd have to go back and look and see. You'd have to have a much larger picture of knowing where the Tesla was purchased from.
The check came from Mercedes-Benz of Jacksonville, right?
For an asset that was sold to them, but we don't know how that was purchased.
You don't know. So you can't say it came from the Gardner irrevocable trust, can you?
You're correct, I can't.
Right. Because you know for sure it came from Mercedes-Benz of Jacksonville, right?
Yes.
So let's talk about two things that we know for sure. $75,000 came from the Gardners personally, not the trust account, right?
That's correct.
And $35,000 came from Mercedes-Benz, right?
Yes.
So that's $110,000 right there that we know for a fact did not come from the Gardner Trust, right?
It would depend on how the Tesla was purchased. There's no way to know that with the records that we currently have.
You're saying that whenever he bought the Tesla, when did he buy the Tesla?
I don't remember exactly when it was purchased.
So you don't even know if he was married when he bought the Tesla, do you?
Off the top of my head, no.
So you're trying to insinuate that possibly it could have come, this asset could have come from money that was given to him through the trust account for an asset that you don't even know when it was purchased, right?
I'm just...
Sir, he was the maintenance man at a gym. There's nothing wrong with that. It's just that he's not buying Teslas and rolling around with hundreds of thousands of dollars until he meets Shanna Gardner. And she's got a job for him to do. Okay, loud and clear. He was not driving around in a Tesla before that. That, I think, is common sense.
Saying that is a possibility versus just saying that the Tesla was his outright, and so the money that he got from Mercedes-Benz was his and did not originate from the trust or the Gardners.
Well, let's circle back.
Okay.
Let's go to the trust. No. Let's go to the trust account.
Mr. Dreiser, could we take a break?
Sure.
Would that be too disruptive to you?
No, that's fine.
I'm going to say the jury will take 15 minutes, okay?
Okay, we could skip right over that. And we're back. Yeah, Studio Taterville says even the Tundra was expensive. I mean, Mario, he went from, what, $37,000 a year to suddenly just like rolling in it and being the world's greatest wannabe dad. Okay. Amazing how also after the murder of Jared Bridegan, it's just like, okay, we're done. Oh, okay. Marriage over. Shanna moves to Washington. What? That in itself is freaking weird. And they still married? It's so weird. Oh my goodness.
Okay. We're working through some bank records trying to figure out money, correct?
Okay.
You've reviewed lots of stuff in order to make findings as to where you think money came from, right?
I don't understand the question.
You've had access to review lots of documents so you could try to get a better understanding of how the Fernandez family, the Gardner family, and the Gardner wealthy family out in Utah, how they move money. That was part of the job of you trying to figure that out, right?
Not necessarily, no.
What have you been testifying to for the last hour and a half?
I received bank statements for a specific period of time that show a picture of a certain thing, but what you're describing is much larger than what was actually done.
Okay. May I approach, Your Honor?
Yes.
I'm showing you. Okay. May I approach, Your Honor?
Yes.
I'm showing you what's been labeled in.
Like the quality just went so low. Make sure you guys, if you don't know, just wait. Let me just see if you can see this. Go to the toggle, right? The little gear at the, I don't know, wait, hold on. Got to show you. Just in case you don't know, if you ever feel like, why is it so blurry? Or why is it this? Or why is it that? It's a YouTube thing sometimes. You go to the little gear here, click it, playback speed. So if anyone feels like I talk too fast or too slow or too this or to that, go there to the playback speed and adjust it your damn self. But mostly what I want to show you is the quality here. I could just see this quality of this feed. What is going on here? Oh, okay, here. It was like on auto. 480p. Oh my word. What are we back in where? 2000 and what now? Okay, in 2026. 1080p. Thank you very much. Just make sure that yours is on the highest it can go. Obviously, if your data or internet or whatever allows, so that you can watch it in the best quality possible for yourself, right? Okay.
Admitted in evidence as defense 2. This will help us figure out where the money came from. Do you know that Mr. and Mrs. Fernandez had a prenuptial agreement?
No, I've actually not seen this.
No one showed you their prenuptial agreement?
No.
So you're seeing it for the first time?
Yes.
Okay, and one of the disputes that we were just trying to reconcile is whether the Mercedes-Benz money from the Tesla, you were saying, well, it could have circulated back through money that came from the trust. And I was saying, well, you don't know that. And then you answered how you answered. Do you remember that exchange?
Yes.
Okay. In a premarital agreement, you've seen those through your work, right?
Yes.
In premarital agreements, people put some of their assets that they owned before the marriage.
That's correct.
You're not unfamiliar with that policy, right?
That's correct.
This could take a while, guys.
Sorry.
We're 40 minutes behind the live feed as well. Damn.
You agree with me? I'm still reading from the premarital agreement, right?
Yes, sir.
And then this is where Schedule 1, Mario's separate property is. You see that?
Okay.
Do you see it?
Yes.
It says Mario's motor vehicles, correct?
Yes, it does.
And what does it say that Mr. Fernandez owned before he even got into the marriage?
A Toyota Tacoma valued at $32,000 and a Tesla Model S valued at $47,000.
Okay. And the $35,000 that came from Mercedes-Benz was because he sold that Tesla S, correct?
Yes.
So now we know that that did not come from the Shanna Gardner trust or anything to do with the Gardners, because we know it was a premarital asset before he even met Ms. Gardner, correct?
Yes.
Way to get it. Why was the maintenance man at the gym driving a Tesla? Way to get it. What else is he into? Was it from Mr. Biggerstaff?
I just need a moment in between. I want to keep these papers organized, Judge.
No problem.
All right. So you testified that Mr. Fernandez, in the month of April, moved. He had about $4,000 or $5,000 in first choice home rentals in the month of March, right?
Okay.
You said that.
I see the statement you're referring to.
Sure. It's the month before the $50,000 gets moved. It had a balance of 4, 5, 6, 7,000, right?
Somewhere around there, yes.
Okay. And then Mr. Fernandez transferred $50,000 from his own personal account into first choice home rentals, right?
Yes.
But then we also know that that month he bought a $15,000 AC unit for the Potomac address from Bueller Air Conditioning, correct?
Yes.
So he had to transfer money into first choice home rentals or the check would have bounced, correct?
Yes.
And you don't know if Mr. Fernandez knew exactly how much that AC was going to be, right?
I would imagine that there was some type of talk about price prior to, but...
Maybe an estimate, right?
Yes.
Okay. And you don't want to bounce a check ever, right?
No.
Especially if you have plenty of money in one account, there's no reason not to move over to another account to make sure you cover your costs for that month. That's just good financial planning, isn't it?
Yes.
And he also wrote Mr. Tenon $10,000 worth of checks the next month, correct?
Yes.
So besides the $15,000 approximate payment to Bueller and the $10,000 that he paid to Mr. Tenon, that's $25,000 right there, right?
Yes.
And then you said Later, he moved another 2 payments of $5,000 back to the original personal banking account, correct?
They were transferred back, yes.
Right. So when you said, I don't know, I can't think of a reason why he would do that, he overpaid himself from one account to another account to cover monthly expenses. He excess paid what the monthly expenses were, right?
I wouldn't characterize that, no.
How could you characterize it any different? He put $50,000 into an account, and he didn't spend $50,000 that month, did he?
No, he did not.
So he overextended additional funds that weren't needed. You agree with that?
Typically, when you deposit funds from a personal account into a business account, you're making a contribution to your company, and you would receive, we're getting into taxes here, but basically the basis of your company would increase, so you would keep that money the way it is.
Or you could move it back.
Or you could move it back.
And then you just adjust your bookkeeping for the month. That's all that is required there, right?
Yes.
You don't pay taxes monthly. So if he overpaid the account to cover expenses and then he moved the money back, he just moved it right back from where it came from, correct?
It would be unusual to do that, but yes, that's correct.
Unusual to you?
To most people who have a business and conduct different books for their business, yes.
And you know that from your training and experience as a police officer or from your financial planning?
From my financial planning and the tax firm that I own as well.
Okay. And with that information, you think that because he moved excess funds and then moved them right back to the very account, there's something suspicious about that?
I didn't say it was suspicious.
Oh, it's just unusual.
Unusual.
Not suspicious.
Your words.
Not suspicious.
It is an unusual transaction.
That you characterize as not suspicious.
It's unusual.
Nonetheless, when you do all of the things that
We're having a word game battle here. Unusual, not suspicious. No, unusual, but not suspicious. You agree? Unusual. Okay.
just talking about, there's a complete
Strange.
bank record of it, right?
Yes, there is.
Nothing is hidden because all you have to do is subpoena the bank, and it showed every single one of these transactions, unusual or not, correct?
Correct.
Okay. So, around the same time period, there is the Shanna Gardner irrevocable trust, right?
Yes, sir.
This is the trust account, also from States 170.
Yes, sir, that's correct.
Top left corner, the Shanna Gardner Irrevocable Trust.
Yes, sir.
This is prior to the homicide, 11/28 to 2/27.
Yes.
This has an ending balance of $178,000.
Yes, sir.
Identify for me anywhere in this statement. Would you like me to bring it to you?
No, that's all right. I can see that.
Identify for me anywhere in this statement where Mr. Fernandez transferred one single penny to himself.
Well, that's just the balances there.
That's why I asked you. Want to see the whole statement?
Sure.
Okay, let's just speed it up slightly more, shall we? 1.15?
There are two transfers of one for 1,800, one for 1,500 that are transferred to a checking account. Unfortunately, the way that these statements are drafted, it doesn't say which account that it went into.
Okay. Except you've already told this jury that those two accounts were designated for AB and LB, the ones that you just read that from, correct? You asked, Mr. Mizrahi asked you, and you said the two sub-accounts were designated for AB and LB, correct?
I understand what you're saying. I'm just saying the statement does not show which account the money was transferred into. It just shows that there was a transfer of $1,800 and one of $1,500.
Detective, do you still stand by that the accounts that you're referring to are for LB and AB?
You're asking two different questions. Your initial question was, do I see any transfers on the statement?
No. I asked you see any transfers, one single penny, to Mr. Fernandez was my question.
And as I'm saying here, and I'll gladly show you, there are two transfers, one of 12/1 and 12/15, to a checking account. It does not state which checking account they were transferred to.
You're talking about the highlighted.
Yes.
The one. So you're acknowledging to me that you should show me. I highlighted them and sent them to you, correct?
Yes, you did.
Fair enough that I probably know that they're on there?
Yeah.
Can I see it? So let's show the jury so they can see. Back to the same statement, the highlighted portions that I sent over to you. In that particular month, there's 2 transfers, $1,800 and $1,500, and you're saying that you don't know that those are for the benefit of LB and AB?
According to the document that you're showing me, it does not state the account that they were transferred into.
Any reason to believe they went to Mr. Fernandez?
I don't know where they went based upon the document you're showing me.
Okay, so as you sit here today as the lead detective in this case, you don't have any evidence that one single penny went to Mario Fernandez?
No, sir, that is not at all what I said.
Okay, tell the jury, what evidence do you have that one single penny went to Mario Fernandez?
Are you talking about the totality of the, are you talking about the statement? What are you referring to?
This $1,800 and this $1,500. If it went to Mr. Fernandez, you have all of Mr. Fernandez's accounts, detective. You would know exactly if it went into Mr. Fernandez's accounts, wouldn't you?
By looking at other statements, yes.
Do you have any reason to believe that that went into Mr. Fernandez's accounts?
I don't know.
Okay, so the answer is you don't know if any money went to Mr. Fernandez, but can we at least agree if it did, it would be less than $4,000?
Based upon the one statement you're showing me, yes.
I'm talking about, yeah, one statement, just this month, right?
Yes.
Okay. This is the next month, correct?
Yes, sir.
Irrevocable trust, 1228-127, right?
Correct.
This is the month that...
We're definitely going to go over he meant it. Every single statement, everything that the state just showed, yeah, the defense is going to cross on that. Which is their job, I get it, but like, damn.
The balance goes up, right?
Yes, sir.
It doesn't go down. It goes up, meaning there was more deposits than withdrawals, right?
That's correct.
This is the next page. We don't have to guess why it went up. This was the month that the checking account recognized the $75,000 check that Ms. Gardner got from her parents, right?
That's correct.
Okay. May I approach, Your Honor?
Yes, you may throw out.
Can you show me on this statement, the following month, where one single penny went from this account to Mr. Fernandez?
There is not one.
Would you agree with me? This is the next month. Shanna Gardner, irrevocable trust. Can you see that?
Would you mind pulling down here for me? Yep, thank you. Yes.
128 to 227.
Yes, sir.
I haven't skipped any months, have I?
Nope.
You see the balance?
Yes, sir.
253,000.
Yes.
Jim L said, I think there's more financial crime mixed in with this case and they needed a financial guru like the Richens case, right? That could have been helpful, yes.
Bless you.
Can you tell the jury if there's any evidence that Mr. Fernandez got one single penny from the irrevocable trust?
Well, there are no withdrawals. You can tell that right here.
There are no withdrawals, so you know that Mr. Fernandez did not get one single penny.
There were no withdrawals, correct.
Right. So the answer is he got zero pennies.
On that statement, that's correct.
Okay. I've shown you 3 statements so far. One statement, there was a $1,500 and an $1,800 withdrawal, and you don't even know where that went. That's where we're at, right?
Based upon the statement you showed me, that's correct.
Do you think that there's a part of the statement I didn't show you?
The statement does not state where the transaction went to.
Right. So you don't know. I didn't mischaracterize that, right? Right? You don't know where that $1,500 and $1,800 went, right?
Based on the statement, no. I answered the question at least 3 times.
That's why when I said you don't know, I thought you would just agree with me. So now you're at the next monthly statement, detective. Shanna Gardner irrevocable trust,
Yes.
228 to 327. I think that's the one we just looked at. Must be a duplicate. Nope.
Nope.
I'm sorry, this is right. This is the month of the homicide, correct?
Pull down the statement for me a little bit.
Oh, I'm sorry, this is post the homicide. The last statement was during the homicide, correct?
Yes, sir.
All right, so we're on track. I haven't skipped anything. Shanna Gardner's irrevocable trust, 228 to 327. You see it?
Yes, sir.
Show the jury, please, if Mr. Fernandez got one single penny from the irrevocable trust.
There is a $1,500 transfer. There again, the statement does not indicate what checking account it was transferred into.
Okay. So if he did get a penny, it's $1,500, and you agree as you sit here, you have no idea whether he got it or anybody else in the world got it.
The statement doesn't state what checking account was transferred into.
Okay. But you have all of Mr. Fernandez's checking accounts for that exact same time period, right?
Yes, I do.
So you would be able to find out in 2 seconds if that went to Mr. Fernandez, couldn't you?
Yes.
It's the next month.
Poor jury. Shame, shame, jury.
Shanna Gardner irrevocable trust, 328 to 427. You agree with me?
Yes, sir.
Didn't skip a month?
No.
Can you please tell the jury if there's evidence that Mr. Fernandez, the month after the homicide, received one single penny from the irrevocable trust?
There was a $1,000 transfer into a checking account.
You don't know who got it, right?
Not without looking at the corresponding statements.
Oh, boy.
Even if Mr. Fernandez got every single checking transfer that you've identified, we're not even close to $50,000, are we?
No, sir.
We haven't even breached 10,000, have we?
No.
So I was just trying to remind myself, wait, why on earth was Shanna, according to Kim Jensen, working 3 jobs when her parents are so wealthy? And based on what Kim Jensen said, which I posted the interviews, right? It's on the playlist. Shanna was working 3 jobs at Publix, the YMCA, and doing meal prep for people during the period after she filed for divorce from Jared Bridegan and while the divorce and custody proceedings were ongoing. Kim Jensen said that Shanna's parents cut her off financially at that time because they were strongly against the divorce. They are devout members of the LDS or Mormon Church, and they don't support that. And they didn't fully believe Shanna's accounts of how bad the marriage and Jared's behavior was. So as a result, Shanna was left to support herself and the twins on her own for a period and ran herself ragged trying to make ends meet, according to Kim Jensen. So that was before. When she married Mario, then her parents were happy again because she's married again, even though she got married within like 2 months of meeting him, the maintenance man at the gym. Wow. So that's why. So I don't think after that she was working 3 jobs anymore. She was supported by her family and then doing her Beach Baked 904 business, right? Okay.
And this is the irrevocable trust. Irrevocable trust dated 4/28 to 5/27, correct?
Yes, sir.
And you told the jury that Mr. Fernandez and Ms. Gardner had separated at this point?
I believe so, yes.
And where did all the money go?
The money that is in the $257,000 accounts went to new accounts for the kids, just under Ms. Gardner's name. And I know there's a distribution of the rest of the assets, but I couldn't tell you exactly where from the statement.
Any reason to believe that Mr. Fernandez got any of it?
I don't recall exactly how much he got.
The vast majority, like hundreds of thousands of dollars, all went to Ms. Gardner, correct?
Yes, sir.
Any evidence that Mr. Fernandez ever got $50,000 from the irrevocable trust?
Directly?
This time period?
No.
Certainly not a week after the homicide. We've gone through all those statements, right?
Yes.
You haven't been able to identify that Mr. Fernandez moved $50,000 from the irrevocable trust to himself 1 week after the homicide. That's for sure. You have not been able to do that as you sit here this afternoon, correct?
Not based upon those statements, no.
Are there any other statements that I'm not showing you of the irrevocable trust, Detective?
No.
And again, this is the following month of the irrevocable trust, 528 to 627. And now it's down to about $10,204.
Yes, sorry.
That's consistent with all the money being transferred to Ms. Gardner, correct?
Yes.
It never goes back into the irrevocable trust account at Navy Federal. The money never gets back in there, correct?
No.
And it never goes to Mr. Fernandez, correct?
The statement you showed, no.
There are no statements that show the money ever going to Mr. Fernandez, correct?
No.
And you know that because you showed the jury that Miss Gardner would regularly have like $2,000, $3,000, $4,000 in her account when she was in the marriage to Mr. Fernandez, right?
Yes, that's correct. It was a small amount.
Right. And then after Mr. Bridegan died, now we're talking big money, right? Tens of thousands, hundreds of thousands of dollars got transferred.
Was murdered, not died. Was murdered. Okay.
From the account that Mr. Fernandez controlled to Ms. Gardner herself, right?
Yes.
And you have no evidence that Mr. Fernandez was ever on any of the accounts that Ms. Gardner set up when she moved, right?
That's correct.
And you also know that when Mr. Fernandez got arrested, okay, Ms. Gardner had about $500,000 in her bank account, correct?
Something about that, yes. So she had access, not necessarily in her account specifically, but yes, she had access to a significant amount of money.
Way more than she had when she was married to Mr. Fernandez, right?
Yes.
And Mr. Fernandez, in all of his accounts added up when he got arrested, he had about $70,000, correct?
I thought it was closer to 80, but about there.
I'll give it to you, 80,000.
Okay, so they used Mario like Mario used Henry Tenon. Okay.
Significantly less money that he had during the course of the marriage, correct?
That he had access to.
That he had access to, right?
Yes.
So Mr. Fernandez didn't get richer, he got poorer, right?
Yes.
Because he's...
In my opinion, he got baited, he got used, he got love bombed, and then he got discarded. And they're still married to this day.
Divorcing and separating from the Gardner family. He's no longer getting annual gifts, right?
I would not have a way of knowing that.
You do have a way of knowing it because you review...
Who's paying for you, sir? Mr. Defense Attorney? Because you're a private attorney. And Mr. Hill and that whole team. Who's funding that? I'd like to know. Is that the gift he's getting now? I don't know.
Their bank records. He no longer got any annual gifts from the Gardners, Detective, correct?
I don't know what he does and doesn't get anymore.
Okay. But you do know what went into his bank account, and you know he had substantially less money at the time he got arrested, correct?
Yes.
And he was living with his brother in Orlando, nowhere near Mrs. Gardner, correct?
Yes.
So now let's talk about the checks that Mr. Tenon received, right?
Okay.
There were 3 of them. You agree with that?
Yes, sir.
And they were checks that were at the end of March, and one was in early April, right?
The checks were all given to him at the same time.
Well, they weren't cashed at the same time.
That's correct.
Right? So you weren't there when the checks were exchanged, correct?
I wasn't, no.
Okay. And just because the check stubs were in his truck, you don't know that they were given to him at the same day. You're just making that assumption, correct?
It would be highly unusual that the 3 check stub would still be intact, and the checks were not given to him all at the same time.
That's true. So even if they dated differently, March and April, they were given to him on the same damn day.
Unless, as you know, owning your own business, managing other people's businesses, that you can rip one check out, then a second check, and then when the third check comes, you just tear all 3 out and hand it to him. You know that's exactly what can happen. Right, Detective?
I have never seen it happen before.
Of course you haven't. But in this case, you weren't there when that...
Oh, my word. It's like, of course you haven't. That tone, hey, that tone is wild.
When Mr. Fernandez ripped the checks out?
No, it was not.
And although they're on different dates, not one single one of them was cashed the same day, correct?
I think 2 were cash. Excuse me, I apologize. 2 of them were deposited the same day. I think one of them went on hold, and then the other one was deposited later.
Okay. So at that time, let's just get some perspective here. The homicide was February 16th, 2022, right?
Yes, sir.
This is a murder for hire, a solicitation. That's what the jury is trying to figure out here, right?
Yes, sir.
Okay. What evidence of checks or payments do you have that Mr. Fernandez paid Mr. Tenon in November of 2021?
I'm sorry, can you repeat the question?
What evidence of payments do you have that Mr. Fernandez paid Mr. Tenon any money in November of 2021?
There were statements made that indicated that one of them was a payment.
You have 3 payments in March, 2 payments in March and 1 in April. I'm asking you of November of 2021.
There was no payments made that I'm aware of.
No payments from Mr. Fernandez to Mr. Tenon in November of 2021. Will you agree with me?
Yes.
There are no payments that you have any evidence of between Mr. Fernandez to Mr. Tenon in December of 2021, correct?
Unless there was some cash exchange, there's no evidence of that.
You don't have evidence that the cash was exchanged, do you?
No.
What evidence, and you have no evidence, that any financial transactions occurred between Mr. Fernandez and Mr. Tenon in January of 2022, correct?
That's correct.
Okay. So that's the 3 months preceding the homicide, right?
Yes.
And then there's 16 days in the month of February. You have no evidence that Mr. Fernandez paid Mr. Tenon one single nickel in the 16 days preceding the homicide, do you?
Correct.
Okay.
How about after?
Far, you've agreed with me that Mr. Fernandez hasn't paid Mr. Tenon one single penny prior to the homicide, correct?
Unless it was a cash payment. That's correct.
You have no evidence.
Correct. He didn't give him any deposit, okay? It wasn't an official, fancy hitman, okay? He just asked Henry Tenon, and it's like he's going to pay him after, in my opinion. After the homicides, damn, payments being made to Henry Tenon, even though communications stop and his phones are getting factory reset, wiped. He was a contact on Mario's phone and then taken off as a contact, and then he was a tenant, but then unlisted as a tenant, but he was still living there. So, yes, okay.
Stuff, right?
Correct.
So now there's the second half of February, and you have no evidence of any payments that Mr. Fernandez gave Mr. Tenon post the homicide that month, correct?
That's correct.
Then the next month is March. In the month of March, that's when there's all sorts of media articles about this case, correct?
Yes, sir.
The blue truck is released to the media. I think you told this jury March 9th, correct?
It was a little later in March, but it was in March.
Sometime in mid-March, right?
Yes.
That's when, if you were Mr. Tenon and you owned a blue truck, you could be on notice, if you were watching the news, that they may be looking for you, correct?
That's correct.
And it's that same month that Mr. Fernandez writes.
Oh my, it just skipped ahead. How unfortunate. You know how it goes. It does it. Damn it, now we have to find a place, okay?
That's when there's all sorts of media articles about this case, correct?
Yes, sir.
The blue truck is released to the media. I think you told this jury March 9th,
good.
Correct?
There was a little
I found our place real quick.
later in March, but it was in March.
Sometime in mid-March, right?
Yes.
That's when, if you were Mr. Tenon and you owned a blue truck, you could be on notice, if you were watching the news, that they may be looking for you, correct?
That's correct.
And it's that same month that Mr. Fernandez writes a check to Mr. Tenon, correct?
Yes, sir.
And you would agree with me that a check has got to be the most identifiable form of payment that almost exists on planet Earth, right?
Yes, sir.
You have to write your name on it. You have to sign it. It comes from your account. It goes into the person who deposits its account.
Yes, ask Donna Adelson, yes.
All the information we have is right there for anyone
You
to
got
look at
LWOPed.
when you write somebody a check, correct?
That's correct.
And then there's memo lines on the check. And the memo lines are for keeping up with the roof on one and landscaping clearing on another, correct?
That's correct.
And you know, as the chief or the lead investigator in this case, that Sonny Fong, 11 months after the homicide, called Mr. Fernandez, correct?
Yes.
And in that call, he asked if he knew Mr. Tenon, and he said that he did, right?
That's correct.
He didn't deny knowing him, right?
No.
Mr. Fernandez's phone records indicate that he's having communications with Mr. Tenon in January and February and March, correct?
Yes, sir.
Okay. So in the conversation, Mr. Fernandez acknowledges, I paid that guy to do some work for me, right?
I believe you made some kind of comment about him. Yes.
I mean, it'll stand for itself, but as the chief lead detective in this case, you've heard that call. It's in evidence, right?
Yes, sir.
And Mr. Fernandez says, I had him do some tree work for me, right?
Correct.
That's on the memo line, right?
Yes.
He said, I had him help me with the roof, right?
Yes.
That's on the memo line, right?
Yes.
No one in law enforcement has any reason to believe that Mr. Fernandez knew he was being recorded on that line, correct?
That's correct.
Everyone has spoken to Mr. Fong in this case, and he's testified. He said he had no reason to believe he was being recorded on that call, right?
That's correct.
So Mr. Fernandez would have to, 11 months after the homicide, on an unrecorded phone call, or a recorded phone call that he's unaware of, he just happens to identify exactly what he paid Mr. Tenon for via check?
I can't say why Mr. Fernandez said that.
But you do know that Mr. Tenon did legitimate work for Mr. Fernandez. Your investigation revealed that fact, didn't it?
It was stated that the work was done, yes.
Pretty sure Mario's being careful. We already
time-
know that he factory reset his phone, deleted information from the cloud. He did a lot of things, including unlisting Henry Tenon as a tenant, removing him as a contact on his phone long before this wiretapped phone call. So meaning if his friend calls him and asks him questions about the crime, he's gonna be sure to be very careful, in my opinion, and say things that might even help him in the future, in my opinion. Maybe he had a hunch. Oh crap, what if they are wiretapping these calls, right?
In March, Mr. Fernandez had he had access to hundreds of thousands of dollars, correct?
Yes, sir.
$5,000 isn't a great deal of money to Mr. Fernandez at that time, is it?
No, sir.
And in that period of time, he writes him a check, Kickstarter, good luck, right?
That's correct.
You learned through your investigative efforts that Mr. Tenon wanted to start his own pallet company, right?
There were some records that indicated that.
Okay, and I'm going to represent to you that it's in evidence that a week before Mr. Fernandez wrote those checks, Mr. Tenon Googled business plans. Did you know that?
I know there was some Googling of that. I don't remember the exact time frame.
Ms. Day, we went through the notepad where he wrote in his business plan. We already did that exchange, right?
Yes, sir.
Okay, I'll show you the Google in a minute. I just got to find it. It's not in ours.
Yeah, that as well. Studio Taterville.
Give me one.
Did Tenon never really start up his stupid pallet business? I don't think so. No, he did not.
Second. And there was no secret that Mr. Tenon wanted to start his own pallet company, right?
I don't know whether he actually wanted to start a pallet company or not.
Yeah,
Wasn't
and did
making
he?
a whole lot of money in the pallet business, was he?
No, he was not.
It's not uncommon that a person who isn't doing well financially would want to do better financially, is it?
No.
Mr. Tenon had decades of experience in the pallet business, correct?
I don't know specifically how much. I would say that he had some experience in the pallet business.
You went and interviewed people at Modest and Pallets, didn't you? You and your team?
My team did, yes.
Yeah, and he was a good employee, wasn't he?
Yes.
And he had been there a long time.
Yes.
Fair to say Mr. Tenon knew a few things about pallet work.
That's probably true.
Okay? And then it just happens to be that on the poll camera footage, a pallet truck pulls up to the Potomac address and stops. We went through that exercise, didn't we?
Yes.
And then when you took photos of the Potomac address, when you guys searched it, there was stacks of pallets next to the house, weren't there?
I don't recall that. I'm not saying that there wasn't, but I don't recall it.
I'll show you pictures in a second. And Mr. Tenon's business was taking older pallets and fixing them to make them reusable. That's what he did at Modest and Pallets, correct?
Yes.
I'm showing what's Defendant's 58, already put in evidence. Take a second to look at all the Google searches. Mr. Tenon was Googling business plans the week before he received those checks?
Yes.
And then the other part of your investigation was revealed that Mr. Tenon in January, in January of 2022, Mr. Tenon didn't have a lot of money in his account. You went through that and you showed the jury that he would even have overdrawn months, correct?
Yes, sir.
Okay. So that would be consistent with a person who has to go to their landlord and say, I can't afford to live here anymore, right? His bank accounts reflected that he could not afford to pay rent to Mr. Fernandez, right?
I would say the bank accounts afforded that he probably would have a hard time paying his rent.
Okay, so we agree. And that was the time that Mr. Fernandez said, again, on the sunny phone call, I tried to work with him, but he just couldn't come up with the money, so I had to get a new tenant. So that's consistent, correct?
Yes.
Now, you know that there are ways that you can pay somebody via implied payments, meaning you don't actually pay them money, you give them value. You're aware of that, right?
Yes.
In your world, in the fancy business world that you come from, that's called sweat equity, right?
Something like that, yes.
In this
The fancy business world that you come from. What? Okay. That was a court question. Wow, okay.
case, we know that Mr. Tenon was having a hard time paying rent to Mr. Fernandez, correct?
According to what Mr. Fernandez said on the call, yes.
And according to Mr. Tenon's bank records, they're consistent with that, correct?
Yes.
You told the jury that you think the rent payment was around $800 to live at the Potomac address, correct?
Yes.
So if you didn't want to write checks, if you didn't want to have any cash exchanges, you could just let someone live at your house for free, and every month you'd get $800. That's another way to pay somebody, correct?
I don't understand the question.
If Mr. Fernandez wanted Mr. Tenon to do something illegal for him, he could have just said, why don't you stay in my house and don't pay me rent? And every month it'll be as if you got $800. That's another way to pay somebody, correct?
I mean, hypothetically speaking, yes, I guess you could do that.
But that didn't happen in this case. Mr. Tenon left, put his stuff in the garage, and Mr. Ordway moved in.
Did he though? Did he leave?
And Mr. Tenon was still basically living there.
Exactly.
From time to time, but he also stayed at his girlfriend Peanut's house. You learned that during the investigation.
But he was still kind of staying there. And Mario unlisted him as a tenant and deleted his number from his phone. So I don't know if that's helping. Thanks, defense. Again, that might help the state. So it could have been like, oh, if you want to do something for me, you could just live here for free, which is kind of what happened.
Didn't you?
He pretty much stayed at Potomac.
Correct.
I showed you, and I'll do it again if I have to, but you remember when I showed you the address of what Mr. Tenon had put on the pawn shop receipts after?
Yes, we remember. Who cares what address he put on there? He put it on there. Why? Because he knew, don't associate myself with the Potomac address at all. Okay.
He had moved out of Potomac?
Yes, sir.
It wasn't the Potomac address, was it?
No.
It was Peanut's address on Old Kings Avenue, correct?
Yes.
Okay, so he wasn't using the Potomac address anymore after he moved out. He was using Peanut's address.
According to the one slip, yes.
Yeah, I wonder why that is.
Okay, now we've gone through the month of March, and those checks, and then early April, there's the $5,000 check. That's the $10,000, right?
Yes.
No checks in May, correct?
No.
No checks in June, correct?
No.
No checks in July, correct?
No.
Also, no communications anymore after that.
No checks in August, correct?
That's correct.
And Mr. Tenon gets arrested in August.
That's correct.
And there's not a single jail call that you're aware of that you've heard where Mr. Tenon is griping that he never got paid to kill Jared Bridegan, correct?
Correct.
So it's your theory that although you learned that he does legitimate work for Mr. Fernandez, that there's $10,000. That's what he got to kill Jared Bridegan, correct?
Yes.
But you also learned
He might have done it for $10,000. He was extremely financially vulnerable. Extremely vulnerable financially. You know? If the story is, well, they were going to offer him $150,000, sure, but maybe they said, maybe it was 10. We don't actually know what was offered. Any amount of money, I think he would have maybe considered doing it over. Why? Because he really, really needed money. So, I don't know if that helps either, but okay.
that he did tree work and landscaping at his house, right?
There were conversations of that.
And you saw it. You saw work being performed at the house, correct?
Not by Mr. Tenon.
I mean, I showed you a video of him coming out.
So someone who can't pay rent, who Mario might just theoretically just let him live there for free, is just suddenly going to get $10,000 from Mario in handwritten checks. I don't know about that.
Unloading boxes from his trunk, right?
Yes, there was a video of him unloading boxes.
Do you think Mr. Fernandez pays Mr. Tenon to kill somebody, and then he calls up and he's like, come outside and unload the truck of my car? Don't you think Mr. Tenon would own Mr. Fernandez at that point?
I can't speak to Mr. Tenon's mind or what he did or didn't do as far as that's concerned.
if it was represented to this jury that Mr. Tenon should be dead to them, Mr. Tenon's not dead right now, is he?
No.
He's very much alive, isn't he?
Yes.
May I have a moment, Your Honor?
Yes.
And I don't know if you want to take, when I am done, I'm going to need like 2 minutes to
Okay.
repack, organize those documents.
Shame, Detective Johns. You've been through it with a cross in this case. Can hear a pin drop in that
There was a
courtroom.
$10,000 cash withdrawal from Mr. Fernandez's accounts you talked to the jury about?
Yes, sir.
And then to show that Mr. Tenon would get cash, he would deposit cash into his account, correct?
There were cash deposits into his account.
Any reason to believe there's a single transaction where Mr. Tenon deposits $10,000 worth of cash?
No, sir.
$9,000 worth of cash?
No, sir.
$8,000 worth of cash?
No, sir.
$7,000 worth of cash?
No, sir.
$6,000 worth of cash?
They were all smaller deposits under $600.
That you have no idea where they came from, correct?
No.
Mr. Tenon was a handy guy, right?
Yes.
Not making a lot of money at Modeston Palace, correct?
That's correct.
So if he went around, he did odd jobs for people and got cash, that wouldn't shock you?
No.
Okay, so that's where that money could have come from, correct?
I don't know where the money came from, unfortunately.
Yeah, you certainly don't know that it came from Mr. Fernandez, right?
Correct.
And there's no huge increase. Let's say the month that the $10,000 cash withdrawal, did you get any evidence that all of a sudden Mr. Tenon did something that was financially out of his reach, like went to Vegas for the weekend?
No, sir.
Went to the Keys?
No.
Took and bought himself a new car?
No.
Not a single thing that would match that a person didn't deposit cash, but all of a sudden got a huge influx of cash. You have no evidence to believe Mr. Tenon got a huge influx of cash, did you?
No.
In fact, what you do know is
pulling my
that
banner.
Mr. Tenon owned a Ford F-150 that was blue in color, that was previously owned by his father, and he couldn't even get the timing belt fixed because he left it at Jimmy Jones's house and didn't have the money to get it fixed, correct?
That's correct.
But he
I
also
don't have
wouldn't want
anything further,
to.
Your Honor. I just need a minute.
At that point, he probably also wouldn't want to and probably was instructed not to. That's speculation because we don't know, but hiding a whole ass car when you don't have anything. I don't know about that, man. Shady stuff.
Clean up.
Okay. Any redirect of the witness? Okay. And just give him a moment.
I will. Mr. Dryshaw, I'll need defense 2, please.
Okay, Mr. Prosecutor, you better bring it home.
Detective Johns, could you explain to the jury how what they have seen is just a small snapshot of the potential financial records or financial transactions that would exist in the entire world with regard to these people?
We only collected a few months period of time that was around before and after the homicide. It does not paint a full picture of the amount of financial benefit that someone would have received during the course of their marriage.
And are there ways that people can make financial transactions that would not appear in bank records?
Yes.
Can you hand each other things of value?
Yes.
Jewelry, cash, anything else?
All kinds of things that are worth something that could be sold later that aren't going to be recorded.
The bank accounts you did receive were the bank accounts that we were able to find out about in subpoena.
Yes.
Could there be other bank accounts that we never found out about?
Yes.
So it's just a small snapshot of the financial records.
That's correct.
Okay. Because the defense asked you questions about there was only the $10,000 in checks, but we also see that Mr. Tenon deposited, although not $10,000 worth of cash, hundreds and hundreds of dollars worth of cash.
Yes, that's correct.
And certainly it's possible that he did handyman jobs, and it's certainly possible that he got it from Mr. Fernandez. We just don't know.
That's correct.
The defense asked you about jail calls, and are all inmate calls recorded?
I'm not sure.
Are you aware of the fact that the jail tells the inmates if they use jail calls that their calls are monitored and recorded?
Yes, that's true.
So if a defendant got on the jail calls after being told that they're being monitored and recorded and said, I'm upset I didn't get my payment for murder for hire, that person would be potentially confessing.
That's accurate.
During the review of all the records in this particular case, did you see any other $5,000 checks that this defendant wrote to any charitable organizations?
No, sir.
Any investments in any other Kickstarters?
No, sir.
Anything that could be classified as trying to help another person?
No, sir.
He saw payments to himself and to his business interests.
Correct.
The defense asked you lots of questions about whether or not the defendant got any money from the trust account. But the defendant, did he get money directly from the Gardners, meaning parents, his in-laws?
Yes.
And that was, we know, at least $75,000 because we saw that check.
That's correct.
Okay. He also got over $300,000 from the marital home.
Yes, sir.
That's a lot of money.
It is.
Let's go over with what the defense counsel spent a lot of time discussing was a prenuptial agreement. Do you remember that?
Yes, sir.
What is the title of this agreement?
It is a postnuptial agreement.
Not pre.
Correct.
Post.
Yes.
What's the date that the parties were married?
I actually don't remember the exact date.
Oh, it's on there.
Oh, sorry. April 13th, 2018.
April 13th, 2018.
Okay.
Let's look
Yeah, let's.
at page 12. The execution of that document?
October 15th, 2019.
That's way after their marriage date.
Yes, sir.
Do we have any idea what cars were transferred in the first 18 months of that agreement? Or 14 months, 16 months?
No, sir.
Could have been the Tesla.
It could have.
Mario's bank accounts. Can you read those into the records? That was written in the post-nuptial agreement?
USAA, $1,463.37. And then two Navy Federal accounts, one for $3,552.32, and the other for $4,000, it's either a 3 or an 8, 44 or 22.
And then back to that page 1 of defense 2. Can you read into record the incomes of Mario Enrique Fernandez and Shanna Gardner?
Mario Fernandez is indicated that he's self-employed and makes approximately $28,000 a year. And Shanna Gardner also indicates that she's self-employed and makes approximately $36,000 a year.
I think you explained this, but I want to give you an opportunity to make it more clear. Why, in your opinion, did Mr. Tenon receive the 3 checks on the same day, even though he deposited them on separate days?
Camera person, please, man. We don't need to see the Elmo with nothing on it.
I think this is directly in response to cross-examination questions.
Respond to the objection. What's the foundation for the opinion?
Well, he crossed him on whether or not it was the same day. He crossed him. I mean, he crossed him on this.
I'll allow you to rephrase then.
Explain to this jury how the check stubs were recovered in Henry Tenon's Fiat truck.
The check stubs or the checks in general are a business-style printed page check. There's 3 checks to a page typically, and there's stubs. The stubs were found intact inside Mr. Tenon's truck.
And those have been made in evidence, so the jury will get to see it. We talked a little bit on cross-examination about the surreptitious phone call between this defendant and Mr. Fung.
Yes, sir.
And nowhere in that call does the defendant indicate that he gave $5,000 to Henry Tenon as a Kickstarter.
No, sir.
That's not mentioned.
No.
That's all the questions I have.
And state point out that Mario said he got an estimate and it would be $3,000 to cut down a tree, and then he decided to rather hire Henry. But then if you're going to give him $10,000 for the work, then your argument makes no sense. You got to make that clear for the jury, right? I really feel like this prosecutor is, I said it earlier, Stefan said it now as well. He's got a complacent attitude. I don't know. Don't be so sure of yourself, sir. This is definitely not a slam dunk. You gotta really make it loud and clear.
Anything further for this witness?
Is that okay, Your Honor?
Okay.
In that postnuptial agreement, Mr. Fernandez, it was stated that he made $36,000 a year when they signed that postnuptial agreement. Is that correct?
$28,000.
Exactly,
$28,000?
Yes, sir.
Yes.
You agree with me that would be $28,000 more than Jared Bridegan made during the course of his marriage to Shanna Gardner, correct?
I'm about to put my middle finger up. Wow, defense, you went low, hey? You went so low. More, $28,000 more than Jared Bridegan made. Why? Because Jared Bridegan was studying. Apparently, Shanna's parents paid for his studies. But he was studying, and that's eventually he became this Microsoft executive, right? Anyway, you're gonna throw shade at the murdered victim right now, financially. What?
Okay. I'll sustain it.
You sit down.
You want to be
Get him
heard?
sit down.
I'll hear you at sidebar.
Okay, thank you.
Oh my word. I mean, for whatever reason, you know, Jared was studying. I don't know. I can't remember what he was doing before that or how old they were, all of that. But like, okay. Yeah, no. Even if Jared made $0 in the marriage, Shanna's parents funded all that. Shanna's parents have funded her life as long as she lives by their principles. Like, be married and stay married, and then we'll give you hundreds of thousands of dollars. If you're not married, we'll take that away. If you're still entangled with Jared Bridegan, we're going to cut you off. And you will only have this trust, control of this trust, if you... It's like a lot of very, very interesting expectations. Okay, what do we have going on now?
Married to Miss Gardner.
Stop it. Sidebar. There's sidebar going on. I think Jared had an MBA, but I think Shanna's parents funded it. I think that they funded his studies from what I remember reading. I think Kim Jensen also said that in her interviews, right?
One moment. So just for the record, I'm allowing Mr. Dreiser to rephrase this question. Go ahead.
In the postnuptial agreement, Mr. Fernandez did in fact have an income, correct?
Yes, sir.
And when Jared Bridegan was married to Miss Gardner, he did not have an income, correct?
I'm not aware of any jobs he did or didn't work.
You already answered my question earlier. You said you knew that he did not work when he was married to Miss Gardner.
I know that the Gardners provided income and education expenses for their children and their spouses.
Thank you. No further questions.
All right. May the
Right. I feel like he went to Utah Valley University, but he graduated in 2014 with a degree in digital media, and they got divorced in 2015. So yeah, I think Shanna's parents funded that, because Kim Jensen was saying that she thought that Jared had a type, which was rich girls, rich women, right? People from rich families, okay. And that he would then just study and study and study so that he could just be at home. Michelle L., thank you for the 3 Mama Bear coffees. Right? So that he could just like be at home. And she made like that's lazy, but I don't think that's lazy. I think it's like brainy and studying. Getting the opportunity to study a lot to be the expert that he eventually was. I don't think that's a bad thing, especially if Shanna's parents offered that. And if he has a type, then so does Shanna. You know what I mean? She likes people she can control. Not? You know what I mean? But I don't think there was any reason to go there.
Witness be excused, or do you want to?
I have to ask one more question.
Okay, go ahead.
Were you aware that Mr. Bridegan was in school during the marriage and learning?
Yes, sir.
That's all the questions I have.
May the witness be excused.
Yes.
No recall?
Oh, he is subject to recall.
Okay. Stay in contact with the lawyers.
Okay. What else we got going on here? Ooh. Is that a break?
We'll
What's
call
going
your
on?
next witness.
Your Honor, the state rests.
Oh my word. The state rests, you guys. Okay, let me just write this timestamp down. Sorry. Normally I feel excited. Do you think he's going to get convicted? Sometimes it's scary to see how people get convicted on circumstantial evidence. There's a lot here. There's a lot to work with, but also not. At the same time, also not. Let's just write down here the state rest so I can make sure I put in the timestamps for you guys. I don't like it. If he walks, I'm not going to be surprised. Let me say it like that. A mistrial? A hung jury? Okay. Convicted. Like sending this guy away for the rest of his life over what the state showed? I don't think so. Would you feel comfortable if you were on the jury and you know what we just heard at the trial, okay? Know of the other deep dives and documents and other contexts we have. They haven't seen Shanna Gardner. They don't know that Henry Tenon confessed. They don't know that he pleaded guilty and then took that back out of, they don't know any of that. Okay, so just based on what the jury saw, if I was in their shoes, no freaking way I'm going to be like, yep, send this guy away for the rest of his freaking life. Based on this. Based on what? Shady checks, sure. Not presented well by the state, in my opinion. Checks? Mr. Biggerstaff? Ooh. I just think there's a lot of speculation. Can you really say... Wait, I should do a poll, right? Hold on. Let's do a poll. Let's first listen to what they're saying here quickly.
Members of the jury, the state of Florida has rested its case. That's going to require me to have a meeting with the attorneys outside of your presence. And right now, we'll call it 4 o'clock. So we're going to recess for your purposes for the evening, okay? We will come back tomorrow again at 9 a.m., all right? So leave your notepads on your chair, please, and follow the communication rules. Have a nice evening.
Oh, my word. Okay, okay. Jury's going home. That day just escalated quickly. I'm asking you a simple yes or no question. Don't base it on anything that you may have known before the case. I want to know, if you put yourself in the shoes of the jury, can you convict this man? Can you send Mario Fernandez away for life? I mean, that's so crazy. So would you convict Mario based on what the jury saw? Yes or no? 50%, 56% so far say yes, 44% say no. I know it also can depend on how closing arguments on evidence, but it depends on, will the defense put on a case? How will the closing arguments go? The burden is not on the defense. I wouldn't feel comfortable. I feel already quite comfortable being like, Shanna's going down. Henry Tenon is going all the way down. Henry Tenon is screwed. Mario, they don't even have evidence that he drove the truck. We just suspect so. Because why is it close to his house? There's many questions. There's many coincidences. I'm not going to be like, yes, guilty based on coincidences. I don't think so. I'm voting no. If you vote yes, tell me in chat why.
All right, everyone may be seated.
If you say, okay, would you convict Mario based on what the jury saw? If you answer yes, actually any answer you get, whatever, if you're voting yes or no, tell me why, especially yes. If yes, why? Yeah, Stefan said the problem started when Tenon withdrew his plea deal. That's if Henry Tenon had testified against Mario, that would have been epic. Because he would just be up there and it would be up to the jury if they believe him or not. But if he had said, well, I worked with Mario, I stayed at this property, and he made me an offer I couldn't refuse. I was financially vulnerable. And so I thought about it and thought, yeah, well, I really need that money. So he had everything worked out, and I had to put the tire in the road and, yeah, shoot Jared in the back. Wow. I don't know who the hell would do that anyway, but if Henry Tenon said all that, if he said, yes, I admit to it, I pleaded guilty, correct, all of that, there's a plea agreement, but let me tell you everything that happened, that would have been great. So who threatened Henry Tenon, huh? Why is he sure they took the death penalty off the table at some point for all three? Especially after Henry Tenon. See, Henry Tenon pleaded guilty based on a plea agreement. And then for the other two, so he was going to be sentenced to 15 to life. He just had to testify against them. It was going to be a joint trial, and they decided to take the death penalty off the table because of the victim's family. I think they were okay with it not being on the table, and then the prosecutor said then it would speed things up a bit. Something like that. Okay, so I'm going to read your comments here.
Please let the record reflect that the jury's left the courtroom. Mr. Dreiser.
Your Honor.
Oh, Mr. Hill, sorry.
Good afternoon. Your Honor, on behalf of Mr. Fernandez, number one, we would renew all previously filed motions with no additional argument to those motions, but this time we would be making motions to count one and count two for a judgment of acquittal. And if I may, I'll take a few minutes with these. As the court is well aware, judgment of acquittal is pursuant to Rule 3.380. If the close of the evidence for the state or at the close of all evidence in the case, the court is of the opinion that the evidence is insufficient to warrant a conviction, it may, on the motion of the prosecution or the defendant, enter a judgment of acquittal. And as the the court is well aware, that standard changed in 2020 pursuant to Bush v. State 295, Southern 3rd, 179 out of the Florida Supreme Court. Whether the state presented competent, substantial evidence from which a rational trier of fact could find the existence of the elements of the crime beyond a reasonable doubt, viewing the evidence in the light most favorable to the state. So I want to start with count two, the solicitation, Your Honor. The state is required to prove the defendant commanded, encouraged, hired, or requested another person, in this case Henry Tenon, specifically from November 1st of 2021 to February 16th of 2022, requested Henry Tenon with the present intent that the other person actually carry out the offense. As the state has in their case, it's not necessary for the defendant, Mr. Fernandez, to do anything in furtherance of the offense. However, to solicit means to ask earnestly or to...
I'm so sorry to pause him there. Mama Rose said there's no motive for Henry to do it. I agree with you, but what if one were to say, but Shanna, because there is, from all the court documents, there's so many, there's like thousands. Somewhere in there I'd read that there is evidence that Shanna knew Henry Tenon. Maybe there's communication. Maybe she organized it. Maybe she drove the truck that night. We don't know. I know about the checks. I get that. But I think the checks do involve him. It does. I think the checks are still the strongest evidence, but without Henry testifying, you know?
Induce another person to engage in that contact. So the definition of earnestly means a serious manner, not lightly, casually, or flippantly. The statute requires, there is no affirmative defense that we have alleged. However, it does require an affirmative communicative act, a command, encouragement, hiring, or request directed at another person. I would point out that the state has not submitted any evidence to the jury of that affirmative communicative act. There's been no testimony that Mr. Fernandez has said a word of encouragement, a text message, an email, or any other act that would actually support that he solicited Henry Tenon. And I point to several different cases that specifically are on point, which is in order to show the present intent, and that would be the Florida Bar versus Marable, 645 Southern 2nd, 438.
Slow down. 645 Southern 2nd.
Yep, and I'm going to email those cases to you at this moment, Your Honor, as well as to the state. In that sense, so you'll have an electronic copy of all case law. Bear with me, Your Honor. I'll give you that exact citation. That was 645 Southern 2nd, 438, 1994. And it was Marable, M-A-R-A-B-L-E, which establishes that present intent is required, meaning that Mr. Fernandez would have to have the present intent in addition to the solicitation and the communicative act in order to be found guilty and sustain a conviction for solicitation to commit a capital felony. In addition, Palumco, P-U-M-B-L-A-N-C-O, v. State, which is 111 Southern 3rd, 249 out of the 5th DCA, and that was 2013. In addition, State v. Gaines, 431 Southern 2nd, 736, 4th DCA, 1983. That actually established what's considered the Gaines standard. In order to support, there has to be a present intent. In that case, a particular person, their conviction was overturned when they expressed a desire for this to happen in the future, but they did not actually formalize that solicitation. And the court found that that person did not have the present intent for the crime to actually have occurred. Additionally, Your Honor, Jones v. State, 908 Southern 2nd, 615 out of the 4th DCA, which is 2005, requires guilty knowledge or mens rea on behalf of the defendant. I would just point out that there's been no witness who has testified, number one, of any evidence of the actual earnestly requested solicitation by Mr. Fernandez to Henry Tenon during the time period alleged, and simply having that relationship in and of itself with Mr. Tenon is found to be insufficient to sustain that conviction.
Sorry for interrupting again. Joe Hoffman said, enough for a reasonable person to convict with circumstances. I mean, could be. Court Lucas said, why on earth would Henry just want to kill Jared? Makes no sense. I don't think just. I think, what if it was Shanna? What if Shanna wrote the checks? There wasn't even a handwriting analyst here in this trial. I know we saw the other checks, but it's also, you know, it's a link to the trust and Mario and Shanna and all this. What if it was Shanna? There's one other person involved, right? Shanna. That's what I'm saying.
No evidence of encouragement. There's no evidence that Mario Fernandez hired Henry Tenon to commit this homicide. Even in the light most favorable to the state, the checks that have been presented by way of Detective Johns and Miss Lindsay Butler are post the time period of which the state has charged Mr. Fernandez. There's been no testimony that those were actually for the homicide. There's been evidence submitted that Mr. Tenon completed legitimate work by way of the recorded phone call and the poll cameras that are in evidence as well. Additionally, with regards to count 1, as a principle, murder in the first degree, there again has been no evidence of the intent. There has to be a communicative act to show that Mr. Fernandez had an intent for this crime to occur. Having a not positive relationship, if the state were to rely on the interview of Mr. Fernandez, where he clearly states that him and Mr. Bridegan didn't have the best relationship, that in and of itself is not sufficient evidence to submit to the jury that Mr. Fernandez had the intent that Jared Bridegan be murdered. Additionally, the second element, as a principle, that the defendant did some act or said something, again, a communicative act, or did some act that was intended to and did incite, cause, encourage, assist, or advise the other person or persons to actually commit the crime. There has been no evidence at all to establish Mr. Fernandez's intent. Nothing to be submitted to this jury, either for the solicitation or for the murder in first degree as a principle. As the state conceded, Henry Tenon is who they believe to have actually committed the homicide, not Mr. Fernandez. That is why they have submitted the principal instruction. Again, simply having that relationship with Mr. Tenon does not carry the day. With regards to element 2, we've heard no evidence of any incitement, cause, encourage, assist, or advise the other person to actually commit the crime. And I would draw the court's attention to a case that's so close to being on point. It's in essence a man killing the husband of the woman he was having an affair, and that's Williams v. State, 314 Southern 3rd, 775. That is a first DCA case from 2021. That proof of a relationship alone with the perpetrator is not enough. There must be proof of some overt act or words uttered in furtherance of the scheme that led to the murder, and where no such evidence exists, a motion for judgment of acquittal must be granted.
Pause. Grayson's Journey said, I don't think it's reasonable to think all of this is a coincidence. Neither do I, but it could all point to Shanna. Do you know what I mean? Imagine if it's all Shanna's doing. Maybe Shanna and her parents, I don't know. True Crime for Me said, you're right, gee, Shanna could have written the checks. I mean, we don't know. Even if the truck was close to the house and all of the stuff that we know, the map time coincidences, the Biggerstaff, that all of this, Shanna, it could be Shanna. Shanna's trial is next, yes. Bianca T, starting with opening statements on September 8th. Of course, before that is jury selection, but opening statements are planned for September 8th.
Under Penny v. State, which is 421 Southern 3rd, 476, out of the second DCA of 2025, in order to be a principal in a crime, one must have a conscious intent that the crime be done and do some act or say some word which was intended to and does incite, cause, encourage, assist, or advise another person to actually commit the crime. The one other point I would establish is that v. Coxwell v. State, 397 Southern 2nd, 335, 1981, establishes that both the principle for first-degree murder and solicitation both require the same communicative act in order to establish the intent, as well as with count 2, the actual solicitation. This means that solicitation charges and the principal liability charge both require the same proof of the communicative act, the act of counsel, procurement, or instigation. Where the state has submitted no evidence of that act, both charges fail simultaneously. The absence of any evidence of the communicative act, therefore, is fatal to both the solicitation charge as well as the principal liability charge. There's been no evidence submitted. I would argue contrary evidence that Mr. Fernandez had any motive to commit this crime, much less any intent that was submitted into evidence. There has been no testimony whatsoever to establish the intent element, certainly no evidence of communications that support the intent or an overt act. And mere association with or proximity to the perpetrator is insufficient to establish principle. Applies to both murder as well as, by principle and solicitation. In every Florida case, a solicitation conviction has been sustained. There has been some form of evidence of the communicative act. I draw the court's attention to Castro v. State, 939 Southern 2nd, 306, 4th DCA 2006, where an ex-husband sought to have the ex-wife murdered by a hitman. The defendant communicated with an undercover FBI agent, recorded conversations, communicating desire and intent to have the ex-wife killed. Robinson v. State, 267 Southern 3rd.
Just pause. You're just citing lots of cases, of course, now in this judgment of acquittal motion. The jury's gone home. The state has rested already. Wow. Okay. I wanted to say something and now I just forgot. It just left my mind. It's just like, wait, empty brain. What was I going to say? Oh, I was going to say this. Do I think that Mario was involved? Yes. Do I think he was driving the truck that night? Yup. Do I think the checks are sus as hell? Uh-huh. And his Biggerstaff connections? Yes, they're freaking shady as hell and all of that. I'm just saying, can the jury convict him? Because even if someone is not convicted, if they are acquitted, it doesn't always mean that they are, in the court of public opinion, innocent. They may have done it, it's just that the state proved that they did it. That's what I'm saying. I'm saying, do you think the state has proven their case beyond a reasonable doubt? Because just because Henry Tenon was separated from the truck does not mean that he didn't have another friend helping him drive the truck. He could have had anyone. We have no idea. It could have been any other guy, any lady, anybody driving with him that night. Now, the cell phone evidence is interesting. The cell phone mapping, that was interesting. Where there's no cameras. The dry run, the timing of everything. The digital forensic evidence is strong against Mario. The 3 handwritten checks is very unusual. And I think the timing of the marriage and the, not even divorce, just the separation, just the way that Shanna packed up and left after using Mario, in my opinion, that's so strange. Okay, so, yeah. Evergreen said, how did Henry get the Biggerstaff's gun? Well, because Mr. Biggerstaff had gone to that property before and knew Henry as well, right?
567, first DCA 2019. Defendant clearly and repeatedly expressed present intent to commit first-degree murder. Hudson v. State, 368 Southern 3rd, 70, first DCA 2019. Jail phone recordings providing victim's address to gang members and relief the victim had died. Those three cases are where the convictions had been sustained because of the communicative act that was recorded or ultimately testified to.
I might be familiar with the Hudson case.
That might have been your case. I didn't see that.
Oh, I was like, I might have been familiar with that. You're citing one of my cases. Janet Murphy said the maps were very incriminating. Also, I don't think the state has proven for sure that a 10mm Glock that John Biggerstaff bought or had or whatever in 2015 or 2016 was definitely the gun used in the murder. Do you know what I mean? There's a lot of holes. I think there's some reasonable doubt, even though personally, I mean for the jury. Do I think that Mario did it? Yep. I think he's involved, but like, is he going to get convicted? I don't know. I'm not confident. Let me say it like that. I am not confident that he'll get convicted. But then again, I wasn't confident about Donna Adelson, even though with the checks, and I wasn't confident about Matthew Paul either. Ooh, that was a big circumstantial case, hey? That was so crazy, oh my word. They got convicted, so okay. But I don't feel very confident in the state's case. That's in this round. I don't know if it'll get better with Shanna or not, but oh dear. And they do watch the chats often. They have someone assigned to watch it, so I hope they are watching and know. No, I don't think a lot of us feel confident, right? Let's see what your poll results said. Would you convict Mario based on what the jury saw? 60% say yes, 40% said no.
You won't have to read that one. Okay. By contrast, there has been no evidence of any communicative act by the defendant to Henry Tenon, who is charged in this case as far as the solicitation. There has been no evidence that Mr. Fernandez asked earnestly as required by the statute. No competent substantial evidence. Maybe evidence that the defendant learned after the murder, but no evidence of prior knowledge or conscious intent. And one further argument, Your Honor, is that the state is prevented from inference stacking. The state is seeking to simply stack inferences and may get up and argue that this is somehow putting pieces of a puzzle together by way of circumstantial evidence. However, the Florida Supreme Court ruled in J.O.A. v. State, 961 Southern 2nd, 198, in 2007, its well-established evidentiary principle bars a criminal conviction when the fact finder must draw an inference from another inference rather than from admitted evidence, and it remains in place even after the J.O.A. standard was changed by Bush v. State. This is not assembling pieces of a puzzle via circumstantial evidence, Your Honor. Based upon that argument in the case law, we would move for a judgment of acquittal on count 1 and count 2.
Okay. Can you give me just a moment? I'm trying to catch up. Did you send that?
I sent it to you.
You sent it to my judicial assistant?
I did, Your Honor.
Can you send it to me?
I can.
Thanks. The Williams case, that's a duck hunting case.
Your Honor, admittedly, I don't have your email address, but your J.A. just indicated she received it.
Okay.
I'll ask
well,
her.
I don't know. Well, she'll send it then. Thank you.
Okay, let me answer some. Diane Watson said, Tenon didn't even know Jared at all, so who organized the hit? Shanna. As a different theory. Maybe the jury doesn't know much about Shanna Gardner right now. They could think, well, why wouldn't the ex-wife? Did the ex-wife, maybe there's a possibility that she was in contact with Henry Tenon. Maybe she was there sometimes when work was being done. We don't know that. But especially the jury doesn't know that. Do you know what I mean? again, we're not arguing with each other, right? We're all just like talking about what is your opinion. Do you think the state did enough? And sometimes on social media, that's when cases can go really crazy, is when there's layered arguments. Like, is the person innocent of the crime completely? They've got the wrong person or not? That's one argument. Or does the state deserve to win the case? That's a whole different argument. I mostly argue that one. Like, did the state bring it? I don't know about this one, about this case. Evergreen said, so Henry just decided to put a tire in the road and randomly kill Jared? Not randomly. Shanna's involved as much as Mario's involved, in my opinion, meaning if the jury has any doubts about Mario, this is the only defendant that they've got to vote on. They have to decide if they're going to send Mario away for life or not. Are they going to convict him of first-degree murder and solicitation to commit first-degree murder or not? I don't know. They might have questions about what about Shanna, the ex-wife? What about Shanna? Maybe she really hated her ex-husband and wanted him killed, and maybe she had Henry hired. We don't know. We don't even know if she was involved in the swinger lifestyle or not. And if Mario was shown by cell phone mapping to be at the Potomac residence at Juan Biggerstaff's house before the murder and on the day of and all this, we know that he was having sex with Juan Biggerstaff's wife. So I just wonder if there's any jurors that will try to, like, in their mind, explain that away. Be like, well, he was there to bang. They were there to do tile work. They were there to, and where is the gun really? Because they don't know. We don't even know. We know what Henry Tenon said, and we know that the Biggerstaffs are saying very strange things about the guns, and serial numbers are being miswritten and things, but still, I just think there's so many questions, right? So does the state deserve to win the case? Is probably more of my question. Sometimes I feel no. And sometimes, you know, like, okay, let's not go down a big rabbit hole, but it's kind of like that. I know everyone has mixed opinions about this, okay? I think he's very, very guilty, but like people have huge debates about Brian Koberger, right? The Idaho case. There, I think the same question applies. Does the state deserve that? No. The investigation, the state and everything, no. But do I think he's super guilty? Yeah, and thank goodness he pleaded guilty. They sure offered him that, and he's like, I'll take it. Okay, that's my opinion. That's my opinion. Does the state deserve that conviction in that case based on the investigation and everything? Probably not. And then it gets like crazy online, you know what I mean? Here as well, I'm like, the state absolutely, did they, without Henry Tenon, I know it's hard because they were planning to have him on the stand. But is Mario involved? Probably yes. Did the state bring it to the level of, yeah, let's send this guy away for life? I don't know about that. Who knows what the jury will decide? It's really an unknown. I can't say that, yes, I really think they're going to find him guilty. I don't know. Yeah, Stacy said it sucks he backed out, but the way he backed out was super sus, and someone got Henry a new lawyer. Provocative. And Henry's got private attorneys, by the way. So does Mario. The question is, who's funding that? We might have a hunch. And now they've separated the trials too. Man. Does it make sense what I'm saying? Yes. LaSusie said, where is Brad Bloodworth to do a closing statement? Right? Georgia Kappelman? Cody Womp? That's what we're going to need on this case. That would be amazing. I think it's the same prosecutors and the same judge, yes, on the case for Shanna Gardner. It's just she's got Jose Baez and his team. Oh, crap. Oh, my word. This is like taking forever. Are we there yet? Ma'am?
Essentially,
okay, wait.
is guilty of both charges.
Hey. Here we go. And then court ends, so don't worry. We've not got much left at all.
Okay, I'm ready to hear from the state.
Yes, Your Honor, I appreciate the defense counsel bringing up the new standard in Bush because they spent the vast majority of their argument speaking about direct evidence that's required to prove a particular crime. Obviously, the state has put forth a substantial amount of circumstantial evidence to prove this defendant is guilty of both charges. It begins with 1,000 different facts that distinguish it from the Williams case, including that the Williams case specifically had a co-defendant that specifically provided testimony, essentially exculpating the defendant by saying, well, she didn't really help me plan the murder. We did talk about it, but I did it on my own. In this particular case, the only link between the stipulated shooter and the victim is this defendant. It's his tenant. This defendant had a motive that we spent a lot of time putting forth evidence of. This defendant had access to the 10mm firearm that was eventually potentially used in this case.
Potentially. You don't know that that's the gun that was used in this case at all. You don't know that at all. You know it's just 10mm, but you don't know that it's the Biggerstaff's one. You just said potentially, sir. And also, if Shanna's able to use a maintenance man, marry him, have him parent her children, I think she could use Henry Tenon if she wanted to. She is known to use people. Do you know what I'm saying? That was proven as well. I would like to prosecute Shanna Gardner's case, please. Can I please? I'm not a lawyer, for those who are new here. I just dream about that. Could I prosecute her case? Thank you so much.
This defendant had a consciousness of guilt after the fact by deleting text messages and resetting his phone so things could not be discovered. This defendant's tenant went on a dry run all the way to the victim's home, all the way to the crime scene, and then back to the rental home where this defendant was. This defendant paid the stipulated shooter for what a reasonable juror could believe was payment for the homicide. Again, doesn't require specific direct evidence of the payment, merely that a rational finder of fact could find that that was paid for the homicide in context of all the payments made to all his different business ventures in those phone records, in those financial records. The outlier of Henry Tenon's $10,000 is stark and shocking, and a reasonable trier of fact could see that that was payment for the homicide. So in the totality of all the evidence, it's very distinguishable from Williams. There is competent, substantial evidence in multiple different arenas that this defendant was the link, the hub of all the spokes that ended up with this victim dead. And if the court has any specific questions or any specific things we need to talk about, I can certainly answer those questions, but I think there is competent, substantial evidence. And I'll point out that the solicitation in all those cases, the act itself didn't happen. You're just talking about to an undercover police officer, so you have the solicitation going on. Here, the act happened, so you don't have to worry about whether or not there was an earnest ask, since the earnest ask ended up in the victim's murder.
So the defense points out that there's a lack of evidence related to, even viewing the evidence in the light most favorable to the state, of any communication for the solicitation.
Sure.
I can go down the elements, but...
Well, the communication...
Also, I don't at all mean that in any arrogant way, because some people, like, you guys are sweet, but you're like, maybe you could, like, send the defense your presentation. I don't know as much as they know about the case. They know the case backwards, but sometimes what that leads to is just an observation from the peanut gallery, which sometimes they might find helpful if they have someone watching. Okay, it's just the peanut gallery might think that they might be handling it in a little bit of a more complacent manner than we expected, because this is absolutely not a slam dunk. I like to risk assess, and I see a risk here in not getting the conviction based on what we've seen so far. That's all. I see risk, and I'm like, I don't know about that. I don't know about that, because there could be other explanations. If it's this potential and that potential and this, yes, circumstantial evidence does convict a lot of people. It does all come together real nicely. But the thing is, there's a lot of questions here. And if I were Mario's defense, I would totally blame Shanna all the way. I would throw her so right under the bus, man. Shanna's probably going to do the same. They can't only point at Henry Tenon either, because, like, okay, we all know that, but what motivated him? Who motivated him, and why? Why would he do that? We can see him on the surveillance. We can see the truck that he was driving, and we can see that they eventually found the truck, and then there were checks from Mario. We can see all that. But Mario's defense, if they were to, like, totally throw Shanna under the bus, maybe, of course, they're not allowed to do that. That would be interesting. And Shanna's defense, oh, they don't go after the widow. What are they doing? They're so busy going after the widow Kirsten Bridegan and her phone, right? Go fully after Mario.
And certainly the
And
evidence is that he paid for it. But in addition, Your Honor, this defendant had substantial contact with the tenant in the months and days leading up to this crime and after the crime. Those contacts were deleted by both parties on their phones. There was no requirement in the law that we use one co-defendant against another co-defendant as long as there's substantial competent evidence to show that the agreement happened. Your Honor knows the agreement happened, the solicitation happened, because the victim was killed by his tenant with no link to the victim. So remember, the solicitation in a lot of those cases about the communication has to deal with situations where the ultimate act did not occur.
Okay, so I'm going back to the elements. It's commanded, comma, encouraged, comma, hired, comma, or requested.
Right.
And then...
And the only reasonable, in the state's mind, in the light most favorable to us, which is what the standard is, the only way to view the evidence that we presented is this defendant hired Henry Tenon to do this.
Okay. Give me just a second. So that Williams case is a little dense. They go through a lot of legislative history, but really what it comes down to, where the first district found that the trial court erred, is that, like Mr. Mizrahi pointed out, there wasn't any, well, actually the flip co-defendant flipped back and said that there was basically this person, Denise, did not do anything. Additionally, there was talk prior to which they found the trial court did not err in basically letting the case go to the jury on the conspiracy, just the other two crimes.
Your Honor, I would just point out that the Williams case was specific to the principal theory.
Of first-degree murder?
Correct.
Correct.
And I didn't know if you were speaking to the...
So there were a lot of things at play. There was conspiracy. There was first-degree murder. The principal theory, it was related to that because they were saying assist, advise, encourage, and they were going through the legislative history of the words aid and abet, and they were going through, that's the part that's dense a little bit. But ultimately, if you get to the meat of the opinion where trial courts need to be aware is that, let me go back up. So in that case, which Mr. Mizrahi points out, it says while, and I'm reading, let me see what page is this, 787. It says, while Brian characterized the planning of the murder as very mutual, he also stated that he planned a lot of it and that he instigated a lot of it. And Brian never testified about anything Denise did or said to incite or encourage him to commit the murder. It's very different, I guess, factually, which is what Mr. Mizrahi was pointing out, that you had someone that was at one degree / level, and I think that's where the appellate court was drawing the line, saying that Denise Williams was culpable, her conduct was culpable based on words when it related to the conspiracy, but not because of this Brian witness. He delineated that he was the main factor, therefore making the evidence not competent or substantial enough to go to the jury. That is the way that I read that. So in this case, while I hear the defense say, and your theories are based on all of the cross-examination that you did, the state of Florida is allowed, if legally sufficient, to go to the jury based on the evidence. And I am familiar with the inference stacking, but there has to also be basically, the court has to be careful between that prohibition by law and what is legally permissible related to circumstantial evidence. And so I believe that the evidence that this court has seen through the testimony of the witnesses, viewed in the light most favorable to the non-moving party, which is the state, is sufficient to go forward. So I'll deny the motion for judgment of acquittal.
Okay. J.O.A. denied. Caroline said, I think what does not help is 3 trials and 3 defendants, and the attorneys and the judge know all kinds of stuff that overlaps, but the jury does not, and the info gets presented poorly. I mean, that, yeah, that's pretty much also what I'm worried about, meaning also Beth Ann said they sometimes mistake what they know for what is actually said and proven. There are points that need to be clearly laid out for a group of fact-finding peers. And with passion, you know what I mean? You can't go over the financial stuff, the biggest evidence you have against Mario in such a lackluster way. It can't be done in a sing-song, yeah, we're going through it, whatever, you saw this and that transaction, this and everywhere. You got to hold the jury's attention with that. It's very important. You got to point it out. Sorry, Mr. Prosecutor, Miss Rahi, Miss Rahi. I wish that Miss Stifler had done that direct examination. That's what I wish. I think she would have done well. Sorry about that.
To both counts. On both counts.
Understood.
So let's have a conversation about what's going to go on tomorrow. You're going to have your witnesses available and ready at 9 a.m., if any?
Yes, Your Honor.
Then what?
I would expect it to be an extremely light day. I think you've given me latitude that that happens. We can work on our closes and close Wednesday.
Oh, my.
Yes. So what I would like to do is, depending on the hour and time, we will finish the defense case. Is there anything left unmoved in, or everything's in from your perspective?
Everything's in from our perspective at this point.
Okay. We will do that. We will have the charge conference, as I've previously indicated. Melanie, I'm going to ask that you stay, okay? I'm going to talk to the lawyers off the record, but I'm going to ask that you stay through that conference off of the record so that we can put it on, so that starting hopefully Wednesday at 9 a.m., I would read a portion of the jury instructions up until the point, and this is where I stop. I don't know that you all have tried anything with me, Mr. Dreiser, Mr. Hill, Ms. Day. So what I do is I read up until submitting the case to jury. Oh, no, I'm sorry, rules of deliberation. So I stop there, and then I don't read rules for deliberation. I stop right before then. I let y'all argue. Then I pick up after that, submitting the case to jury, the verdict forms, and then they would retire after that for their deliberations. Does that sound okay?
Yes, ma'am.
And does the court envision not doing that Wednesday afternoon, or waiting until Thursday morning? I guess since we have a waiver, it doesn't matter.
Well, I would let them deliberate late. I mean, late, like 8, 9 o'clock, and then let them come back if they can't reach a verdict. So if we start at 9, these jury instructions aren't that long. So I would envision that they would possibly get the case early afternoon. So they would have 6, 7 hours to start deliberating.
And is there any chance of doing the closing tomorrow, even if it's a bifurcated proceeding? Okay.
I wouldn't do that. What I would do,
Why?
I would give y'all, so what we would do.
Why not? It sounds like we're going to have a light day, said the defense. When the defense says we're going to have a light day, that means, good morning, everyone. The defense rests. That's probably what's going to happen, right? You got any witnesses back there? You got Mario? Anyone? No? The defense rests? And then what? Then they're going to do the charging conference, send the jury home. What? Charging conference, and come back the next day for jury instructions, closing arguments, deliberation instructions, off they go. Okay.
The charge conference, we break so that you all have plenty of time. You're rested. The jury's rested, so that you all can work on your closings. You'll know what the law is. That would be my plan.
Yeah, just hashing it out really informally with the state. It's probably going to be like state's close in the morning, defense close in the afternoon, then deliberation, given the time that each party thinks they'll go.
I read about a minute or so a page, and so the opening instructions are about 20 pages, so that's like 20 minutes, give or take. And then, so you think your closing would be
Say she does
all morning?
Well, if she does, let's just say she goes a couple hours. then I would say, I would request that they get maybe an early lunch, and then I go. Maybe we just.
Lunch is like a clockwork, Mr. Dreiser, so it comes at like 11.
I would tell the court probably an hour 30 to hour 45, but build in a little extra time for that, just in case.
So for your first close?
Yes, ma'am.
And then if I'm long, so just.
Okay.
So I would still want to, that I would like to not be broken up.
Oh, boy.
Like I don't want to, and then take a lunch.
Would y'all rather them just come back the next day and deliberate?
I think it depends. Let's say we take a lunch.
I'm trying to give them a whole day. I could start the instructions at 8:30 if that would help.
Can we discuss amongst ourselves and come back to the court with some kind of better idea of scheduling? Now that I'm hearing this, I'll speak to Mr. Dreiser about how many witnesses tomorrow. It's conceivable, rather than breaking it up that way, I could get through first close tomorrow afternoon, depending, but I need some time.
I think that's a really strong possibility.
So.
What the hell?
Let me propose this.
Stop it. That'll be so weird. I've never seen that. So I'm definitely reading between the lines that the defense will have no witnesses. Are you reading the same? Yeah. Okay, so then they should just do closing arguments tomorrow. Exactly. Do closing arguments tomorrow. Let the state go, have a lunch, everybody early lunch. Then the defense goes for, I don't know how many hours long. The defense said, I'm long. How long? Yeah. Okay, girl said defense will be 4 hours minimum. But now they're proposing that the state does their first 2 hours of closing tomorrow? And then everybody goes home. They come back in the next morning, and then the defense goes for what? 3 hours? Then a lunch break, and then the state finishes off then deliberations. Okay. I've never seen that happen.
So for your discussions, you don't have to commit. Let's say the defense finishes relatively early. We have our charge conference. I don't think it's very complicated. It's very straightforward. There are a couple of things that I'd like to talk to you all about tonight that I think would help. Would you like for me to read the instructions, send them home, and then start your closings in the morning, first thing? And then would that help? So in the morning, if they start at 9, they essentially have 4 hours. And then, do you think you could get it done by then?
I think we would have the entire afternoon.
Right.
I like to get
entire afternoon.
silly to waste that time. From a age perspective, I think
Man.
the thing that makes the most sense.
Defense. Ma'am, set a time limit, please. 2 hours aside max. You can't just say defense. I don't know. I know it differs per state, but ma'am, judge. Defense wants to go all afternoon with closing arguments?
Is that we do the defense case, we have a charge conference, we have a large break for lunch. The Stifler does her closing. We come back fresh on Wednesday for Mr. Dreiser's closing on Monday. And then they get their case much earlier in the day.
When would I be reading, according to your plan?
Before Ms. Stifler does her closing.
So 20 minutes, you would, okay.
I think we would have the whole afternoon.
I think he may be right.
Right, that'll give us 4 hours, and that's plenty of time to get the instructions and first close done tomorrow afternoon.
And then it'll be the next day, defense close rebuttal case.
Mr. Dreiser gets a overnight to think about it, so. It does.
I'll take it.
Are you trying to give the defense an advantage, state? I don't like it. Do you like it? I'm like, so tomorrow, okay? They're going to come in. The defense will probably rest. Okay, cool, we got that. Then there's a charging conference, which is never my favorite part, but I will stream it anyway. Okay, because we're going to hear it anyway when they read it to the jury. But all right, they're going to iron all that out. Okay, lunch, right? So the jury, after the defense rests, the jury gets sent out. They do a charging conference for, I don't know how long that'll take. And then they break for lunch. Everybody breaks for lunch. Okay, cool. The charging conference is not with the jury. Yes. Then they come back, and then in the afternoon, the state does their closing argument, the first part, because they get a rebuttal. and then everybody goes home. Then the defense has time all night to think about it, to argue that, oh, that's fine. They don't have to think on their feet. They don't have to react. They just have all night to prepare their epic defense closing argument. All right, for the next morning. And then the state's rebuttal goes and the jury gets the instructions and they go to deliberate. They go deliberate on Wednesday or so. Wow. Okay.
You're also giving him extra time to figure out what to say. Yeah, longer and longer.
He doesn't need that.
I probably couldn't do it without that extra time. But thank you. I'll take it.
I'm joking. All right. Okay. First order. All right, we'll be done for the day then. And I want to see the lawyers at sidebar because I have a few questions that will help me. I'm going to push my draft of the jury instructions out to you all. Okay. No, I just have some questions before I. All right, court's adjourned. Thank you all very much.
Okay, I might have to just rethink my starting time for tomorrow because if it's going to be morning, defense rest. Okay, jurors, the defense is rested. Out you go, out you go. They didn't even ask Mario if he's testifying here in front of us, outside of the presence of the jury. Probably because they already know he isn't gonna. All right. There's probably been, I'm assuming it's on the record behind the scenes or something. Right, so tomorrow, if they come in and the defense rests and the jury gets sent out, then we're going to have to watch the charging conference for what, 2 hours? An hour and a half, 2 hours? I don't know how long it is. And then they go to lunch. So 9, rest. By 11 o'clock, I'm saying they might be done. But then they all go to lunch. So what time do they come back? There's going to be a huge gap. Okay, I might just start later so we can just skip over that massive lunch. Because closing arguments for the state would then only start after lunch, which technically would be 1 p.m. type of thing. Eastern. Huh? So, okay, I'll do my calculations from there. That was strange. I don't like it. Do you like it? Hate it. I just did. I don't know if this is a delayed message or what, but HB Labs and Rod said, can we recap? I just did. Right? I just recapped what they were doing tomorrow. The poll said, what would you convict Mario based on what the jury saw? 65% say yes and 35% say no. I mean, there's a lot of coincidence, a lot to for the jury to go like, that's a coincidence and that's a coincidence and that's another one, right? I get that, but we'll have to see what the jury decides, and it also depends on the closing arguments, and now the defense will have a whole night to think about how they're going to respond to the state's closing arguments. Okay, so that's all very strange. Moving on. Let me know in the comments as well what you think about this plan. And that means on Tuesday, August 25th, we'll see the state's closing argument. And then on Wednesday, the 26th, then we'll see the defenses and then the state's rebuttal. Maybe they go deliberate after that, or Thursday. I think we'll have a verdict by Thursday. Maybe, unless it's a mistrial, but we shall see. Thank you so much, everyone, for joining me for this interesting day. State rested. I think the defense will rest in the morning. Let's see how it goes. And I'll see you for that. Please leave comments below, especially if you're watching the replay. Maybe you weren't in the live chat. Even if you're in the live chat, let me know in the comments below, okay, the evidence you think that will convict Mario Fernandez Saldana. Or why you think it's not enough. I'd love to hear your thoughts. All right, everyone. See you tomorrow. Bye.